Fresh matter for admission. Since the suit was dismissed, madam. Suit was dismissed by trial court. Appellate court also the same.
Dismissed. Urgency and ನಾಳೆಗೆ ಎಂದೆ.
Next week, madam.
Next week.
Next week.
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇವತ್ತು ಯಾವ್ದು ತಗೊಳ್ಳೋದಿಲ್ಲ. ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಬೇರೆ ಇದೆ ಮಧ್ಯಾಹ್ನ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ನಾರು ಯಾರು ವೇಟ್ ಮಾಡೋದು ಬೇಡ. ನೋ ನೀಡ್ ಟು ವೇಟ್. ಯಾವ್ದಾರು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇದ್ರೆ ಕೋರ್ಟ್ ಆಫೀಸರಿಗೆ ಕೊಟ್ಬಿಡಿ, ಬರ್ತ್ ಕೊಟ್ಬಿಡಿ. ಹ್ಮ್ 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 ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ. ಟುಮಾರೋ ಇಲ್ಲ, ನಾಳೆ ಯಾವ್ದು ಮಾಡೋದಿಲ್ಲ. ಇವತ್ತಿದ್ರೆ ಕೇಳೋಣ ಏನಕ್ಕಿದೆ ಹೇಳಿ. ಪಾರ್ಟೆಡ್ ಯಾವ್ದು ಇಲ್ಲ ರಿಲೀಸ್ ಮಾಡೋಣ. ಯಾರ್ಯಾರಿಗೆ 2 ತಿಂಗಳು ಕಾಯಕ್ ಟೈಮ್ ಇಲ್ಲ, ರಿಲೀಸ್ ಮಾಡೋಣ. ನೋಡಿ ಹೇಳಿ ಮಾಡಿ ಕರ್ಸ್ತೀವಿ, ಪೇಜ್ ವೈಸ್ ಕರ್ಸ್ತೀವಿ.
Serial number 74, madam. I pay for the appellant.
Appellant counsel 6 time. Counsel for the respondent also. President says no objection. List the matter after 2 weeks.
83 madam. 82 my lord.
82 ಹೇಳಿ.
ಸ್ವಲ್ಪ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡ್ಬೇಕು.
ಅದರ್ ಸೈಡ್ ಗೆ ಹೇಳಿದಿರಾ ಇದಾರ ಮಾಡಿದಿರಿ. Appellant counsel 6 time and also submit that already intimated counsel both R1 and R2. R1 and R2 and list after 2 weeks.
83 madam.
83 ಹೇಳಿ.
Pay for 2 weeks time.
Appellant counsel 6 time, list after 2 weeks. 86 ಬಂದಿಲ್ಲ ತಡೀರಿ. 86 ಹೇಳಿ.
Appearing for the appellant, you will pray for 2 weeks time, Swami.
Appellant counsel 6 time and also counsel for respondent says no objection. List after 2 weeks.
Kindly extend the interim order, your lordship.
Interim order ಇದೆಯಾ?
Yes, your lordship.
Interim order is extended till the state of hearing.
Much obliged.
90 my lord. 90 my lord, your
Yes,
lordship.
90 ಹೇಳಿ.
90 my lord, your lordship may grant me 2 weeks time.
Appellant counsel 6 time, list after 2 weeks. ಇವತ್ತು ಯಾಕೆ ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಯಾವ್ದು ಮೋಸ್ಟ್ಲಿ ಯಾವ ಒಂದು ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಇದೆ ಹಿಯರ್ ಮಾಡೋದು ಬೆಂಚು, ಅದಕ್ಕೋಸ್ಕರ ಕೊಡ್ತಾ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 94 ಹೇಳಿ. 94 ಫಸ್ಟ್ ಟೈಮ್. Appellant counsel 6 time, list after 2 weeks. 92 Appellant counsel ಯಾರು ಅದರ್ ಸೈಡ್ ಇದಾರಾ, ಯಾರು ಮಾಡಿದಿರಾ? Appellant counsel 6 time and also submits that already intimated other side counsel and hence list after 2 weeks. 104 ಹೇಳಿ. 104 ಏನು? Appellant counsel ಇದ್ರಲ್ಲೇನೋ ಲಿಮಿಟೇಷನ್ ಇದೆ ಅಲ್ರಿ, ಡಿಲೇ 1102 days. Appellant counsel 6 time, list after 2 weeks.
101 my lord.
101 ಹೇಳಿ.
Paper appellant my lord. Respondent move ಮಾಡಿದ್ರೆ
ಹೇಳಿದಿರಾ?
ಹೇಳ್ತೀನಿ, ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ.
ಮಾಡಿದಿರಾ?
ಮಾಡಿ
ಮಾಡ್ಬಿಟ್ಟು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಕೊಡ್ತೀನಿ.
ಆಯ್ತು.
ಬಿಫೋರ್ 130 ಮಾಡಿ ಹೇಳಿ.
ಆಯ್ತು.
ನೆಕ್ಸ್ಟ್
106 for respondent number 3.
106 ಅದರ್ ಸೈಡ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿದಿರಾ? ನೀವ್ ಯಾರಿಗೆ? R3 counsel 6 time and also submits that already last time ನೀವೇ ಟೈಮ್ ತಗೊಂಡಿದ್ರಿ. Appellant counsel already intimated appellant counsel, hence list after 2 weeks. 119 ಫಯಾಜ್ ಸಾಬ್ ಅವ್ರು ಹೇಳಿದಿರಾ? ನೀವೇನಾ? ಆಯ್ತು. ರವಿಕುಮಾರ್ MC ಹೇಳಿದಿರಾ? ಕೌನ್ಸಲ್ ಬೇರೆಯವ್ರದ್ದು ಹೇಳಿದಿರಾ ಅಂದೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿದಿರಾ ಅಂದೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 time and also submits that he has already intimated appellant counsel, list after 3 weeks. 123 ಹೇಳಿ. ಏನು ಫೈನಲ್ ಹಿಯರಿಂಗ್? Appellant counsel 6 time ದೇವೇಂದ್ರಪ್ಪ ಏನೋ ಇದ್ರಲ್ಲ ಅವಾಗ
I appear for the
Ah.
appellant, my lordships.
List
Serial
after
number
three, list after 3 weeks.
In serial number 111, my lordships, I appear for the appellants. I pray for a week's time, my lordships.
111, appellant counsel 6 time, list after 2 weeks.
Memo, my lordship, tomorrow, my lordship,
My lord,
specific performance. Memo.
ಆಗೋಯ್ತು ಟೈಮ್ ಅರ್ಜೆನ್ಸಿ ಏನ್ ಮೇಡಮ್ ನಾಳೆಗೆ
Nare-
ಕೊಡಿ ಮೆಮೋ ಯೂಶುವಲ್ ಕೋರ್ಸ್ ಅಲ್ಲಿ ಬರ್ದು ಕೊಡಿ
Objection
ಮೆಮೋ
ಇದೆ,
ಕೊಡಿ
two
ಅವ್ರಿಗೆ
weeks
ಕಲೆಕ್ಟ್
time.
ಮಾಡ್ಕೊಡ್ರಿ.
Delivery warrant has been issued.
ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿರೋದು?
Last week, madam.
ಯಾವ ಇಯರ್ದು
2020,
ಅಪೀಲ್ ಯಾವ ಇಯರ್ದ್ರಿ?
2024, my lord.
24
my lord.
ಇಲ್ಲಿ ಹಾಕಿರೋದು ನೀವು 24
My lord.
ವಾಟ್ ಈಸ್ ಕೊಡಿ ನಾಳೆ ಹಾಕ್ಸಿ ಮೇಡಮ್ ನೋಡಿ ಅದೇನು.
Serial 50. Address करला जा देश का complaints of the office of the Ram.
ಎಲ್ಲಾನು ಅಷ್ಟೇ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಬಂದಾಗ ಮೆನ್ಷನ್ ಮಾಡಿ
Last
ಆಯ್ತಾ? ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಬಂದಾಗ ಮೆನ್ಷನ್ ಮಾಡಿ ಕೊಡ್ತೀನಿ ಏನದ್ ನೋಡೋಣ. ರಾಜಾ ಎಲ್
appear for the
ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಫ್ ಮೆಮೋ ನ್ಯೂಸ್ ಪೇಪರ್ ಫೈಲ್ಡ್ ಬೈ ಹಾಕಿದಾರ ಮೇಡಮ್? ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಆಗಿದೆ ತಗೊಳ್ಳಿ. ದ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪ್ಲೆಂಟ್ ಹಸ್ ಫೈಲ್ಡ್ ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ಪೇಪರ್ ಇನ್ ವಿಚ್ ಎ ಪಬ್ಲಿಕೇಶನ್ ಇಸ್ ಮೇಡ್ in respect of notice to R2 and H. Shivram. Date ಎಲ್ಲ ನೋಡಿದಿರಾ ಮೇಡಮ್ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ? And verification date is also correctly mentioned and hence and also H. Shivram is called out before the court and not appeared and hence held sufficient against R2. ನೆಕ್ಸ್ಟ್ ಏನಾಗ್ಬೇಕು? ಪೋಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಡ್ಮಿಷನ್
finally admit ಆಗಿದೆ.
ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
Paper book.
ಆಯ್ತು ಪೋಸ್ಟ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್.
Appearing for appellant, my lordship.
Bringing LRs of deceased appellant,
File.
deceased appellant,
ಹೌದು.
compliance ಇದೆ? ಓನ್ಲಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತನಾ? ಹಾಕಿಲ್ಲ ಅಂತಲ್ಲ. 2 weeks time granted to comply with. 2 weeks ಬೇಕಾ 1 ವಾರ ಸಾಕ? ಫುಲ್ ಕಾಸ್ಟ್ ರೇಟ್ ಹಾಕ್ಬೇಕು.
1 ವಾರ sir.
1 week time granted to comply with office objections.
Please.
Appellant to bring LRs of deceased R1, non-taking of steps. 2 weeks finally, another 2 weeks finally granted to bring the LRs of R1. Non-taking of steps, council appellant brings the LRs of deceased R2.
2 weeks time.
Another 2 weeks time granted as sought. Non-taking of steps by the appellant to bring the LRs of R1 and
My
R.
lord, we have filed an IA for bringing the LRs on record.
When you filed, madam?
Yesterday, my lord.
Yesterday.
Yes.
Council submits that yesterday filed application and hence put up the same. Non-taking of council to bring the LRs of deceased respondent.
My lord, so today morning I filed my
Council
lordship.
submits that application is filed in the office today and hence put up the same.
Therefore,
One of 23, 2 of 20, recalling the order. Office objection ಇದೆ.
ಮಾಡ್ತೀನಿ sir. Two weeks,
ಎಷ್ಟು
sir.
ದಿವಸ ಬೇಕು?
ಮಾಡ್ತೀನಿ 2 weeks ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ.
2 weeks. ಕಾಪಿ ಸರ್ವ್ ಮಾಡೋದ್ ಮಾತ್ರನಾ? ಆಯ್ತು 2 weeks time granted to comply with office objections. Postal Sara shown as expired ಅಂತ ನೋಡ್ರಿ ಯಾರು?
R9 ಆಗಿದೆ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀನಿ 1 week.
2 weeks time granted to bring file necessary application to bring the LRs of R9.
And others
Complaints of office objections ಬೇರೆದ್ರಲ್ಲಿ ಇದೆ ನೋಡಿ. R3 ಗೆ R3
ಅದೇ
objections ಇದೆ. 2 weeks time granted to comply on office objection number objections on IA 1 of 24 to 3 of 24. Memo for treating R3 to R5 as LRs of R6. Memo ಯಾರು ಫೈಲ್ ಮಾಡ್ರ ನೀವ ಅವ್ರ ಯಾರು ಅಪಲೆಂಟ ಅವ್ರ ಇಲ್ವಾ ಈಗ? ನಿಮ್ದೇನಾದ್ರು ತಕರಾರು ಇದೆಯಾ ಅದಕ್ಕೆ? ಕರೆಕ್ಟ್ ಅವರು heard on memo and prayer is made to treat the R3 to R5, R7 to 8 as LRs of R6 and counsel for the respondent also not disputes the memo and hence memo is allowed. Appellant counsel accepted and accepted. Appellant counsel is directed to amend the cast title in terms of the memo and file amended appeal memo within 2 weeks. Ivrga issue notice on 1 of 23, 2 of 23, 3 of 23 against the LRs of R2. And appellant counsel is directed to pay the process forthwith.
Needful done, your lordship.
Compliance. ಏನ ಇದೆಯಲ್ರಿ?
Needful done, your lordship, in
ಯಾವಾಗ?
10 morning.
ಇವತ್ ಮಾರ್ನಿಂಗ್.
Yes, your lordship.
ಇವತ್ ಮಾರ್ನಿಂಗ್ ಎಲ್ಲಿ ಮಾಡಿದ್ರಿ?
The PF defective, sir, for DCFO.
Council submits that needful is done and hence issue notice to R1, R2, R7 and R20. ನೀಡ್ಫುಲ್ ಡನ್ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರಲ್ಲ PF ಅಂತ. Deceased R1.
This is.
Hmm.
This is the
PF
hormone death
ಯಾರಿಗೆ?
ಆಗಿದೆ. ಅದಕ್ಕೆ filing memo for this is respond 2 and 3 are the legal aids of the respond 1 your lordship.
1 ಗೆ ಯಾರು LRs?
2 and 3 your lordship.
Appellant counsel files memo stating that R2 and R3, R2 ನು ಸತ್ತೋಗೋನಲ್ರಿ. R1, R2, R7, R20 ಇಷ್ಟು ಜನ ಸತ್ತೋಗೋರೆ.
I'll verify and
ಇದ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಮೇಡಮ್ ಕ್ಲಿಯರ್ ಮಾಡ್ಕೊಳ್ಳಿ. The counsel submits that he has paid the PF. ಈ PF paid issue notice to ಯಾರಿಗೆ ಅದು PF ಕೊಟ್ಟಿರೋದು ನೀವು?
PF your lordship. Respondent number R 5, 8, 9, 10 and 18.
5, 8
5, 8, 9, 10 and 18.
and 18.
Yes, your lordship.
2 weeks time granted to file necessary application to bring the LRs of R1, R2, R7 and R20 finally. ಹಿಂದೆನೂ ಕೊಟ್ಟಿದೆ ಟೈಮ್ ನೋಡಿ.
Yes, sir.
Non arraying of depend number 1A to C. trial court in appellate court.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ
ಹಾ?
ಡಿಸ್ಮಿಸ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್ ಆಗಿತ್ತು. ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಕ್ಸ್ ಪಾರ್ಟಿ ಆಗಿದ್ರಿಂದ ಇಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿರ್ಲಿಲ್ಲ ನಾವು. ಆ ಪಾರ್ಟಿ ಮಾಡಿ ಅಂತ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದಾಗ ಪಾರ್ಟಿ ಮಾಡಿ ನಂಬರ್ ವೆರಿಫಿಕೇಶನ್ ಆಗಿತ್ತು. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4 and 5.
ಈಗೇನ್ ಮಾಡಿದೀರಾ?
ಹಾ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ.
ಹ್ಮ್. ಹ್ಮ್.
Trial court now made party in RSA, but in RA due to ex parte they are not made party.
Counsel submission is accepted with regard to making of different number 1A to C in RSA. In RSA. ಆಯ್ತು. Recalling ಏನ್ ಕೊಡ್ ಇದೆ ಈಗ.
ಹಾ
ಮತ್ತೆ ಇಲ್ಲಿ-
ಡಿಫಾಲ್ಟ್ ರೆಸ್ಟೋರೇಷನ್ ಹಾಕಿದ್ವಿ.
ಆಯ್ತು. This court earlier for pending consideration directed to comply with office objection and accordingly office objection is complied. ಎಲ್ಲಿದೆ ಮೇಡಮ್ ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್? Void order dated 21/2/24 and hence and in of compliance of the same IA is allowed and order dated so and so is recalled on 21 dated 21/6/23. Post the matter for admission. Notice to
Respondent 1 and 2 are taken steps. Needful.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಈಗ ಇಬ್ರು R2 ಸತ್ತೋಗೋರು.
R2 ಗೆ I will take steps against the R2.
ಮತ್ತೆ ಇನ್ಯಾರಿಗೆ ಮತ್ತೆ R1 ಗೆ?
R1 and 9 ಗೆ
1 and 9 ಗೆ.
1 and
Counsel
9.
submits that he has paid the PF and hence issue notice to R1 and R9. 2 weeks time granted to
R2.
file necessary application to bring the LRs of R2 within 2 weeks.
Yes.
Finally ಅಂತ ಹಾಕೋಬಿಡಿ. Finally 2 weeks. Awaiting service of notice to R1, R2, R3 ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿರೋದು ಮೇಡಮ್?
I pay for the appellant in 13.1 your lordships. ಅದರಲ್ಲಿ needful done 13.1 ನಲ್ಲಿ.
ಅದೇ await ಅಂತ ಹಾಕ್ಬಿಡಿ. Await
13.1
await notice of R1, R2, R3, A and B, R4, R5, R8 to 11. List is matter on toilet.
13.1 ನಲ್ಲಿ needful done interim order extension ಆಗ್ಬೇಕು ಸ್ವಾಮಿ.
ಏನ?
ಆ ಮ್ಯಾಟ್ರಲ್
ಯಾವ್ದ್ರಲ್ಲಿ? Connected ಅಲ್ಲ.
ಕನೆಕ್ಟೆಡ್ 13.1.
Serial number 30.
13 ಅಲ್ಲೇ ರವಿ ಪ್ರಕಾಶ್ ಯಾರ್ರಿ?
I appear for the
ನೀವಾ?
appellant in this matter, my lord, sir.
ನಿಮ್ದಾಯ್ತು. ಈಗ ಯಾರು ಇದ್ರಲ್ಲಿ SR ದೇಶಪಾಂಡೆ ಇದ್ರಲ್ಲಿ
13.1.
ಹೊಸ ಅಡ್ರೆಸ್ ಗೆ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದೆ ಸರ್.
R6 ಗೆ ತಗೋಬೇಕಲ್ಲ.
ತಗೊಂಡಿದೆ ಸ್ವಾಮಿ. ನೀಡ್ಫುಲ್
ಯಾವಾಗ?
ಇವತ್ತು
Counsel submits that he has paid the PF
ಹೊಸ address
with
ಇದೆ.
correct address.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್
Hence,
ಮೆಕ್ಯಾನ್ಲಿ ಬಿ ಎಕ್ಸ್ಟೆಂಡ್.
Against R6.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್.
ಹಾ?
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್
4
ಎಕ್ಸ್ಟೆನ್ಷನ್.
big ಏನು
Interim
deliver
order, sir.
ಕುಮಾರ್.
ಅವ್ರ ರಿಲೇಷನ್ ಅವ್ರ ಕಸಿನ್ ಅಂತೆ ಸ್ವಾಮಿ.
ಕಸಿನ್ ಆದ್ರೆ ಬರಲ್ಲ. ಅಡಲ್ಟ್ ಮೆಂಬರ್ ಆಫ್ ದಿ ಫ್ಯಾಮಿಲಿ ಆಗಿದ್ರು ಮಾತ್ರ.
ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟೆ.
ನೋಡಿ. ಇಲ್ಲ
ಈ-
ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು ನೀವು.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್.
ಆಯ್ತು. Appellant counsel is directed to verify whether the notice is taken by the adult member of the family. ಇನ್ನೇನಾಗಬೇಕು?
ಅಲ್ಲ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್.
Interim order extension.
Granted earlier is extended till next state of hearing.
My
ಇದ್ರೆ
lord, sir.
interim
ಅದ್ರಲ್ಲಿ
order
ಇನ್ನೊಂದು earlier, my lord, sir.
connected ಅಲ್ಲಿ ಇದೆ. ಅದು
My
extended.
lord, sir, in
Yes.
earlier matter, in
Ah.
serial number 13 ಅಲ್ಲಿ, the IA copies has been served upon them, my lord, sir.
Yes, sir.
Acknowledgement
IA served.
served, it has
ಅದ್ರಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. First matter ಅಲ್ಲಿ connected ಅಲ್ಲಿ IA copy is served on the other side and the same is acknowledged by the counsel for respondent.
please.
Acceptance of acknowledgement for having received notice by other person in respect of R6. ಯಾರು ವೆರಿಫೈ ಮಾಡಿದಿರಾ? ಯಾರು ಅದರ್ ಪರ್ಸನ್ ವೆರಿಫೈ ಮಾಡಿ. ಕೌನ್ಸಿಲ್ ಲಾಸ್ಟ್ ಟೈಮ್
I filed LR application for bringing LRs of R8.
R8 ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಅವ್ರಿಗೆ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಆನ್ IA 1/22 as against the LRs of R8. ಆಮೇಲೆ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಏನಿಲ್ಲ. Appellant counsel is directed to verify whether a notice is served on the adult member of the family.
Obliged.
And submit regarding the same in the next date of hearing. Next,
15.
steps to be taken in respect of deceased R1. Ilva, appellant counsel is absent.
No, appellate. I mean,
ಹೇಳ್ರಿ,
I'll take steps, I mean,
ಯಾವಾಗ?
2 weeks permitted.
Counsel again 6 time, and hence 2 weeks time granted to bring the LRs of R1. Memo reporting death of appellant along with death certificate. Bring LRs of appellant on record as appellant number 1. A to C. Heard on memo is taken on record and heard on IA 1 of 23 and for the reasons stated in the accompanying application and affidavit. Other side copy serve ಮಾಡಿದ್ರಾ?
ಮಾಡಿದ್ವಿ.
IA is allowed and permitted to bring the LRs of appellant on record as appellant number A to C. Appellant counsel is directed to amend the cast title and file amended cast title within 2 weeks. GB Sastri,
Lord will pay the.
furnishing of correct address. ಹೇಳಿ madam.
Will pay the fresh PF for second time.
ಏನು? Time
respect-
ಬೇಕಾ ಏನು?
1 week time.
Counsel 6 1 week time to pay PF and to furnish correct address. And if furnished, issue notice to R1, R15, R17, R18. There is a lot of unsought Shara, noted, Satogon noted,
Yes, my lord.
Murjana,
2 weeks time. to-
Nakchana. 2 weeks time granted to bring the LRs of R16, R21 to 24.
Great.
Notice to R6 for third time.
2 weeks time.
Huh?
2 weeks time.
Counsel 6 2 weeks time to pay PF and furnish correct address. If furnished, issue notice to R6.
Then,
Shara in R, they are Satog or noted. 2 weeks,
ಹೌದು,
2 weeks
R3
time
to
granted to
7,
bring the
my-
LRs of R3 and R7.
Yes, ma'am.
Vijay Kumar K.
For 1 week time.
Huh?
1 week time.
Counsel 6 1 week time and hence, and if PF paid within 1 week, issue notice to R1 to R3. Sufficiency of refused, R4 refused and hence sufficient. Filing of the appeal and bringing LRs of respondents ಅಂತಿದೆ. ಯಾರು ಸತ್ತೋಗಿರೋದು?
Appellant number 1.
1. Appellant number 1. ಇಲ್ಲಿ respondents ಅಂತ ಹಾಕಿದಿರ ಅಯ್ಯೇ?
Respondents ಅಂತ ಅದಾಗಿದೆ.
ಹಾ?
They are already on record.
Filing the LR application.
ಎಲ್ಲಾರ application ಹಾಕಿದೀನಿ.
ಯಾರು?
R1.
ಹಾ?
R1 ತೀರೋಗಿದ್ದಾರೆ.
R1 ತೀರೋಗಿದ್ರೆ ಅವ್ರು ಎಲ್ಲಾರು ತಂದಿದ್ದೀರಾ? ಈಗ ಅಯ್ಯೇ ಅಲೋ ಆಗ್ಬೇಕಾ?
IML ಹೋಗಿದೆ ಸರ್. ನೋಟಿಸ್.
ನೋಟಿಸ್ ಹೋಗಿದೆಯಾ?
ನೋಟಿಸ್ ಹೋಗಿದೆ.
ಹೋಗಿಲ್ಲಲ್ಲ, ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
ಹೋಗ್ಬೇಕು.
Issue notice on, correct madam? IA 4 of 23.
2 to 4 ಆಲ್ರೆಡಿ ಇಶ್ಯೂ ಆಗಿದೆ.
3 of 23
Please.
ನೋಡಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅಂತಿದೆ ಮೇಡಮ್ ನೋಡಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅಪಲೆಂಟ್ಸ್. ಮತ್ತೆ ಇಲ್ಲೇನ್ ಏನಾಯ್ತು? ಸರ್ವ್ ಆಯ್ತಾ ಏನಾಯ್ತು? ಏನು ತೋರ್ಸಿಲ್ವಲ್ಲ ಸರ್ವಿಸ್ ಆದಾಗೆ? ಯಾವಾಗ ಹೋಗಿದೆ ನೋಟಿಸ್? ಆಲ್ರೆಡಿ ಆನ್ ರೆಕಾರ್ಡ್.
ಸಿದ್ಲಿಂಗ ತೀರೋಗಿದ್ದಾರೆ. They LRs are already on record. Since the office has raised objection to
ಈಗ
file
notice-
LR application, ನಾನು LR application ಹಾಕಿದ್ದೆ. ಅದ್ರ ಮೇಲೆ ನೋಟಿಸ್ ಹೋಗಿದೆ.
ಫಾರ್ಮಲ್ ಆಗಿ ಹಾಕಿದೀರಾ?
ಹೌದು ಹೌದು ಹೌದು.
ಅದ್ರ ಮೇಲೆ ಈಗ ನೋಟಿಸ್
ನೋಟಿಸ್ ಹೋಗಿದೆ ಸರ್.
ಏನಾಗಿದೆ ಮೇಡಮ್? ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ ಹೇಳಿ?
ಒಬ್ಬರಿಗೆ ಸರ್ವಿಸ್ ಆಗಿದೆ, ಇನ್ನು 3 ಜನಕ್ಕೆ ಆಗಿದೆ.
PF ಎಲ್ಲ ಕೇಳ್ತಾ ಇರೋದು ಅದಕ್ಕೇನ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲ, ಒಬ್ಬರಿಗೆ
ಕನ್ಸಿಡರ್
ಸರ್ವಿಸ್
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಹಾಗಾದ್ರೆ. ಆಯ್ತು. ನೆಕ್ಸ್ಟ್. Perusal of unserved cover returned with postal Shara.
I have to take steps in respect of.
2 weeks time granted
2
to
weeks time.
bring the LRs of R7.
Obliged.
Non-filing of paper book. Balakrishna Sastri.
My lord, previously, in 19 to
ಸರಿ ಬಂದಿದೆ ಹೇಳಿ. ಹಿಂದೆ ಏನೋ ಮತ್ತೆ ಬಂದಿದೆಯಾ ಪೇಪರ್?
ಒಂದ್ಸಲ ಬಂದಿದೆ madam.
ಯಾವಾಗ?
2019 ಅಲ್ಲಿ.
2018 ಅಲ್ಲಿ 8 weeks. ಆಮೇಲೆ 19 ಅಲ್ಲಿ
8 weeks ಕೊಟ್ಟಿದ್ರು madam.
ಆಮೇಲೆ ಬಂದಿಲ್ವಾ? ಫೈನಲಿ 4 weeks time granted to file paper book.
weeks time may be given.
Weeks time is granted as sought. If we have paid, issue notice to R2 and R3.
In this case,
ಹಾ.
this 22
R4 and R6 ಗೆ ಹೇಳಿ.
ಅವ್ರಿಗೆ ಮತ್ತೆ ನಾನು ಇನ್ನೊಂದ್ಸರಿ just
Same.
weeks time, but
If
3
we have
and 5 ಗೆ
paid, if we have and correct address furnished,
respond number
notice
3
to-
and 5 ಗೆ
R4 and 6.
R3
3 and 5 ಗೆ? ಅದ್ ಯಾರು ವೆರಿಫೈ ಮಾಡಿದ್ರೆ ಯಾರು ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ?
ಅದು ನನಗೆ
Appellant counsel is directed to verify whether an adult member of the family has taken notice
Yes, ma'am.
against R3, R5
yes ma'am.
and submit regarding the same in the
Yes,
next state of hearing.
Yes ma'am.
Perusal of unserved cover returned with one the R5 dead. 2 weeks time granted
weeks.
to bring the LRs of R5. Acceptance.
In this
Ah,
matter,
ಹೇಳಿ.
ಇದರಲ್ಲಿ what has happened is
ಹಾ.
the so far as respond number 3 is concerned,
ಯಾರು ತಗೊಂಡವ್ರೆ?
ಯಾರು ತಗೊಂಡಿದ್ದಾರೆ ನೋಡ್ಬೇಕಾದ್ರೆ
ಗೊತ್ತಿಲ್ಲ. Acceptance ಅಂತ ಇದೆಯಲ್ಲ.
acceptance.
Applicant counsel is directed to verify whether adult member of the family is taken the notice against R3. ಮುದ್ದುರಂಗಪ್ಪ ಅಂತ.
ಮುದ್ದುರಂಗಪ್ಪ ಅಂತ
ನೋಡಿ ಅದು ವೆರಿಫೈ ಮಾಡಿ ನೆಕ್ಸ್ಟ್
Verify
ಟೈಮ್
ಮಾಡಿ.
ಸಬ್ಮಿಟ್ ಇನ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್.
yes,
Notice to R1 and R1 for third time.
Parties are ready to report their settlement 26 ಅಲ್ಲಿ.
ಪಾಸ್ ಓವರ್ ಮಾಡ್ಬೇಕಾ?
ಹೌದು.
ಪಾಸ್ ಓವರ್. ಹಾ.
OS judgment ಅಲ್ಲಿ
Presiding officer signature not
It's a-
forthcoming.
that's a
Counsel
certified copy
submission
I
is-
have filed, my lord.
Council submission is accepted. Only page number 25 illa ಅಷ್ಟೇ.
ಹೌದು.
Accepted. Post the
Please.
matter for admission. Fourth time. MH Saukar.
I appear for the appellant, my lord. Your
Yes,
lordship may
counsel.
kindly grant 2 weeks time, my lord, I will. Finally.
Council seeks further time and hence on cost of rupees 500. 2 weeks time granted. If office objection not complied within 2 weeks, appeal is dismissed without reference to the bench. ಒಂದೇ ಇರೋದ?
Please.
Dispensation ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಅದು dispensation of production of voice judgment.
ಹಾ.
Voice judgment decree.
ಮತ್ತೇನಕ್ಕೆ dispensation application ಹಾಕಿದ್ರಿ? Already you have produced certified copy of judgment and decree of the trial court. Why you
ಕೆಲವು
filed an
ಕಂಪ್ಲೈ
IA?
ಮಾಡಿದೆ ಸ್ವಾಮಿ, ಇನ್ನೊಂದಿಷ್ಟು ಇದೆ.
ಹಾ?
Some of them
Office
we have
objection
complied.
ಒಂದೇ ರೀ. ಸುಮ್ಮನೆ ಯಾಕೆ ಕಾಸ್ಟ್ ಹಾಕ್ಸ್ಕೊಳ್ತೀರಿ ಮತ್ತೆ?
ಇಲ್ಲ ಕೊಡ್ತೀನಿ.
ಹಾ? Already produce ಮಾಡಿದಾರಂತ?
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ ಅದು.
Voice judgment or filed ಅಂತ ಇದೆ.
ತೊಗೊಳ್ಳಿ. IFR dispensation of the certified copy of OS not survives for consideration since already furnished the certified copy of judgment and decree. Post the matter for admission ಅಷ್ಟೇ, non compliance ಏನಿಲ್ಲ.
Please.
Dismissal of appeal in view of non compliance of office position. ಆಯ್ತೇನ್ರಿ, ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರಾ?
No, my lord, because my parties are not cooperating, my lord.
ಏನ್ ಮಾಡ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಾ? ಕೊಡಿ.
There is no instructions, please.
ತೊಗೊಳ್ಳಿ. Appellant counsel submits that no instructions to
File
pay the
affidavit.
cost and also to comply with office objections and party appellant is not cooperating him and in view of the submission appeal is dismissed. For non-compliance and non-payment
Cost
of
is-
cost.
Cost is paid, man.
Next Anandeshwara ಹೇಳಿ.
Cost is paid, man.
ಕಾಸ್ಟ್ ಆಯ್ತು, compliance ಹೇಳಿ.
Compliance 1 week because they have
Counsel
already
again.
sent a judgment decree
Cost
copy.
cost receipt ಅಲ್ಲಿ
ಇಲ್ಲಿದೆ.
ಕೊಡಿ. ಮತ್ತೆ ಹಂಗ ಇಟ್ಕೊ ಬಂದ್ರ ಆಗಲ್ಲ.
I will file it in the count.
That he has paid the cost today na?
Please.
Today in the office and again seeks 1 week time to comply with office objection and further cost of rupees 500. Another 2 weeks time is granted. If further cost not paid, not complied, appeal is dismissed without reference to the bench. R Kiran,
Place 1 week time.
second time.
In the
Counsel-
connected matter, my lord. I am
Counsel
for the
seeks, counsel seeks 1 week time to pay PF. If PF paid, issue notice to R1 to 6. ಹೇಳ್ರಿ.
In my case, R11 to R7, A to F, my lord.
ಏನು?
ಅದು ಅವ್ರಿಗೂ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು, ಸೇಮ್ ಪಾರ್ಟಿ.
ಕೊಡ್ಬೇಕು, PF ಕೊಡ್ಬೇಕು.
ಕೊಡ್ತೀನಿ,
ಯಾವಾಗ?
1 week.
Council seeks 1 week time to pay PF. If PF paid, issue notice to R11 and R7, A to F. ಅಷ್ಟೇನಾ?
Please, ಅಷ್ಟೇ.
32. R6 and R7 for second time. Appellant counsel is absent, 1 week time granted to pay PF. If PF paid, issue notice to R6 and R7. Acceptance ಏನಿದೆ ನೋಡಿ ಮೇಡಮ್. Appellant counsel is also directed to verify whether notice has been served on R4 and R5 against an adult member of the family. The appellant counsel is directed to bring the LRs of R1 and R3 within 2 weeks. Non-compliance of office objection third time. Appellant counsel absent, finally 2 weeks time granted to comply with office objections.
Appellant, cost paid.
Cost compliance. Compliance ಹೇಳ್ರಿ.
1 week.
Counsel again seeks 1 week time and submits that he has paid the cost. ಎಲ್ಲಿದೆ cost receipt?
Today would be paid. I have to.
ಕೊಡಿ ಅದು ಎಲ್ಲಿದೆ?
I have to place the.
ಇನ್ನು ಪೇಮೆಂಟ್ ಮಾಡಿಲ್ಲ.
Payment ಆಗಿದೆ.
ಇದೇನದು receipt?
ಹೌದು sir.
ಆಯ್ತು. Official ಹಾಕಿ. Counsel submits that he has paid the PF to cost today and again seeks time and on further cost of rupees 500. Another 2 weeks time granted. If not paid, further cost not paid and not complied, appeal is dismissed without reference to the bench. ಇಲ್ವಾ? Memo filed by council appellant along with death certificate, flag that ಯಾರು ಸತ್ತಿರೋದು ಯಾರು? ಬಟ್ ಏನೋ ಕಾಸ್ಟ್ ಕಟ್ಟಿಲ್ಲ, ಏನೋ ಕಂಪ್ಲೇಂಟ್ಸ್ ಏನೋ ಇದೆ. Appellant counsel is absent and cast R1 ಸತ್ತೋಗಿರೋದು. The appellant counsel filed memo reporting death of R1 and the same is taken on record. The appellant counsel has not paid the cost as ordered on 27/9/23. Appellant is the legal representative of. ಮತ್ತೆ ಹಂಗಾಗಿ ಏನಾಗ್ತದೆ? ಆಗಲ್ಲ. ಆಮೇಲೆ ಹಾಗಾದ್ರೆ ನಮ್ಮ ಹಂಗೇರ್ಲಿ ಬಿಡ್ಲಿ ಬಿಡಿ, ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡಿ, ನಾವು ಉಳಿಯೋದಿಲ್ಲ. The appellant counsel has not paid the cost as ordered on 27/9/23 and also on 12/10/23 and also not complied with office objections and hence the appeal is dismissed for non-payment of cost and also the non-compliance of office objections. Mohan PS, cost not paid and not complied, dismissed. Counsel absent ಅಂತ lock. Next,
For the
Suya
appellant-
Karle. Yes, madam.
Lordships, apologies, your lordship, due to oversight, we paid it to a different,
Karnataka State Level Advocates Clerks Association, instead of payment of cost, High Court Advocates Clerks Association, ಆಯ್ತು accepted. Compliance ಹೇಳಿ.
the court fees has been paid, your lordships.
Compliance, non-compliance.
That is regarding the your lordship, then it is an alias name, the alias name is same in the RSA and.
Correct name mention ಮಾಡಿದ್ರೇನ್ರಿ ಈಗ?
These are-
The council submits that correct name is mentioned in RSA and there was a typographical error in the
The RA judgment has not included the alias name, so it is there in the OS and you have included.
alias
the
was
same
not included.
In the RA judgment. it's included.
ನೇಗೌಡ ಅಂತ ಇದೆ. ಈಗ RSA ನಲ್ಲಿ. ಅಲಿಯಾಸ್ ಮೊದ್ಲಿರ್ಲಿಲ್ಲ. ಎರಡರಲ್ಲಿ ಇರ್ಲಿಲ್ವಾ ಅಲಿಯಾಸ್?
OS ಅಲ್ಲಿ ಇತ್ತು, RA ನಲ್ಲಿ ಇಲ್ಲ.
ಅಲಿಯಾಸ್ ಇತ್ತು OS ಅಲ್ಲಿ. ಆಯ್ತು. The council submission is accepted by inadvertently the alias name is not mentioned and both in original suit as well as in the RSA mentioned the name as well as alias name. And hence council submission is accepted. Court
Court
fee?
fee has been paid
ಯಾವಾಗ ಕಟ್ಟಿದ್ರಿ?
yesterday.
Yesterday. Council submits that court fee is paid yesterday. And hence office is directed to verify and put up. Non-compliance of office objection. Portal mood ಬೇರೆ ಇದೆ. Appellant counsel is absent in spite of portal memo ಯಾರು ಅವ್ರು ಹಾಕಿದಾರ ಅಥವಾ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಾಕಿದಾರ ನೋಡಿ. ಅದೇ in spite of portal memo is moved and hence on cost of ₹500 another 2 weeks time granted to comply with office objections. 2 weeks on cost. Alias name of appellant number in RSA not reflected in RA to be clarified along with council submission. ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ, ಇಲ್ಲಿ ಮೆನ್ಷನ್
ಅಲ್ಲ
ಮಾಡಿಲ್ಲ.
RA ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಮಾಡಿಲ್ಲ.
OS ಅಲ್ಲೂ ಇದೆ, ನಾವು appeal ಅಲ್ಲಿ
OS ಅಲ್ಲಿ ಇದೆ, ಇಲ್ಲೂ
ಮಾಡಿದ್ದೀವಿ.
ಇದೆ.
RA
Appellant counsel
judgment
submitted
ಅಲ್ಲಿ.
that in OS as well as this RSA alias name is mentioned but by mistake not mentioned in RA. Council submission is accepted. Cost to
ಕಾಸ್ಟ್ ಪೇ ಮಾಡಿದ್ವಿ, ಬಟ್
ಹಾ.
ಮೈ ಮಿಸ್ಟೇಕ್ ಇಟ್ ಇಸ್ ಗಾನ್ ಟು ಸಮ್ ಅದರ್.
appellant counsel submits that cost is paid. ಬಾಕಿದೆಲ್ಲ office objections comply ಆಗಿದೆಯಾ? ಯಾವ್ದು? ಆಯ್ತಾ? ಆಯ್ತು. ಬೇರೆಯವ್ರು ಕಟ್ಟಿದಾರ?
ಬೇರೆದಕ್ಕೆ ಹೋಗ್ಬಿಟ್ಟು.
Accepted. Filing of the payment of cost is accepted. ಅಷ್ಟೆಲ್ಲ post the matter for admission. Next, notice to R2 for second time. Appellant counsel is absent, 1 week time granted to pay PF. If PF paid, issue notice to R2. ನಾಳೆ ಯಾವ್ದು steps matter ಯಾವ್ದು ಹಾಕೋದ್ ಬೇಡ ನಾಳೆ. ಸಾಕು ಮಾಡಿರೋದು 2 ತಿಂಗಳು. Next.
For
Acceptance of payment of court fee ಏನ್ರಿ ಅದು?
For
ಯಾಕ್ರಿ ಗೊತ್ತಾಗೋದಿಲ್ವಾ ಯಾರಿಗೆ ಹಾಕಿರ್ತದೆ? ಎಲ್ಲರೂ ಹೀಗೆ ಮಾಡ್ತಾರಲ್ಲ.
council was paid.
Accepted. Payment of cost is accepted. ಬೇರೆಲ್ಲ ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಒಂದು ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಒಂದು ಹಾಕ್ಬೇಕು.
ಹಾ?
ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಒಂದು ಹಾಕ್ಬೇಕು.
ಹಾಕ್ಬೇಕಾ ಇನ್ನೂನು?
ಅದೊಂದು 1 week ಟೈಮ್ ಕೊಟ್ಟರೆ ಪಾರ್ಟಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀವಿ.
ಇಲ್ವಾ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ವಾ ಮೇಡಮ್? ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದ್ದಾರೆ, ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕ್ಬೇಕು. ಬೇಡ, ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್. ನೆಕ್ಸ್ಟ್, ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ 4th time. Acceptance of cost ಇದ್ರಲ್ಲಿ ಹಂಗೇನಾ? ಯಾಕ್ರಿ ರಾಂಗ್ ಕಾಸ್ಟ್ ಪೇಮೆಂಟ್ ಮಾಡ್ತೀರಿ ಎಲ್ಲ?
1 week time.
Accepted, cost payment of cost is accepted, compliance ಹೇಳಿ.
1 week.
Again 1 week time and hence further on further cost of rupees 500. Another 2 weeks time granted and if not complied within 2 weeks, appeal is dismissed without reference to the bench. ನಾಲ್ಕು ಸರಿ ಹಾಕಿದ್ರು ಹಿಂಗೇನೆ. ಹೇಳಿ.
Serial number 38 my lords.
38
Held up in another court.
ಆಗೋಯ್ತಲ್ಲ, ಏನಾಯ್ತದ?
My lords ಅದ್ರಲ್ಲಿ
ಅದ ಆ ಕೇಸ ಆಯ್ತಲ್ಲ, ಆಗೋಯ್ತು. 2 ಸರಿಲೂ ಕಾಸ್ಟ್ ಕಟ್ಟಿಲ್ಲ, ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
ಅಲ್ಲ ಸ್ವಾಮಿ 38 serial number 38.
38 ಹೇಳ್ತಾ ಇರೋದು. ಕಾಸ್ಟ್ 2 ಸರಿ ಹಾಕಿತ್ತಲ್ಲೇನ್ರಿ? ಅದಲ್ವಾ? 38 ಏನಿದು?
ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇದೆ.
ಮೆಮೋ ಮಾಡೋದು ಕಾಸ್ಟ್ ಕೊಟ್ಟಿ ಕಾಸ್ಟ್ ಮೇಲೆ ಅರ್ಜೆಂಟ್ ಮಾಡಿದೀನಿ. ಮೆಮೋ ಮೂವ್ ಮಾಡಿ ಕೋರ್ಟ್ ಮುಂದೆ ನೀವಿಲ್ಲ.
Held up in the another.
ಆಯ್ತು, ಏನಿಲ್ಲ, 500 ರೂಪಾಯಿ ಕಟ್ಟಿ ಕಂಪ್ಲೈ ಮಾಡಿ ಅಷ್ಟೇ. ದಟ್ಸ್ ಆಲ್. ನೆಕ್ಸ್ಟ್.
I have given this council submission ಸ್ವಾಮಿ.
ಏನ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ, ಯಾವ್ದು ಇಲ್ಲ. ನಾನು ನೋಡಿದೀನಿ ನೋಡಿ.
ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ
37 ಅಲ್ಲಿ ಯಾವ ಇದು ಇಲ್ಲ. 38 ಅಲ್ಲಿ ಇಲ್ಲ ರೀ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ, ಕೋರ್ಟಲ್ ಮೆಮೋ ಮೂವ್ ಮಾಡಿದಿರಿ.
ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇದೆ ಸ್ವಾಮಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4 ಗೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ವಿ.
ಯಾವ ಸಬ್ಮಿಷನ್ ಇಲ್ಲ ನೋಡಿ, ತಗದ್ ನೋಡಿ, ಯಾವ್ದು ಇಲ್ಲ. Next. 38 ರೀ. ಡೋಂಟ್ ವೇಸ್ಟ್ ದಿ ಟೈಮ್. ಟೈಮಿಗೆ ಇರೋದಿಲ್ಲ, ಬಂದ್ ಮಾಡ್ತಾ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ಬೇಡಿ. ಇಲ್ಲಿ ದಿನಕ್ಕೆ 100 ಮ್ಯಾಟರ್ ಇರ್ತಾವ, ಬರೀ ಪ್ರೋಸೆಸ್. ದಿನ ಬರೀ 2 ಅವರ್ ಬರೀ ಅದೇ ಕೆಲಸ ಆಫೀಸ್ ಇಲ್ಲಿ ಕುತ್ಕೊಂಡು.
Appearing for the applicant, 2 weeks time may be granted, my lord. 2 weeks time may be granted.
Council 6, 2 weeks time to pay PF and furnish correct address. If furnished, 2 weeks issue notice to R2. Then R3 ಏನಾಗಿದೆ?
RT steps ತಗೊಳ್ತೀನಿ sir.
2 weeks time granted to bring the LRs of R3.
Interim order may be extended, my lord.
Interim order granted earlier is extended. ಅಲ್ಲ ರೀ, PF ಯಾಕೆ ಕೊಡಲ್ಲ ಮತ್ತೆ? Interim order ಇಟ್ಕೊಂಡು. Next 44.
ಕಾಸ್ಟ್ ಇಸ್ ಪೇಡ್.
Non compliance of office objection 5th time.
ಅಪ್ಲೈಡ್ ಮಾಡಿದ್ವಿ. 2 weeks time ಟ್ರೇಸ್ ಮಾಡಿ ಅಪ್ಲೈಡ್ ಮಾಡಿ ಕಾಪೀಸ್ ನಾಟ್.
ಏನ್ ತೋರಿಸ್ತಾ ಇದೀರಿ ಹಿಂಗೆ?
ರೆಸಿಪ್ಟ್ ಆಫ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಪ್ಲೈಡ್.
ಅದೇನ್ರಿ ಅದು ರಸೀಟು?
ರೆಸಿಪ್ಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕಾಪಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪೀಸ್ ಅಪ್ಲೈಡ್ ಮಾಡಿ.
ಅಪ್ಲೈ ಮಾಡಿದಿರಿ?
ಅಪ್ಲೈಡ್ ಮಾಡಿ.
ಆಯ್ತು.
ನಾಟ್ ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ.
ಈ ಕಾಸ್ಟ್ ಕಟ್ಟಿದಿರಾ?
ಕಾಸ್ಟ್ ಪೇಡ್.
ಯಾವಾಗ?
2 days.
Council submits that he has paid the cost. 2 ಕಡೆ ಇದೆ, 2 ಸರಿ ಇದೆ ಕಾಸ್ಟ್.
2 ಕಾಸ್ಟ್ ಪೇ.
2 ಸರಿ ಇಲ್ಲ ಕಟ್ಟಿದಿರಾ? And council submits that both the costs are paid. And council submits that he has applied for ಏನ್ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದಿರಿ?
ಅದು OS ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್.
Valuation slip of OS and hence for seek further time. And hence another 2 weeks time granted and further cost of rupees 500 payable at registry. If cost not paid, further cost not paid and not complied within 2 weeks, appeal is dismissed without reference to the bench.
ಅಂಬಲ್ ಸರ್ವಿಸ್
ಯಾವ್ದ್ರಿ? 44 ಅಲ್ಲ?
ಅದು ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲಿಂದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಂದ ಅಲ್ಲಿ ಹೋಗಿದೆ ವಾಪಸ್. ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬೆಂಗಳೂರು ರೂರಲ್ ಕೋರ್ಟ್.
ಎಲ್ಲಿಗೆ ಹೋಗಿದೆ?
ವಾಪಸ್ ಹೋಗಿದೆ.
ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಇಂದ ವಾಪಸ್ ಹೋಗಿದೆ.
ಬಟ್ ಅಲ್ಲಿ ಟ್ರೇಸ್ ಆಗ್ತಾ ಇಲ್ಲ ರೆಕಾರ್ಡ್ಸ್. ಕಳೆದ ಬಾರಿ ತಮ್ಮ ಗಮನಕ್ಕೆ ತಗೊಬಂದಿದ್ದು ಬೆಂಗಳೂರು.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ ನಾನು? 5ನೇ ಸರಿ ಬಂದಿದೆ.
ಹೌದು ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ನಾವು ಹೋಗಿ ಪರ್ಸೂ ಮಾಡ್ತೇವೆ. ನಾವು ಶಿರಸ್ತೆದಾರಿಗೆ ಹೇಳಿದ್ರೆ ಅವ್ರು ಕ್ರಮ ತಗೊಳ್ಳಿ. ತಾವೇನಾದ್ರೂ ಒಂದು ಅವ್ರು ಡೈರೆಕ್ಷನ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಅನುಕೂಲ ಆಗುತ್ತೆ.
ಏನಂತ ನಾನ್ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಬೇಕು? ರೆಕಾರ್ಡ್ ಟ್ರೇಸ್ ಮಾಡಿದಕ್ಕೆಲ್ಲ ಹೈಕೋರ್ಟ್ ನವರು ಡೈರೆಕ್ಷನ್
ಏನಾಗುತ್ತೆ ತಮ್ಮ ಗಮನಕ್ಕೆ ಕಳೆದ ಬಾರಿ ತಂದಿದ್ವಿ. ವಿತೌಟ್ ರೆಫರೆನ್ಸ್
ಫರ್ದರ್ ಕಾಸ್ಟ್ ಬೇಡ, ಅನದರ್ 2 weeks ಅಂತ ಕೊಡಿ, ನೋಡಿ ಮಾಡ್ಕೊ ಬರ್ಲಿ ಅವ್ರು. ಇಲ್ಲಾಂದ್ರೆ ಎಂಡರ್ಸ್ಮೆಂಟ್ ತಗೊಬನ್ನಿ, ಬರ್ಕೊಡಿ ಅಂತ ಹೇಳಿ. ರೆಕಾರ್ಡ್ಸ್ ಆರ್ ನಾಟ್ ಟ್ರೇಸ್ಡ್
ಅಂತ ಹೇಳ್ತಾರೆ. ಪ್ರತಿ ಸಾರಿ ಹೋದಾಗಲೂ ಕೂಡ ನಾವು
ಬೇಡ, ಈಗ ಕೋರ್ಟ್ ಮುಂದೆ ನಾವು ಸಬ್ಮಿಷನ್ ಮಾಡಿದೀವಿ, ಇಲ್ಲಾಂದ್ರೆ ಕೋರ್ಟ್ ನವ್ರು ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿ ಪ್ಲೀಸ್. ಎಂಡರ್ಸ್ಮೆಂಟ್ ಕೊಡಕ್ಕೆ ಹೇಳಿ
ಪ್ಲೀಸ್.
ಆಮೇಲೆ ಇನಿಷಿಯೇಟ್ ಮಾಡೋಣ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. ನೀವ್ ಅವಾಗ ಏನ್ ಮಾಡ್ಬೇಕು? ಅಲ್ಲಿ PDJ ಹೋಗಿ ಹೇಳ್ಬೇಕು. ಮಾಡ್ಬೇಕಲ್ಲ ಮತ್ತೆ. ಬಂದ್ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಕೊಡಿ ಅಂದ್ರೆ ನಾವೆಲ್ಲ PDJ ಪವರ್ಸ್ ಎಲ್ಲ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡಕ್ಕಾಗುತ್ತಾ? ಆಯ್ತು. ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮಹೇಶ್ BJ.
Applied, my lord.
ಹೇಳಿ ಮೇಡಮ್.
Mahesh BJ. 1 week time ಕೊಟ್ರೆ ಕಾವಿಲ್ ಕಂಪ್ಲೇಂಟ್.
ಕೋರ್ಟಲ್ ಮೆಮೋ ಮೂವ್ ಮಾಡಿದಿರಿ? ವಿತೌಟ್ ಕಂಪ್ಲೈನ್ಸ್ ವೈ ಹ್ಯಾವ್ ಮೂವ್ಡ್ ದಿ ಮ್ಯಾಟರ್?
ಮಾಡಿದೀನಿ, ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದೀನಿ. ಏನ್ ತಪ್ಪಾಗಿದೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ನನ್ಗೆ.
DCF ಅಷ್ಟೇನಾ? ಕೌನ್ಸಿಲ್ 1,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಆಗಿದೆ, ಕಾಸ್ಟ್ ಕಟ್ಟಿದಿರಿ.
ಕಟ್ಟಿದೀನಿ ಸರ್.
ಮತ್ತೆ ಯಾಕೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಲಿಲ್ಲ? ಕೋರ್ಟ್ ಫೀ ಯಾಕೆ ಕೊಡ್ತಾ ಇಲ್ಲ? ಡೆಫಿಸಿಟ್ ಕೋರ್ಟ್ ಫೀ.
ಕೋರ್ಟ್ ಫೀನು ಕಟ್ಟಿದೀನಿ, ಮತ್ತೆ ನಾನು ರೆಸಿಪ್ಟ್ ಹಾಕಿದೀನಿ, ಫೈಲ್ ಮಾಡಿದೀನಿ.
ಡೆಫಿಸಿಟ್ ಇದೆ ಮೇಡಮ್, ಯಾವಾಗ ಹಾಕಿದ್ರಿ ಹೇಳ್ಬಿಡಿ. ಡೆಫಿಸಿಟ್ ಯಾವಾಗ ಕಟ್ಟಿದ್ರಿ ಹೇಳಿ, ಎಷ್ಟು ಕಟ್ಟಿದ್ರಿ?
ಒಂದು
ಡೇಟ್ ಆಫ್ ಪೇಮೆಂಟ್ ಹೇಳಿ ಮೇಡಮ್, ಯಾವಾಗ? ಲಾಂಗ್ ಬ್ಯಾಕ್ ಯಾವ್ದು ಇಲ್ಲ ಇಲ್ಲಿ.
ಪೇಮೆಂಟ್ ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
ಇಲ್ವಾ ಮೇಡಮ್? ಇದೆಯಲ್ಲ ರೆಸಿಟ್ ಆಫ್ ರುಪೀಸ್ ಇದೆ, ಇದ್ರಲ್ಲಿ ಎಷ್ಟು ಕಟ್ಟಿದೆ? ಇದು ಎಷ್ಟು ಬರ್ದಾನ್ ನೋಡ್ರಿ, ಅವ್ನು ಓದಕ್ಕಾಗುತ್ತಾ ಎಷ್ಟು ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ? 5,600. ಆಮೇಲೆ ಡೆಫಿಸಿಟ್ ಇದೆ, ಎಷ್ಟಿದೆ ಮೇಡಮ್ ನೋಡಿ? ಡೆಫಿಸಿಟ್ ಎಷ್ಟು ಬರ್ದವ್ರ? ಬರಿಬೇಕಲ್ಲ ಮೇಡಮ್. ಕಟ್ಟಿರೋದು ನಾಟ್ ಕರೆಕ್ಟ್ ಅಂತ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ ಹಾಕ್ಬೇಕು ಎಷ್ಟು ಡೆಫಿಸಿಟ್ ಇದೆ ಅಂತ. ಎಷ್ಟು ಸರಿ ಹೇಳುತ್ತದೆ ಅವರಿಗೆ. ತೊಗೊಳ್ಳಿ ದ ಕೌನ್ಸಿಲ್ಸ್ ಮತ್ತೆ ಮೆಮೋ ಮೂವ್ ಮಾಡಿದ್ರಿ ಕೋರ್ಟ್ ಫೀ ಡೆಫಿಸಿಟ್ ಕಟ್ತಲೇನೆ
ಕಟ್ಟಿದಿರಿ ಅಂತ ಹೇಳಿದ್ರು.
ತೊಗೊಳ್ಳಿ ಏನಾಯ್ತು ಮೇಡಮ್?
1 week time ಸಾಕು.
The council seeks 1 week time and in spite of non-payment of deficit court fee, memo is moved and hence on cost of rupees 500, another 2 weeks time granted to pay the deficit court fee. Harish Pandari,
Lordship, in this case,
non-taking of cess in
yes,
respect of
Lordship,
R8.
I want to make a submission with respect to that. On the last date, due to oversight, we have submitted that R8 has deceased. But R8 to the LRs are already on record. Now there is another party who has expired.
Who is expired?
One misses. Now it would, because we have implemented the LRs.
The
Lordship,
council
the
submitted
numbers
that R8 LRs are already on record, but the
One
ಯಾರು ಸತ್ತೋಗಿದ್ದಾರೆ ಹೇಳಿ.
Gangaratnam Manta
ಹೆಸರು ಹೇಳ್ರಿ. ಅಲ್ಲ ಅವ್ರಿಗೆ ಇದನ್ನ ಹೇಳಿ.
would be placed as R8 now, Lordship.
ರ್ಯಾಂಕಿಂಗ್ ಹೇಳ್ರಿ. ಈಗ R8 ಗೆ ಇರೋದು ನಾಟ್ ಬ್ರಿಂಗಿಂಗ್ ಆಫ್
Yes, Lordship. After impleading, the numbers have been changed, Lordship, due to which now it is R8 is Gangaratnam.
ಆಯ್ತು. ಈಗ ರಾಮಕ್ಕ ಬದುಕಿದ್ದಾರೆ.
Ramaka has deceased, Lordship.
ರಾಮಕ್ಕ ತೀರ್
Ramaka has died.
ಹಾ
ಬರೀ ಕೊಟ್ಟಿದ್ರು.
ಆಯ್ತು ಗಂಗಾರತ್ನಮ್ಮನ ತಂದಿದ್ದೀರಿ ರೆಕಾರ್ಡ್ಗೆ.
Yes, Lordship. ಅದರಲ್ಲಿ ವಕಾಲತ್ ಒಂದು ಹಾಕ್ಲಿಕ್ಕೆ ಪೆಂಡಿಂಗ್ ಇದೆ. ಇನ್ ಓವರ್ಸೈಟ್ ಆಗಿ ನಾವು ಮಾದಕ
ಸರಿ ಈಗ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಬೇಕೋ ಬೇಡವಾ ಹೇಳ್ರಿ ಏನಂತ.
if Gangaratnam has already on record, then ವಕಾಲತ್
ಆಲ್ರೆಡಿ ಬ್ರಾಟ್ ಆನ್ ರೆಕಾರ್ಡ್.
Lordship.
ಹಾ ವಕಾಲತ್ ನೀವೇ ಹಾಕ್ತೀರಾ? ಯಾರು ನೀವ್
ಇದೆ.
ಯಾರಿಗೆ?
ವಕಾಲತ್ other side.
ಯು ಆರ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
No, I appear for appellant, Lordship.
ಅವ್ರಿಗೆ ವಕಾಲತ್ ಅಂದ್ರೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ.
Notice ಆಗಿಲ್ಲ, Lordship. As per my knowledge, notice has not been served on them.
ಈಗ ಮತ್ ನೀವು ತೀರ್ಕೊಂಡ್ರು ಅಂದ್ರೆ ಫಸ್ಟ್ ಟೈಮ್ ಮಾಡುವಾಗ್ಲೇನೆ ಮಾಡಿದೀರಾ ಅವ್ರನ್ನ ಪಾರ್ಟಿನ?
Yes, Lordship.
ಈಗ
Lordship, but
ನೋಟಿಸ್ ಆಗಿದೆಯಲ್ಲ ಮೇಡಮ್ ಎಲ್ಲರಿಗೂನು. R7 ಮುನಮ್ಮ ಡೆಡ್ ಅಂತೆಲ್ಲ ಇದೆ. ಈ ಗಂಗಾರತ್ನಂ
then notice is held sufficient. R8 ನಾವು ಅವರು R8 shall be overruled, Lordship, as we have made wrongly submitted that R8 has
ಗೊತ್ತಾಯ್ತು ಬಿಡಿ. ಈಗ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. PF ಇಟ್ಟಿದ್ದಾರೆ ಕಳ್ಸಿಲ್ಲ. ಏನಾಯ್ತು ಮೇಡಮ್? Submits that R8 LR already on record, already brought on record, that is Srimati Gangaratnamma, and hence notice has to be ordered. And hence issue notice against R8 LR Gangaratnamma, Srimati Gangaratnamma.
one more submission, Lordship, till next date, if we could get grant stay, as they are initiating other proceeding in respect of the
ಏನ್
scheduled
ಎಸ್ಟೇಟ್
property.
ಸ್ಟೇ ಇದೆಯಾ?
We have applied, we have filed an IA for stay, Lordship, as they have initiated FDP proceedings. And after FDP proceedings, in respect of the same suit scheduled property, the suit is one for partition. That being the case, now in respect of the same property, Lordship, they are filing other suits in different courts.
ಅದಕ್ಕೆ ನಾನೇನ್ ಮಾಡ್ಬೇಕು?
Lordship, the FDP, in respect of the said suit scheduled property, till next date of
ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ ಅಷ್ಟೇ. ಅಲ್ಲೇನಾರು ಇದ್ರೆ ಸೇಮ್ ಸೂಟ್ ಹಾಕಿದ್ರೆ ನೀವು ಸೆಕ್ಷನ್ 10 ಇನ್ವೋಕ್ ಮಾಡಿ ಸ್ಟೇ ಮಾಡಿಸ್ಕೊಳ್ಳಿ ಅಷ್ಟೇನೆ. ಆ ಕೋರ್ಟಲ್ಲಿ
they have
ಹಾಕೋಬೇಕು.
filed IA for stay of FDP, Lordship, as this Gangaratnam is also a purchaser.
ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ ಮೇಡಮ್, ದೆನ್ ವಿಲ್ ಸಿ. ಶಿವರಾಮ ಭಟ್.
Obliged, Lordship.
Next, non-compliance of office officer memo along with death certificate of RN R1.
I'm on behalf of the
Sithamma.
appellant, your lordships. We have filed a memo, your lordships. That is the only
ಮೆಮೋ
compliance.
ಮತ್ತೆ ಎಲ್ಲಾರು ತರ್ಬೇಕಲ್ರಿ ರೆಕಾರ್ಡ್ಗೆ.
LRs agli idare, your lordships. We have filed a note, your lordships, along with the cost title in.
ಏನ್ ಮೆಮೋ?
Memo
ಎಲ್ಲಾರು
is,
ಆಲ್ರೆಡಿ ಇದಾರೆ ಅಂತನಾ?
yes, your lordships.
ಅದನ್ನ ಹೇಳಿ ಯಾರು ಅಂತ.
Memo respondent number 1 ತೀರೋಗಿದ್ರು, your lordships. ಅವ್ರನ್ನ ಇದ್ ಮಾಡಿಲ್ಲ.
ಬೇರೆ ಎಲ್ಲಾರ್ಸ್ ಯಾರು ಹೇಳಿ?
Respondent 2 to 5, your lordships.
ಅದನ್ನ ಹೇಳಿ. 2 to 5 ಆರ್ ದಿ ಎಲ್ಲಾರ್ಸ್ ಆಫ್ R1 ಕರೆಕ್ಟಾ?
Yes, your lordships.
ಅಂಡ್ ಅಷ್ಟೇ ನಾವು ಹೇಳಿರೋದು ಮೇಡಮ್. ಅಂಡ್ ಮೆಮೋ ಹೇಳಿಲ್ಲ. ಮೆಮೋ ಮತ್ತೇನ್ರಿ ಇದು? ಮೆಮೋ ಏನಂತ ಹಾಕಿದ್ರೆ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಆಫ್ ಶ್ರೀಮತಿ
Your lordships are
ಕೈಂಡ್ ಪೆರುಸಲ್ ಆಫ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಅಂತ ಹಾಕಿದ್ರಿ. ಎಲ್ಲಿದೆ ಎಲ್ಲಾರ್ಸ್ ಅಂತ?
please, your lordships. RA judgment ಅಲ್ಲಿ one Mrs. Sitaraman.
ಹಾಕ್ರಿ ಮೆಮೋ ಕರೆಕ್ಟ್ ಆಗಿ ಯಾರು ಎಲ್ಲಾರ್ಸ್ ಅಂತ ಬರ್ದ್ ಕೊಡಿ ಈಗ.
non
ಅವರೇ ಬೇರೆನಾ?
non
Police violations need to be filed ಅಂತ officer section.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆಯಾ? ಎಷ್ಟ್ ಸರಿ ಬಂದಿದೆ ನೋಡಿ.
first time before the court, your lordships.
ಹೌದಾ? ಆಯ್ತು. 2 weeks time granted to comply with office objections. ಮೆಮೋನಲ್ಲಿ ನೀವು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿ ಯಾರು ಎಲ್ಲಾರು ಅಂತ. ನೆಕ್ಸ್ಟ್
For appointment, Lord, the name of the,
discrepancy in the name of defendant number 5 and 8 in OSRS. ಹೇಳ್ರಿ ಏನಾಯ್ತು?
it was wrongly mentioned that in the OS,
that Ramegowda, his name is Sri Ramegowda. The appellate court name was correctly shown Ramegowda, but it's shown that late Ramegowda, he is alive.
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 By mistake, it is mentioned as late Ramekoda, but he is alive.
But in the trial court,
In the appellate court.
appellate court,
In trial court,
in trial court, it was wrongly shown that Mante Ramegowda.
and and in the trial court wrongly mentioned as Mante Ramegoda. But in second appeal correctly mentioned his
mentioned.
name as
Uh,
only Ramegoda na?
only Sri Ramegowda.
Sri Ramegoda.
Ramegoda.
Ramegoda na?
Ramegoda,
Ramegoda.
not late.
And hence council submission is accepted. What's the
is-
matter for admission? ಬೇರೆ ಏನಾರಿದೆಯಾ?
In respond number 8,
Eight?
husband of respond number husband's name.
8 ಇದೆ.
8 ಇದೆ.
8 ಏನಾಗಿದೆ?
ಕರೆಕ್ಟ್ ಆಗಿ ತೋರಿಸಿದೀನಿ ಇಲ್ಲಿ ವೆಂಕಟೇಗೌಡ, ಅಲ್ಲಿ ರಾಂಗ್ ತೋರಿಸಿದ್ದಾರೆ. 8 ಸೂಟ್ ಅಲ್ಲಿ ವೆಂಕಟಪ್ಪ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
ವೆಂಕಟಪ್ಪ.
ಹೌದು.
ಸೂಟ್ರಲ್ಲಿ ಅಪೀಲಲ್ಲಿ
ಅಪೀಲಲ್ಲಿ ಚಿಕ್ಕಿರೇಗೌಡ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ಇಟ್ಸ್ ರಾಂಗ್.
The name of Venkatagowda wrongly mentioned in the trial court as Venkatappa.
Yes.
And in the appeal also
Chikkiregowda,
mentioned
Chikkiregowda.
as Chikkiregowda. But his correct name is
Shown in this appeal, my lord.
Venkatagowda in RSA. Howda correct
Yes,
name
yes.
Venkatagowda and the same is shown in RSA and hence council submission is accepted.
And there is a delay in the appeal, my lord. Notice has to go to the respondents.
Just to say that delay.
Delay 380 410 ದಿನ.
Huh?
300
Notice on IA and also on main against respondent.
And also I may permitted to serve the notice to the counsel who is appearing in FDP, my lord.
And also council is permitted to serve the copy of this appeal memo and IA on the council who appears in FDP.
Yes, the stay is also there.
Stay ಎಲ್ಲ ಆಮೇಲೆ ಬರ್ಬೇಕು. Notice ಹೋಗಿ ಬರ್ಬೇಕು. Next. Awaiting service of notice to R1 to R6. Await notice 11/7 or 12/8. ಯಾರಿಗೆ? R6 ಮಾತ್ರ. Council Sri TK Chandrasekhar and TA na? TA Chandrasekhar undertakes to file wakalat for R6. Await notice of R1 to 5. List this matter on 12/8. If wakalat is filed, show the name of the council in the cause list. Dasappa B. Compliance of fourth time.
I have completed the office objection, Your Honor. I have completed the office of objection.
ಮತ್ತೆ ತೋರಿಸ್ತಾರೆ.
ಏನು
Council ಎಷ್ಟಿದೆ
ಸರ್?
ನೋಡಿ ಮೇಡಮ್.
ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ ಟೈಮ್ 2ನೇ ತಾರೀಕು ಕಂಪ್ಲೇಂಟ್ ಇವು ನಾವು.
Certified copy of the OS
I have
judgment.
given you.
ಹಾಕಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಯಾವಾಗ?
2/9 ಸರ್.
ಯಾವತ್ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
2/9 ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ.
2/9.
2/9. ಹೌದು ಸ್ವಾಮಿ. ಅಲ್ಲ 2/7 ಮೊನ್ನೆ ಸ್ವಾಮಿ.
Submits that on 2/7 he has furnished the certified copy of the judgment and decree of OS. And hence the registry is directed to put up the same. ಇನ್ನೊಂದೇನು G3 ನ?
GT ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ.
And also G3 ಅಂತ ಕೊಡಿ. Put up the same. Next Chetana. Discrepancy in the disposal date of OS is stated as 18/2, whereas improved order stated as, the typographical error is found in mentioning the disposal date and hence a council submission is accepted. Post the matter for admission. Tirthegowda, non-compliance of office objection second time. Non-furnishing of certified copy of OS judgment.
ಫರಿಶ್ ಮಾಡಿದ್ದೀವಿ ಸರ್.
ಯಾವಾಗ?
ಲಾಸ್ಟ್ ಲಾಂಗ್ ಟೈಮ್.
ಡೇಟ್ ಹೇಳ್ರಿ, ಯಾವತ್ತೊಂದು ಅಕ್ನಾಲ್ಜ್ಮೆಂಟ್ ತಗೊಂಡಿರ್ತೀರಾ, ಡೇಟ್ ಹೇಳಿ.
ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್
ಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರಂ ಮೇಲೆ ಒಂದು ಇರುತ್ತೆ ನಿಮ್ ಸಿಗ್ನೇಚರ್ ಇದು.
ಲಾಸ್ಟ್ ಟೈಮ್ ಫರ್ನಿಶ್ ಮಾಡಿದೀವಿ OS ಸರ್ಟಿಫಿಕೇಟ್.
ನಾನು ಹೇಳೋದು ಅರ್ಥ ಆಯ್ತಾ? ನೀವ್ ಯಾವತ್ ಫರ್ನಿಶ್ ಮಾಡಿದಿರಿ ಒಂದು ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಇರುತ್ತೆ, ತೋರ್ಸ್ರಿ. ಅಪ್ಲೈ ಮಾಡಿದೀವಿ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದಿರಿ ಅಷ್ಟೇನೆ. ಮತ್ತೆ
2 weeks
ಫರ್ನಿಶ್ ಮಾಡಿದೀವಿ ಅಂದ್ರೆ ಎಷ್ಟನೇ ಸರಿ ಬಂದಿದೆ ನೋಡಿ ಮೇಡಮ್?
ಸೆಕೆಂಡ್ ಟೈಮ್.
The council is given another 2 weeks time to furnish the certified copy of the judgment and decree of lower court ಅಲ್ಲ ಮೇಡಮ್, ಒರಿಜಿನಲ್ ಸೂಟ್ ಅದೊಂದೇನ ಇರೋದು? ಇಷ್ಟು ಹೇಳಿ ಮೊದ್ಲೇ ಕೊಡ್ತಾ ಇದ್ನಲ್ಲ ಟೈಮ್. ಫರ್ನಿಶ್ ಮಾಡಿದೀವಿ ಅಂತ ಸುಳ್ಳು ಹೇಳಿರ 53. ಆಯ್ತು. ಕಂಪ್ಲೈನ್ಸ್ 2 weeks time. Non-compliance of office objection second time Sangamesh RB. 2 weeks time granted to comply with office objection. Next, second time, Parinita channel, 2 weeks time granted to comply with office objections. Next.
PF for appellant.
PF ಕೊಟ್ರಾ?
PF ಕೊಟ್ಟಿದ್ದೀರಾ?
ಯಾವಾಗ?
ನೆಕ್ಸ್ಟ್ ಡೇನೆ ಕೊಟ್ಟಿದ್ದೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್. ಅಡ್ಮಿಟ್
ಅದೆಲ್ಲ ಹೋಗಿ ಬಂದಿದೆ ಬಿಡಿ, ಈಗ ಮತ್ತೆ ಕೊಡ್ಬೇಕು ಫ್ರೆಶ್ ಆಗಿ. Council is directed to pay PF within 1 week. If PF paid, issue notice to R2, R3, R7, R8, R9, R10, R12. ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಹೊಸದಲ್ಲ ಮೇಡಮ್ ಇದು? ಆಯ್ತು, ಇನ್ನು 8 ಆಗಿಲ್ಲ. ಪಾರ್ಟಿಷನ್ ಏನ್ ಬೇಕಲ್ಲ, ಡೇಟ್ ಕೊಟ್ಟಿದೀವಿ ಇಲ್ಲಲ್ಲ? ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಇಸ್ ಡಿಸ್ಪೆನ್ಸ್ಡ್ ಸಿನ್ಸ್ ಸೂಟ್ ಇಸ್ ಓನ್ಲಿ ಫಾರ್ ದಿ ರಿಲೀಫ್ ಆಫ್ ಪಾರ್ಟಿಷನ್. ಪೇಪರ್ ಬುಕ್ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿದೀನಿ.
ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್
ಸ್ಟೇ ಇದೆಯಾ?
ಅಲ್ಲ
ಎಂಟ್ರಿ ಮಾಡ್ರಿ, ಈಗ ಆಲ್ರೆಡಿ ಇದೆಯಾ?
ಇಲ್ಲ ನಾವು
ಇಲ್ಲ, ಸರ್ವ್ ಆಗ್ದಲ್ಲ ಏನ್ ಸ್ಟೇ ಕೊಡೋದು? ಸರ್ವಿಸ್ ಮಾಡ್ಕೊ ಬನ್ನಿ ಅಂತ ಕೊಟ್ಟಿಲ್ಲ. ಉಮಾಶಂಕರ್ MN.
Page 34 madam. Page 34.
ಏನಾಯ್ತು ಹೇಳಿ?
ಅದು ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರು ಇದೆ, ಡಿಕ್ರಿನಲ್ಲಿ ಅವ್ರು ಬಿಟ್ಟಿದ್ದಾರೆ.
ಡಿಕ್ರಿನಲ್ ಬಿಟ್ಟಿದ್ದಾರೆ,
ಅವರೇ ಬಿಟ್ಟಿದ್ದಾರೆ.
ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ.
ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ.
ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್, ಬಟ್ ನೀವು ಇಲ್ಲಿ ಹಾಕಿದೀರಾ?
ಇಲ್ಲಿ ಹಾಕಿದೀವಲ್ಲ.
ಆಯ್ತು, ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್ ಇನ್ ದಿ ಡಿಕ್ರಿ ಕಾಪಿ ನೇಮ್ ಇಸ್ ನಾಟ್ ಮೆನ್ಷನ್ಡ್.
4A my lord. In the judgment
4B ಇರೋದ್ರಿ ಈಗ.
ಅದೇ 4B ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ, ಡಿಕ್ರಿನಲ್ಲಿ ಅವ್ರು ಬಿಟ್ಟಿದ್ದಾರೆ.
Council submits that the name of 4B is mentioned in the judgment but not mentioned in the decree, and here he has been made as party. ಹೌದಾ?
ಹೌದೌದು.
And council submission is accepted. Other than office objections ಎಷ್ಟಿದೆ? 3 ಇದೆ. Another 2 weeks time granted to comply with other office objections.
ಅದಕ್ಕೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿದೀವಿ. ಮಾಡಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಅಲ್ಲಿ ಸೂಟ್ ನಂಬರ್ ಅವ್ರು ಹಾಕಿಲ್ಲ ಆಫೀಸ್ನವರು.
ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಇದೆಯಾ? ಏನಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನೋಡಿ.
alias Jayamma is not made party in OS and in
ಆರ್ಯನಾ?
party in RA and RS. ಅವ್ರು OS ಅಲ್ಲಿ ಇಲ್ಲ, RA ಮತ್ತೆ
OS ಅಲ್ಲಿ ಇಲ್ದವ್ರನ್ನ ಏನೋ ಪಾರ್ಟಿ ಮಾಡಿದಾರೆ ಅಂತ.
ಅವ್ರು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಲ್ಲಿ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಎಲ್ಲಾರು ಇರ್ಬೇಕ್ರಿ.
ಇದರಲ್ಲಿ ಎಲ್ಲ ಮಾಡಿದೀವಿ ಆರ್ಯ ಎಸ್ಟೇನಲ್ಲಿ.
ಈಗ ಅಪೀಲ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅಂದ್ರೆ OS ಅಲ್ಲಿ ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಎಲ್ಲಾರು ಇರ್ತಾರೆ.
ಮೇಡಮ್ ನಿಂಗಮ್ಮ is 4-1 in 35 page number 35.
ಇಂಥವ್ರನ್ನ ಸ್ವಲ್ಪ ಸೆಲೆಕ್ಟ್ ಮಾಡಿ ನನಗೆ ಪ್ಯಾಕ್ ಕಳಿಸ್ರಿ.
All are LRs.
ಅವರೇ ವಾಸಿ ದನ ಕಾಯರು.
ಮೇಡಮ್ ನಿಂಗಮ್ಮ is 4-1.
4-1.
4-1.
4 ಹಚ್ಚೋದ್ರೆ ಎಲ್ಲಾರು ತಂದವ್ರೆ.
ಎಲ್ಲಾರು ತಂದಿದ್ದಾರೆ.
ಅಪೀಲ್ ಅಲ್ಲಿ ತಂದವ್ರೆ. ಅವ್ರ ಹೆಂಗ್ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ?
ಅದೇ
ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಹೆಂಗ್ರಿ ಇರ್ತಾರ ಅವರು? ಈಗ R4 ಸತ್ತೋದ ತಕ್ಷಣ ಬೇರೆ ತಂದ್ರು ಪಾರ್ಟಿ ಅಲ್ವಾ? ಆಮೇಲೆ ಏನು? Office objection is overruled regarding non-mentioning of name of the R4 LR in the original suit, and they have been brought on record in appeal.
RA.
In RA. Overruled. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದೇನು?
ಅದು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಅಲ್ಲಿ OS ನಂಬರ್ ಬರ್ದಿಲ್ಲ ಅವರು.
ಆಯ್ತು, ಮೊನ್ನೆ ಕೂಡ ಸತ್ತೋದ. ಬಟ್ ಅಲ್ಲಿ ಕೆಳಗಡೆ ಬೇರೆ ತಂದಿಲ್ವಾ? ನೀವು ಸತ್ತವನ್ಗೆ ಹೆಂಗ್ ರ್ಯಾಂಕಿಂಗ್ ಕೊಡ್ತೀರ್ರಿ?
ಅಲ್ಲಲ್ಲ, ಸತ್ತೋರ್ ಕೆಳಗಡೆ ರ್ಯಾಂಕಿಂಗ್.
ಕೆಳಗಡೆ ಯಾರಿಗೂ ಇಲ್ವಲ್ಲ? ಇದಾರಲ್ಲ ಇಲ್ಲಿ ಯಾರು?
ಮೊನ್ನೆಗೌಡ ತಾನೆ.
Children of defendant number 4 born through his illicit relationship with Rangamma.
ಅದೇ 4 ಮಲಡ್ ಹೊನ್ನೇಗೌಡ
15 ಅಂತ ತೋರಿಸಿದ್ರಲ್ಲ, ಯಾಕೆ ಸತ್ತವನ್ನ?
ಎಲ್ಲಿ ಯಾವ್ದು?
ಅವನಿಗೆ ಎಲ್ಲಾರು ಯಾರು
ಅರೆಸ್ಟ್ ನಲ್ಲಿ
R15 ತೋರಿಸಿದ್ರಿ ನೋಡಿ. ಹೊನ್ನೇಗೌಡ ಸತ್ತೋಗೋಣ ಮೇಡಮ್. ಅದಕ್ಕೆ ಎಲ್ಲಾರು ತಂದಿರೋದು
ಅಲ್ಲಿ ಬರ್ದಿಲ್ಲ 15 ಕೆಳಗಡೆ. 15 ಕೆಳಗಡೆ ಹೊನ್ನೇಗೌಡ ಚಿಲ್ಡ್ರನ್ ಆಫ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 4 ಬಾರ್ನ್.
ಚಿಲ್ಡ್ರನ್ ಆಫ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 4 ಬಾರ್ನ್ ಥ್ರೂ
ಇದು ರಿಲೇಶನ್ ವಿತ್ ರಂಗಮ್ಮ. ಅದ್ ಕೆಳಗಡೆ ಬರ್ದಿದೀವಿ.
ಸರಿ ರೀ, R15 ಗೆ ಯಾಕೆ ಮಾಡಿದ್ರಿ ಅಂತ?
ಅದು
ಕೊಡಿ, ಮಾಡಿ ಕಂಪ್ಲೈ ಮಾಡಿ.
ಅದೊಂದೇ
ಕಂಪ್ಲೈ ವಿತ್ ಅದರ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ವಿತಿನ್ 2 weeks.
ಒಂದೇ ತಾನೆ?
ಒಂದೇನೆ ಹೋಗಿ ಮಾಡಿ. 10 ನಿಮಿಷವಾಯ್ತು. ನೆಕ್ಸ್ಟ್ note stated below cast title to be clarified and correctly stated with
appellant
respect to respond number 12A. note ಇದೆಯಾ?
ನೋಟ್ ಹಾಕಿದೀನಿ ಕೆಳಗಡೆ.
ಆಯ್ತು, ನೋಟ್ ಈಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್. ಕರೆಕ್ಟ್ ಅದು. ಇನ್ನೊಂದೇನೋ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇದೆ.
Court fee 50.
ನೋಟ್ ಏನೇ ಕ್ಲಾರಿಫೈ ಮಾಡಬೇಕು ಅಂತ ಮಾಡಿದ್ದಾರೆ.
The suit is for injunction filed by the appellant against the respondent number 1 Grama Panchayat my lord. The respondent the defendant number 2 to 17 are impleaded themselves as interested parties. Then during the pendency of the appeal, the defendant number 12 died. Their LRs were
brought on record.
But I have not amended the cause title before the RA. But the judgment and decree shows of the RA shows that the R12A to D were the absent. In the present appeal, I have not made them as party, as I have not claimed any relief against the
ನೋಟ್ ಹಾಕ್ಬೇಕು. ನೀವು ಹಾಕಿದೀರಾ?
ಹಾಕಿದೀನಿ, ಅಲ್ಲಿ ಕೆಳಗಡೆ ಹಾಕಿದೀನಿ. ಅದನ್ನ ಕ್ಲಾರಿಫೈ ಮಾಡಿ ಅಂತೇಳಿ ಹೇಳಿರೋದು.
ಆಯ್ತು. The council submits that no relief is sought against R12A to D.
Yes, ma'am.
And hence they have not been made as party.
Yes.
And notice also mentioned below the cast title,
Yes, my lord.
mentioned below the cast title. And hence the council clarifies the same.
Court
Andena?
fee- regarding the court
Discrepancy
fee,
in
my
the
lord.
court fee paid before RA to that of OS along with council submission. ಏನ್ ಹೇಳಿ?
Before
Court
the,
fee ಸಂಬಂಧಪಟ್ಟಂತೆ.
the suit is for permanent injunction and mandatory injunction, my lord. The court fee paid was rupees 50 before the trial court. The same is adopted by the appellant before the RA court also.
ನೀವೇನ
But-
appellate portal
ಹೌದು, ಹೌದು.
ಮತ್ತೇನ್
Correct
ಮೇಡಮ್
finding.
clarification?
But the decree of the RA shows that the rupees 100 paid in the,
100 ಅಂತ ತೋರಿಸಿದಾರೆ.
ಹೌದು. ಅಲ್ಲಿ ಡಿಕ್ರಿಯಲ್ಲಿ
50 ಬರೆಯುತ್ತಾವ 500 ಬರ್ದಿರ್ತಾರೆ ಅಷ್ಟೇ. ಟೈಪೋಗ್ರಾಫಿಕಲ್ ಎರರ್. ಸೂಟ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್. ತಲೆ
ನಾನು
ಓಡಿಸ್ತಾರೆ.
100 ಕೊಟ್ಟಿದ್ದೀನಿ ಇಲ್ಲಿ ಫಸ್ಟ್ 50
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರಿ? 50 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಈಗ?
50 ರೂಪಾಯಿ ಫಸ್ಟ್ ಕೊಟ್ಟಿದ್ದೆ, ಆಮೇಲೆ ಅಗೈನ್ 50 rupees ಪೇ ಮಾಡಿದ್ದೀನಿ,
ಯಾಕೆ?
ಕಟ್ಟಿದ್ದೀನಿ. When the officers
100
raised
ಸರಿ.
the objections.
ಮತ್ತೆ 500 ಯಾಕೆ ಬರುತ್ತೆ ಮೇಡಮ್? ಏಕೆ? ತಗೊಳ್ಳಿ, ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪಲೆಂಟ್ ಇವರೇ ಬರೀತಾರ. ಏನಂತ 500 ಅಂತ?
ಇಲ್ಲ 100 ಅಂತ ಹೇಳಿ.
500 ಅಂತ ಇದೆಯಲ್ರಿ?
100.
100 ಅನ್ನೋ 500 ಬರ್ದಿದ್ದೀರಾ? 400 ಕಟ್ಟಿ ಹಾಗಾರೆ ಡೆಫಿಸಿಟ್. ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕ್ರಿ? ನೀವು ಬರ್ದಿರೋದ ಅದು ಇವ್ರು ಟೈಪ್ ಮಾಡಿರೋದ? ನೋಡಿ ಮೇಡಮ್, ಅವ್ರ ಏನ್ ಅವ್ರ ಸಬ್ಮಿಷನ್ ಬರ್ದಿರ್ತಾರಲ್ಲ ಅದ್ ನೋಡಿ, ಒರಿಜಿನಲ್ ನೋಡಿ ನೀವು.
ಇಲ್ಲ, ನಾನು
Counsel for the
valuation
appellant would submit that suit is filed for the relief of permanent injunction and mandatory injunction, and accordingly court fee of rupees 50 is paid, and in the appellate court also the same is paid. Same is paid, but in the memorandum of cost shown as 100, and hence even deficit 50 is also paid, and hence council submission is accepted. Correct?
Yes, ma'am.
ಅಲ್ಲಿ ಎಷ್ಟು ತೋರಿಸಿದಾರೆ ಮೇಡಮ್? ಅವ್ರು 100 ತೋರಿಸಿದಾರೆ. ಆಫೀಸ್ನವ್ರು 500 ತೋರಿಸಿದಾರ? ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಒರಿಜಿನಲ್ ಏನು ಅಂತ ನೋಡಿ ಅಂತ. 1275 days in filing.
I am representing appellant counsel, my lord.
ಹಾ ಹೇಳಿ.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ OS number 291 is the same. 2 appeals were filed. That is, my lord, RA 170 of
OS 291 of 2005.
ಹೌದು
ಹೌದಾ?
ಹೌದು ಸುಮ್ಮನೆ.
ಆಯ್ತು.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, 2 ಅಪೀಲ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ, ಪ್ಲೈಂಟಿಫ್ ಅಂಡ್ ಡಿಫೆಂಡೆಂಟ್ಸ್.
ಇಬ್ರು ಫೈಲ್ ಮಾಡ್ತಾರೆ.
ಇಬ್ರು ಫೈಲ್ ಮಾಡ್ತಾರೆ.
ಆಯ್ತು.
That is one RA 154 of 2011 and another RA my lord 170 of 2013.
ಆಯ್ತು.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಇದು 154 of 2011 ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಬಿಟ್ಟು they have filed RAC at 1240 of 2014 before this honorable court.
ಆಯ್ತು.
ಆಮೇಲೆ ಇದೇನಾಗುತ್ತೆ, ಇದು RA 170 of 2013 ನ ಚಾಲೆಂಜ್ ಮಾಡಿ ಅದನ್ನು ಅಪೀಲ್ ಹಾಕಿದ್ದು, ಇವಾಗ ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ. ಮೇಲಡ್ ದೇರ್ ವಾಸ್ ಅವು RA ಕೋರ್ಟ್ ಅಲ್ಲಿ 2 ಕ್ಲಬ್ ಮಾಡೋದಿಲ್ಲ, ಬೇರೆ ಸಪರೇಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ.
ಮಾಡ್ಲಿ ರೀ, ಈ ಜಜ್ಮೆಂಟ್ ಆಗಿರೋದು ಯಾವಾಗ? 2015 ಅಲ್ಲಿ.
ಹೌದು,
ನೀವ್ ಈಗ ಫೈಲ್ ಮಾಡಿರೋದು ಯಾವಾಗ?
ಅದೇನೆ ಅದೇನಾಗಿದೆ, ಅದರಲ್ಲಿ ಒಬ್ರು ಬ್ರದರ್ ನೋಡ್ತಾ ಇದ್ರು, ಅದಕ್ಕೋಸ್ಕರ ಇದು
ನೋಡಿದ್ ಬಿಟ್ಬಿಡ್ರಿ, ಕತೆ ಹೇಳಿ, ಕಾರಣ ಹೇಳಿ, ರೀಸನ್ಸ್ ಹೇಳಿ.
ರೀಸನ್ಸ್ ಅದಕ್ಕೆ
ಸಪರೇಟ್ ಅಪೀಲ್ ಆಗಿ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ. ನೀವು ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಿತ್ತು, ಅರೈಸಿಂಗ್ ಕೋರ್ಟ್ ಆಫ್ ಕಾಮನ್ ಜಜ್ಮೆಂಟ್ ದೀಸ್ 2 regular appeals are pending before the court, both the matter has to be considered together ಅಂತ.
ಹೌದು,
ಅದ್ ಬಿಟ್ಬಿಡಿ, ಅದನ್ನ ಸ್ಟೋರಿ ಯಾಕೆ ಹೇಳ್ತೀರಿ? ಈಗ ಇಲ್ಲಿ ನಿಮ್ದು ರೀಸನ್ಸ್ ಹೇಳಿ. 1275 days ಅದೇಗ್ರಿ ಆಗುತ್ತೆ.
RSC ಅದು
4th day of February 2015 dispose
ಅಲ್ಲ,
ಆಗಿದೆ.
2 ಇದು both appeals are arising out of the my lord same judgment in
ನೀವು
OS.
2 ಹಾಕಿದೀರಾ?
ಅಲ್ಲ, ಹೌದು, ನಾನು ಒಂದು ಅಪೀಲ್ ಹಾಕಿದ್ದೀನಿ, ಅವರೊಂದು ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ.
ನಿಮ್ದು ಹೇಳ್ರಿ, 1275 days ಹೇಗ್ರಿ ಡಿಲೇ ಆಗ್ತದೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ ನಾನು. 2015 ಫೆಬ್ರವರಿ ಡಿಸ್ಪೋಸಲ್ ಆಗಿರೋದು, ನೀವು ಹಾಕಿರೋದು 31/10/2018.
2018
ಆಗ್ತಲ್ಲ, ಅಷ್ಟೇ ಆಗ್ತದೆ. 3,900
3 ವರ್ಷ 4 ತಿಂಗಳ
4 ತಿಂಗಳು. 4 ತಿಂಗಳಲ್ಲ, ಅಕ್ಟೋಬರ್ ನೀವು ಹಾಕಿರೋದು 8 ತಿಂಗಳು, 3 ವರ್ಷ 8 ತಿಂಗಳು. ಫೆಬ್ರವರಿ ಜಜ್ಮೆಂಟ್ ಆಗಿರೋದು ಫೆಬ್ರವರಿ.
2 ಕ್ಲಬ್ ಮಾಡಿದ್ರೆ ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ದಿ ಸೇಮ್.
ರೀಸನ್ ಹೇಳ್ರಿ, ಅದು ಕ್ಲಬ್ ಮಾಡೋದು ಆಮೇಲೆ. ಫಸ್ಟ್ ನೀವು ರೀಸನ್ ಹೇಳಿ. ಡಿಲೇಗೆ ಏನ್ ಹೇಳಿದಿರಿ? ಡಿಲೇ
ಮಿಲಾರ್ಡ್
CD ಇನ್ ಫೈಲಿಂಗ್ ಲಿಸ್ಟ್ ಆದಾಗ ನೋಡ್ಕೊ ಬರ್ಬೇಕು ರೀಸನ್ಸ್ ಏನು ಅಂತ. ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್
ಪ್ಯಾರಾಗ್ರಾಫ್ 3 and 4 ಮಿಲಾರ್ಡ್. That he was not aware of the judgment and decree ಅಂತ ಹೇಳ್ತಾರೆ ಒಂದರಲ್ಲಿ. And my lord, second defendant, my lord, the one of second appellant was, my lord, conducting
Regular
the
appeal,
case.
second appeal ಎಲ್ಲ ಆಯ್ತು. RA so were not aware of the proceedings in RA number 170 of 2000 till recently. Accordingly, the finding of trial court in respect of suit item number 5 also dismissed the regular appeal by the lower appellate court on the ground of delay being erroneous and not sustainable in law. ಯಾವಾಗ ಬಂತು ನಿಮ್ ನಾಲೆಡ್ಜ್ಗೆ?
I will file better affidavit.
ಆಮೇಲೆ certified copy was applied on 18/9/2014. ಆಯ್ತು, 89 ಅಲ್ಲಿ ಅಪ್ಲೈ ಮಾಡಿದ್ರು ಮತ್ತೇನಾಯ್ತು? ಮತ್ತೆ why there was a delay in till October?
10/10/2018, my lord, it was.
Reasons ಎಲ್ಲಿದೆ ರೀ?
Lord, he was not aware. One of the, my lord, brother was looking after the, my lord, case. That is one Shankrappa. My lord, he died, my lord, during the pendency of the appeal. My lord, the other appellants were, my lord, they were on the impression.
Issue notice. ನೋಡೋಣ, ಇನ್ನೊಂದು ಅಪೀಲ್ ಇದೆಯಲ್ಲ, ಅದರಿಂದ ನೋಟಿಸ್.
Oblige.
Notice on IA and also on main. 59 Jayakirti. 172 days in filing. Filing ಇದೆಯಾ? LRs ಇರ್ಬೇಕು ನೋಡಿ. LRs of deceased appellant. Heard on IA number 1 of, heard ಅಲ್ಲ, perused. On IA number 1 of 24 and there is a delay of 172 days, and also IA 2 of 24 is filed for setting aside the abatement, and IA 3 of 24 for bringing LRs of appellant, deceased appellant on record, and also on perusal of reasons assigned in the application of appropriate delays of 172 days is condoned and abatement is set aside and permitted to bring the LRs of appellant on record. Appellant counsel is directed to amend the cast title and file amended cast title within 2 weeks. Next. Recalling the order dated 24/2/22 and CD of 27 days in filing the application. Put it.
Cost paid, madam. Cost paid and office objection complaint.
ಏನಕ್ಕಿದೆ? Pending consideration ಅಂತ ಮಾಡಿದ್ವಾ? Counsel appearing for the appellant would submit that on pending this court-wide order dated 11/7/24. Directed to comply with office objections pending consideration of IA 1 of 22. And cost is also paid and complied alla? Complied, and in view of compliance, IAs are allowed. And order of dismissal dated 24/2/22 is recalled. The appeal is restored. Post the matter for admission. Abubakar Shafi.
Serial number 61 appeal for the appellant,
Filing,
my lord. Appellant, my lord.
Other side ಇದಾರಲ್ಲ, ಯಾರು? ಜಿ ಮಣಿವಣ್ಣನ್
ಇದಾರೆ
ಇಲ್ವಾ? ಕಾಪಿ
ಇದಾರೆ.
ಕಾಪಿ ಅವ್ರಿಗೆ ಜಾರಿಯಾಗಿದೆಯಾ?
Copy ಯಾವ್ದು online?
ಮೇಡಮ್ R428. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ಕಿಲ್ಲ ಅಂತಲ್ಲ, ಸರ್ವ್ ಮಾಡಿ ಕಾಪಿನ. The council.
ಮಾಡ್ತೇನೆ ಅಂದ್ರೆ ಅದ್ರಲ್ಲಿ
on the other side. Within 2 weeks. ಅಲ್ಲ, forthwith, and if any objections to be filed within 2 weeks. This matter up to 2 weeks. Chetana.
Please,
Notice on IA 1 of 24 and also on main. Next.
46 days. 46 days of delay in filing the appeal, my lord. 46 days.
Notice order ಮಾಡಿದ್ನಲ್ರಿ?
Please.
ಯಾವುದು?
46 days.
Notice ordered. Next. Chandrasekhar Pathard. GB Shastri. Dismissed. Exhibit D1. Cross examination.
Lower court records.
Discussed, confirmed. Yes, madam.
It is await lower court records. It was lower court records were called for actually last time. I have already filed the list of seniority.
ಯಾರು early hearing ಒಂದು ಹಾಕಿದ್ರೆ not pressed by the both the.
It was filed by me earlier.
ಅಲ್ಲ, both TCRs called and awaited ಅಂತಿದೆ. ಬಂದಿಲ್ಲ ತೋಳಿ.
In the meantime, I have filed the list of senior members of the seniority as your lordship had requested.
ಏನ್ seniority?
Seniority
Records
list of
ಕಾಲ್ಫರ್ ಮಾಡಿದೀವಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ. ತೋಳಿ. This court with order dated 12/7 ಅಲ್ಲ ಮೇಡಮ್, ಬಂದಿದೆಯಾ? ತೋಳಿ. So the records are called and not received, and hence registry is directed to issue the reminder and list this matter up to 2
My
weeks.
stay application is pending, your lordship. Execution.
Pathard is released. 2 ವಾರ ಆದ್ಮೇಲೆ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಅಷ್ಟೊಳ್ಳೆ ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ರೆ. 64. Keep both parties present. ಏನಾಯ್ತು ರೀ? ಕೆ ಪ್ರಸನ್ನ ಶೆಟ್ಟಿ, ಶಶಿಕಾಂತ್ ಪ್ರಸಾದ್, ಏನಾಯ್ತು?
Appellant is before the court.
ಏನಾಯ್ತು
ಅಪಲೆಂಟ್
settlement?
ಇಸ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್
ಹಾ?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಹೌಸ್ ಪ್ರಾಪರ್ಟಿ ಅವರೊಂದು ಗಿಫ್ಟ್ ಡೀಡ್ ಅಲ್ಲಿ ಇವರಿಗೆ ಬರ್ದು ಕೊಡಿ ಅಂತ ಅವ್ರ ತಂದೆ ಗಿಫ್ಟ್ ಡೀಡ್ ಬರ್ದು ಕೊಟ್ಟಿದ್ರು
ಓ, ಅದೇನೋ ಗೊತ್ತಾಯ್ತು ಹಳೆದ್ರಲ್ಲಿ ಏನೋ
ದೇ
ಬರ್ದಿದ್ರು ಅಂತ.
ರಿಸೈಡಿಂಗ್ ಇನ್ ದಿ ಹೌಸ್ ಸಿನ್ಸ್ 2003 ಇಂದ ಮನೆ ಕಟ್ಕೊಂಡು ಅಲ್ಲೇ ವಾಸ ಇದ್ದಾರೆ.
ಆಯ್ತು
ಈಗ ಇವರೇನೋ ದುಡ್ಡು
ಅದೇನೋ
ಕೊಡ್ಲಿಕ್ಕೆ
last
ready
time
ಇದ್ದಾರೆ,
ಎಲ್ಲ
but-
ಹೇಳಿದ್ವಲ್ಲ
ಹೌದು
ಏನು?
ಹೌದು
ಇಬ್ರು ನಿಮ್ ಪಾರ್ಟಿ ಬಂದಿಲ್ಲ ತಗೊಳ್ಳಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ ಪಾರ್ಟಿ ಇಸ್ ನಾಟ್ ಪ್ರೆಸೆಂಟ್.
Appellant is
ಪಾರ್ಟಿ
present.
ಏನಾಯ್ತು ಅವ್ನಿಗೆ ಏನಾಯ್ತು?
ಇವರು
Counsel submits that the respondent is not keeping well and hence could not keep him present before the court. And keep both the parties. ಯಾವಾಗ ಇದು ಹೊಸದಲ್ಲ ಇದು ಇನ್ನು 2024 ಏನ್ ಮಾಡ್ಬೇಕು? ಪಾರ್ಟ್ ಇದೆ
ಹೌದು
ರಿಲೀಸ್ ಮಾಡೋಣ ಅಥವಾ ಏನು? ಪಾರ್ಟ್ ರಿಲೀಸ್ ಮಾಡೋಣ ಏನು?
ನಮ್ಮ ಮುಂದೆ ಇದ್ರು
ಅವ್ರು ಹೇಳ್ಬೇಕು, ನೀವು ಹೇಳ್ಬೇಕ್ರಿ ನಿಮ್ ಪಾರ್ಟಿ ಬಂದಿಲ್ಲ ಕೋರ್ಟ್ಗೆ. ಏನು ಎಲಿಮೆಂಟ್ ಆಫ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಇದೆಯೋ ಇಲ್ವೋ? ಎಲಿಮೆಂಟ್ ಆಫ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಇದೆಯೋ ಇಲ್ವೋ? ನಿಮ್ಮ ಪಾರ್ಟಿ ನಿಮ್ ಮಾತು ಕೇಳ್ತಾ ಇಲ್ವಾ? ಆಯ್ತು ಬಿಟ್ಬಿಡೋಣ. Could not be keep the present before the court and hence list the matter after 2 weeks. Release from parted.
ಇವ್ರು ಹೋಗಿ ಮಾತಾಡಿದಾರೆ, ಅಮೌಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದಾರೆ. ಇವ್ರು ಹೋಗಿ ಮಾತಾಡ್ಲಿಕ್ಕೆ ಅಮೌಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದಾರೆ.
ಅವ್ರ ಪಾರ್ಟಿ ಏನೋ ರೆಡಿ ಇಲ್ಲ ಅಂತಲ್ಲ. ಏನ್ ಅಮೌಂಟ್ ಕೊಡ್ಬೇಕು?
ಸೆನ್ಸ್
ವ್ಯಾಲ್ಯೂ
10 cents ಆಫ್ ಲ್ಯಾಂಡ್ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರೇನ ಮನೆ ಎಲ್ಲ ಕಟ್ಕೊಂಡಿದಾರಂತಲ್ರಿ ಅರ್ಲಿಯರ್ ಇದ್ರ ಪ್ರಕಾರ. ಗಿಫ್ಟ್ ಮಾಡಿದಾಗ ಏನೋ ಅವರಿಗೆ ಬರ್ಕೊಡ್ಬೇಕು ಅಂತೆಲ್ಲ ಬರ್ದವ್ರಂತಲ್ಲ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ. ಏನ್ ವ್ಯಾಲ್ಯೂ ಇದೆ ಮಾತನಾಡ್ತಾರೆ ಕೊಡ್ತಾರ ಅಷ್ಟೇನೆ. ಬಟ್ ಅವ್ರೇನ ಅವ್ರ ಪಾರ್ಟಿ ಬರ್ತಾ ಇಲ್ಲ, ಇಂಟ್ರೆಸ್ಟ್ ತೋರಿಸ್ತಾ ಇಲ್ಲ ಅಂತ ಏನ್ ಅಂತಾರಲ್ಲ ಅವರು. ನೆಕ್ಸ್ಟ್ ಬೆಂಚ್ ಮುಂದೆ ಟ್ರೈ ಮಾಡಿ ಇನ್ನೊಂದ್ಸರಿ.
ಇಟ್ ಮೇ ಬಿ ಕಾಲ್ಡ್ ಅಪ್ 2 weeks.
ಅದೇ ಮಾಡಿ ಕಾಲ್ ಅಪ್ ಟು 2 weeks. Release from parted. Next. Non-compliance of order dated 26/24. What is that order?
To produce the original of all the documents in lordship. So I produced the original of the verifying affidavits of the attesting witness.
You have already produced.
Yes, your lordship. Original of death
Here is
certificate
those
is
documents.
original of death
Directed to
certificate.
produce the original of the documents. The counsel Sri Lakshmi Shah submits that he has not filed wakalat in this case, but office has shown his name in the cause list. It is noticed that respondent is nil. Hence, registry is directed. Board branch is directed to verify the records before the posting the matter and not to repeat the same in future. ಏನು ಮಾಡಿದೀವಲ್ರಿ ಮೇಡಮ್? ರೆಕಾರ್ಡ್ಸ್ ವೆರಿಫೈ ಮಾಡಿ ಅಂತ. Directed to verify the records before posting the matter and not to repeat the same in future. ನಮ್ಮ ಮುಂದೆ ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ? ನೀವು ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಇರೋದಾ?
Yes, lordship. It has to be posted for evidence, for inquiry.
ಎನ್ಕ್ವೈರಿಗೆ ಆಲ್ರೆಡಿ ಇದೆ ಅಲ್ವಾ? ಸೇಫ್ ಕಸ್ಟಡಿ ತಗೊಳ್ಳಿ. The original documents which have been produced before the court ordered to be kept in safe custody.
Very.
And post the matter for inquiry.
On the 5th of August, your lordship, the witness.
5th of August.
Great.
Before ಮುಂದೆ ಇವ್ರ ಮುಂದೆ CPC ಮುಂದೆ ಹೋಗುತ್ತೇನಾ? Before CPC. ವಿಶ್ವನಾಥ್ ವಿಶ್ವಜಿತ್ ರೈ ಹೇಳಿ.
In this case, I appear for this.
ನೀವೀಗೇನು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಗ್ತಾ ಇದ್ದೀರಾ? The counsel for the respondent filed objections to the IA 1 of 2024. ರಿಟ್ ಬೇರೆ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? ರಿಟ್ ಬೇರೆ ಪೆಂಡಿಂಗ್ ಇದೆ.
Our back and we have not been issued with the notice. Therefore, that is being challenged. After receipt of the copy of the order, I have filed the writ petition before.
ಆಯ್ತು, ರಿಟ್ಟು RSA ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳಿ ಬಿಡಿ, ಒಟ್ಟಿಗೆ ಹಾಕೋಣ. If it is same belongs to the same property ಆಗಿದ್ರೆ.
After disposal of the writ, it could be considered because their main contention is that they have to appeal to owner.
ರಿಟ್ ಅಲ್ಲಿ ಏನ್ ಸ್ಟೇ ಆಗಿದೆ ರೀ?
Now what?
That order, filing or order, there is a very specific direction, not to dispose of the order ಮಾಡಿದ್ದಾರೆ.
ಯಾರು?
This one, I have produced the copy of the website.
ಅದೇ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ. ನಾಟ್ ಟು ಡಿಸ್ಪೋಸೆಸ್. ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ನಾಟ್ ಟು ಡಿಸ್ಪೋಸೆಸ್ ಆರ್ಡರ್ ಮಾಡೋದ್ರಿ. ಬಟ್ ಇಲ್ಲಿ ಸೂಟ್ ಇರೋ ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಇಂಜಂಕ್ಷನ್ ಇದೆಯಲ್ಲ, ಇದೆಯಲ್ಲ.
Declaration ಅಲ್ಲ, permanent injunction. It is not a suit for declaration, my lord. Permanent injunction and
Only for injunction
and mandatory injunction. Yes.
Dismissed and confirmed.
Yeah, dismissed and confirmed by both the courts will.
ಆಯ್ತು.
Against that,
ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಆರ್ಡರ್ ಇದೆಯಾ?
ಇಲ್ಲ, last time ನೀವು records call for ಮಾಡಿದಿರಿ. Records ಬಂದಿದೆ.
ಬಂದಿದೆ.
ಹೌದು. So it is being posted for admission.
ಅಲ್ಲ ಈಗ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇಂಜಂಕ್ಷನ್ ಕೊಟ್ಟವ್ರೆ ಅಂತಾರಲ್ಲ ಅವರು.
The additional document which I have produced.
Sought the stay of the tribunal order. Now he has told that.
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಅಂತಿದೆ.
Please, my lord.
ಇಲ್ಲೂ ಆರ್ಡರ್ ಇದೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆರ್ ಡೈರೆಕ್ಟೆಡ್ ನಾಟ್ ಟು ಡಿಸ್ಪೋಸೆಸ್ ದ ಪಿಟಿಷನರ್ ಫ್ರಮ್ ದಿ ಸಬ್ಜೆಕ್ಟ್ ಲ್ಯಾಂಡ್ ಟಿಲ್ ದಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಂತಿದೆ. ಆಮೇಲೆ ಡೇಟ್ ಬರಲೇ ಅಲ್ವಾ? 10/7 ಮೊನ್ನೆ ಆಗಿರೋದು ಇದು.
ಅದ್ ಮೊನ್ನೆ ಅಂದ್ರೆ
ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ RSA ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳಿಲ್ವಾ?
It is stated in the.
Itself.
ಹೇಳ್ಬೇಕಿತ್ತು, ಬಟ್
Notice was.
ಅದಿದೆ. I don't dispute man.
List after 2 weeks ನೀವೇನಾದ್ರು ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ.
ಅಲ್ಲ, what happens is my lord, formally admit ಮಾಡಿ.
ಏನ್ ಫಾರ್ಮಲ್ ಅಡ್ಮಿಟ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ.
ಇಲ್ಲದ ಒಟ್ಟಿಗೆ ಅದು ರಿಟ್ ಅಲ್ಲಿ ಇನ್ನು ಯಾವಾಗ ಬರುತ್ತೆ ರಿಟ್ ಪಿಟಿಷನ್.
ನೀವು ಮೂವ್ ಮಾಡ್ಕೋಬೇಕು.
ಯಾಕಂದ್ರೆ this
ಆರ್ಡರ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಡೈರೆಕ್ಟೆಡ್ ನಾಟ್ ಟು ಡಿಸ್ಪೋಸ್
yes, this writ was filed my lord after
next date of hearing. ನೀವು ರಿಟ್ ಫಸ್ಟ್ ಇದನ್ನ ವೆಕೇಟ್ ಮಾಡಿಸ್ಕೋಬೇಕು ಈ ಆರ್ಡರ್ ನ.
the writ was filed after I produced the judgment.
ಆಯ್ತು, ಈಗ ರೀಸೆಂಟ್ ಆಗಿ ಹಾಕಿರೋದು ರಿಟ್ ಆಫ್ 2024.
yes 24 ನೋಟಿಸ್ ಆಗಿಲ್ಲ ನಮ್ಗೆ.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂತ ಈಗ ಆಗಿದೆ. ಈಗ ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್
Receive agreed.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 129 ಅಂತ ಆಗಿದೆ. ಗವರ್ಮೆಂಟ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಫಾರ್ R1 and 2. ಇಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ.
ವೆರಿ ವೆಲ್.
ವೆಕೇಟ್ ಕೇಳಿ ಅಲ್ಲಿ ನೋಡಿ. ತಗೊಳ್ಳಿ. ದ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಲ್ಸೋ ಫೈಲ್ಡ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಟು ದಿ IA number 1 of 24. List after 2 weeks.
Grateful.
Manjunatha HR, Nischal Dev,
I appeal for appellant.
partly declared allowed in part.
Kindly pass on. Kindly pass on.
ಪಾಸ್ ಓವರ್ ಎಲ್ಲ ಇಲ್ಲ ಮೇಡಮ್. ಎಷ್ಟು ಮ್ಯಾಟರ್ ಇದೆ ನೋಡಿದೀರಾ? 1.5 ಒಳಗೆ ರೀಚ್ ಆಗಲ್ಲ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ರೆ.
26.
ಡೇಟ್ ಬೇಕಾ ಕೊಡ್ತೀನಿ.
Date may be.
ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 time list this matter up to 2 weeks. 130 ಮ್ಯಾಟರ್ಸ್ ಇದೆ. ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಮುಗಿಸ್ಬೇಕು. 68 RBS partly declared 1/3 limitation section 5 of limitation act dismissed. ಇಲ್ವಾ? ತೋಳಿ. Appellant counsel not yet filed an application to bring the LRs and finally another 2 weeks time granted to bring the LRs. Next. Letter dated from the Karnataka Mediation Center, Bangalore stating not settled. Ilwa ibruno? S. Vishwaraya, Varadarajan, ibru illa. Both Varadarajan idaralri ille? D. Vishwaraya. Appellant counsel absent, respondent counsel present, list up to 2 weeks.
May it please.
Dhanalakshmi Somanatha,
May it please, Your Worship.
declared owner not
1,000 rupees cost we have paid, my lords.
ಕಾಸ್ಟ್ ಹಾಕಿತ್ತ ಏನಕ್ಕೆ?
ನಾವು ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇಗೆ ಅರ್ಜಿ ಹಾಕಿದ್ವಿ. ಅದ್ರ ಮೇಲೆ ಈಗ
ಅಡ್ಮಿಷನ್ ಮುನಿಯಪ್ಪ ಹೇಳಿ.
my lords, this is a case where OS 7
as owner
my lords, OS 71 of 2007
not binding compromise ಅಂತ
compromise not binding ಅಂತ ಕೇಳಿದ್ದಾರೆ. OS was decreed and then ARIA was also decreed. Concurrent findings we are before your lordship. Lordship may kindly come to first page, my lords, page 5. ಅದರಲ್ಲಿ ಇದೆ ಲಾಸ್ಟ್ ಟೈಮ್ ತಮ್ಗೆ ಸ್ವಲ್ಪ ಹೇಳಿತ್ತು. ಪೇಜ್ 5 ಅಲ್ಲಿ ಇದೆ, ತಾವು ಗಮನಿಸಬಹುದು. ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇದೆ, ಲಿಂಗಮ್ಮ ಅಂಡ್ ಚಂದ್ರಕಲಾ ಅಂಡ್ ಸುಗುಣ ಆರ್ ಮದರ್ ಅಂಡ್ ಡಾಟರ್ಸ್.
ಮದರ್ ಅಂಡ್ ಡಾಟರ್ಸ್.
ಮದರ್ ಅಂಡ್ ಡಾಟರ್ಸ್. ರೆಸ್ಪಾಂಡೆಂಟ್ ಇನ್ ಪೇಜ್ 6 ಇದೆ ಸಿದ್ದರಾಮಯ್ಯ ಅಂತ ಹೇಳಿ. ಸಿದ್ದರಾಮಯ್ಯ ಅನ್ನೋರು ಗಂಡ, ಲಿಂಗಮ್ಮನ ಗಂಡ. ಅಂದ್ರೆ ಗಂಡನ ಮೇಲೆ ಹೆಂಡತಿ ಮತ್ತೆ ಮಕ್ಕಳಿಬ್ರು ಮೊದ್ಲು ಒಂದು ಕೇಸ್ ಹಾಕಿದ್ರು.
ಫಸ್ಟ್ ಪ್ಲೇಂಟ್ ಇವರು ಪ್ಲೇಂಟಿಫ್.
ಪ್ಲೇಂಟಿಫ್ ಇಸ್ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, ರಾಮಕೃಷ್ಣ ಅನ್ನೋರು. ಇವ್ರು ಯಾರು ಅಂತಂದ್ರೆ ಗಂಡನ ಅಣ್ಣನ ಮಗ. ಐ ವಿಲ್ ಪಾಸ್ ಆನ್ ದಿ ಜೀನಿಯಾಲಜಿಕಲ್ ಟ್ರೀ. ಗಂಡನ ಅಣ್ಣನ ಮಗ. He claims to have purchased, ಸ್ವಾಮಿ ದಯವಿಟ್ಟು, he claims to have purchased these properties. P miss ಹಾಕ್ದಾಗ್ಲೇನೆ P miss ಹಾಕಿದ್ವಿ, ಆಮೇಲೆ OS ಆಯ್ತು. OS ಅಲ್ಲಿ ಚಾರ್ಜ್ ಕ್ರಿಯೇಟ್ ಆಗಿತ್ತು ನಮ್ಮ ಫೇವರ್ ಅಲ್ಲಿ, ಬಿಕಾಸ್ ಇಟ್ ವಾಸ್ ಫಾರ್ ಮೇಂಟೆನೆನ್ಸ್. ದೆನ್ ವಾಟ್ ಹ್ಯಾಪನ್ಡ್ ವಾಸ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ವಿ. P miss ಅಲ್ಲಿ OS ಅಲ್ಲಿ he remained absent. My husband remained absent. In execution petition he comes there is a compromise decree. Now OS
compromise between husband and the wife and children.
ಹೌದು. ಅದರಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ there is a finding that the charge is created over dash dash ಅಂತೆಲ್ಲ ಇದೆ.
ಯಾವ್ಯಾವ ಪ್ರಾಪರ್ಟಿಗೆ ಅಂತ
ಎಲ್ಲ ಇದೆ. Now, my lords, after we got everything done in the execution petition, now the
in
husband,
terms of compromise.
ಹೌದು. Now husband's brother has filed this independent, brother's son, that is Ram Krishna. He claims to have purchased it under various sale deeds from, ನಾನ್ ನಿಮ್ಗೆ genealogical tree ಕೊಟ್ಟೆ ತಾವು
ಯಾರಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದಾನೆ ಅವನು?
ಅವರು ನಮ್ಮ ಹಸ್ಬೆಂಡ್ ಇಂದಾನು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ. The details of the various sale deeds are here. He claims to have purchased from different persons. ಅಂದ್ರೆ ನಮ್ಮ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಹತ್ರನೇ. ಅವ್ರು ಯಾರನ್ನೂ ಅವ್ರು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. Kindly see my lords this.
ಆಯ್ತು, ನಿಮ್ಮ ಹಸ್ಬೆಂಡ್ once he had compromised the matter, the respect of some of the properties, how can he sell that property?
His claim, that's what we say, but his claim is that, the other side claim is that, ನೀವು ಕಾಂಪ್ರಮೈಸ್ ಆಗಕ್ ಮುಂಚೆನೆ ನನಗೆ ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರು 97, ನಾವು 97
ಸೇಲ್ ಆಗಿದೆಯಾ
ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. 97 ಅಲ್ಲಿ ನಾವು ಸೂಟ್ ಹಾಕಿದ್ಮೇಲೆ ಒಂದನ್ನ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ಸ್ ಒನ್ ಆಸ್ಪೆಕ್ಟ್. ನಾವು ಅನದರ್ ಆಸ್ಪೆಕ್ಟ್ ಇಸ್ ಹ್ಯಾಸ್ ಪರ್ಚೇಸ್ ಫ್ರಮ್ ಆ ಜಿನಿಯಾಲಜಿಕಲ್ ಟ್ರೀ ನಲ್ಲಿ ಇದೆ, ತಾವು ಗಮನಿಸಬಹುದು. ಮರಿಗೌಡ ಮಕ್ಕಳುಗಳೆಲ್ಲರ ಕಂಡೇನೋ ಬೇರೆ ಬೇರೆಯವರಿಂದ ಸೇಲ್ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ. ಮೈ ಜಸ್ಟ್ ಪಾಸ್ ಆನ್ ದಿಸ್ ಮೆಲರ್ಸ್ ಟು ಗಿವ್ ಮೈ respectful submission is twofold. One is that the suit itself was not maintainable because Trilokinath ಆಮೇಲೆ ನಮ್ಮ ಕೋರ್ಟ್ ಮೂರು ಜಡ್ಜಸ್ ಸಿಂಗಲ್ ಬೆಂಚ್ ಮೂರು ಜಡ್ಜಸ್ ಹೇಳಿದ್ದಾರೆ, it has to be when you are claiming right through the person who has entered into compromise, then it cannot be by an independent suit. That's one respectful submission.
Whether the plaintiff is a party to that compromise?
Plaintiff was not a party,
No,
but
then
ಅಲ್ಲ plaintiff not a party ಅಂದ್ರೆ ಅದಕ್ಕೆ ತ್ರಿಲೋಕಿನಾಥ್.
whether the plaintiff is a party to the said compromise, ಇಲ್ಲ.
He was not a party.
Then he can file an independent suit.
ಇಲ್ಲ, ಅದನ್ನ ಡಿಸ್ಟಿಂಗ್ವಿಶ್ ಮಾಡಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ದಯವಿಟ್ಟು with due respects my lords, three different, one court has taken a different view, but all the other two benches here and then Trilokinath's case, they
If
say
they are the parties, if they are challenging the very compromise, then they have to initiate the proceedings in the very same proceedings.
ಹೌದು.
If they are not parties, they can maintain a independent suit. That is the law.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಸ್ವಲ್ಪ ಡಿಸ್ಟಿಂಗ್ವಿಶ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ತ್ರಿಲೋಕಿನಾಥ್ ಅಲ್ಲಿ
ಅವನ್ ಪಾರ್ಟಿ ಇಲ್ದವ್ರು how can he go to the very same court?
ಅಲ್ಲ, ಅದನ್ನೇ if you are claiming through the same person, you have to do it ಅಂತ.
Claiming through.
Claiming through the person who was a party in the
Well, if the sale, if for example the vendor is party to him anta,
ಅದನ್ನೇ ಎಲ್ಲ ಕೋರ್ಟ್ಸ್ ಅಲ್ಲಿ ಆಮೇಲೆ
claiming through ಅದರ ಮಾತ್ರ.
ಹೌದು, ಅದಕ್ಕೆ ಜಸ್ಟಿಸ್ ಸಂಜಯ್ ಗೌಡ್ರದ್ದು
ಇಂಡಿಪೆಂಡೆಂಟ್ ರೈಟ್ ಇದ್ರೆ ಮಾಡಕ್ ಬರಲ್ಲ.
ಅದಕ್ಕೆ ಮೂರು
They have to file an independent suit.
ಹೌದು, ಜಸ್ಟಿಸ್ ಕೆ ನಟರಾಜನ್ ಸರ್ದು, ಆಮೇಲೆ ಜಸ್ಟಿಸ್ ಸಂಜಯ್ ಗೌಡ್ರ ಸರ್ದು, ಆಮೇಲೆ
ನಾನು ರೀಸೆಂಟ್ ಆಗಿ ಮೊನ್ನೆ ಮಾಡಿದೀನಿ ಅದಕ್ಕೆ.
ಸೊ ಇಫ್ ದಟ್ಸ್ ಒನ್ ಆಸ್ಪೆಕ್ಟ್. ಸೆಕೆಂಡ್ ಆಸ್ಪೆಕ್ಟ್ ಇಸ್ ರೋಹಿತ್ ಚೌಹಾನ್ಸ್ ಕೇಸ್ ತಮ್ಗೆ ಗೊತ್ತಿದೆ ಸ್ವಾಮಿ. This is all these people had right. So the our father's property. So independent ಆಗೋ ಆ ಹೆಣ್ಮಕ್ಳುಗಳಿಗೆ ಪಾರ್ಟಿ ಇತ್ತು. ವೈಫ್ ಗೆ ಚಾರ್ಜ್ ಮೇಂಟೆನೆನ್ಸ್ ಅಂತ ಅನ್ಕೊಂಡ್ರು ನಾವು ಒಂದ್ ವಿಧದಲ್ಲಿ.
Daughters are get the right.
ಹೌದು, ಇವ್ರು ಅವ್ರೊಬ್ರ ಹತ್ರ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಂಡು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. These were the critical aspects. All those aspects have not been considered.
Records ಬಂದಿದೆಯಾ? ಇಲ್ಲ. Call for records. List the matter immediately after receiving the records.
ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ
ಏನಾಗಿದೆ?
ಎರಡನೇ ಸಲ ಅವರು ಡಿಕ್ರಿನ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. ಕಾಂಪ್ರಮೈಸ್ ಡಿಕ್ರಿ ಇಸ್ ನಾಟ್ ಬೈಂಡಿಂಗ್ ಅಂತ ಇದಾಗಿದೆ.
ಈಗ ನೀವೇನ್ ಕೇಳಿದಿರಿ? ರಿಲೀಫ್ ಏನ್ ಕೇಳಿದಿರಿ?
ಸ್ಟೇ ಕೇಳಿದೀವಿ ಸ್ವಾಮಿ.
ಸ್ಟೇ ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಅಥವಾ ಏನು? ಫರ್ದರ್ ಎಲಿನೇಟ್.
ಹೌದು, 68 to 72 ನಲ್ಲಿ ಕೇಳಿದೀವಿ. 68 page 68 ಅಲ್ಲಿ we have sought for that.
ಸಾರಿ, ಕೊಡಿ ಮೇಡಮ್, ಜಿ ಟ್ರೀ ಕೊಡಿ.
ಸ್ಟೇ ದಿ ಆಪರೇಷನ್ ಅಂಡ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಂತ ಕೇಳಿದೀವಿ ಸರ್. 69 page 69 ಅಲ್ಲಿ ಸರ್. ಸ್ಟೇ ದಿ ಆಪರೇಷನ್ ಆಫ್
ಆಯ್ತು. ಈಗ ಪೊಸೆಷನ್ ಕೇಳಿದಾರ, ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಕೇಳಿದಾರ?
ನಾವ್ ಏನು ಕೇಳಿಲ್ಲ, ನಾವು ಕೇಳಿದ್ರು ಸ್ಟೇ ದಿ ಆಪರೇಷನ್
ಆಫ್ ದಿ
ಆಪರೇಷನ್ ಅಂಡ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ ಕೇಳಿದೀವಿ ಅಷ್ಟೇ.
ಜಡ್ಜ್ಮೆಂಟ್ ನ?
ಹೌದು, ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಗ್ರಿ ಅಷ್ಟೇ. ಅವ್ರ ಸ್ವಾಧೀನ, ನಾವು ಸ್ವಾಧೀನದಲ್ಲಿ ಇದೀವಿ.
ಪೊಸೆಷನ್ ಬಗ್ಗೆ ಅವ್ರೇನ್ ರಿಲೀಫ್ ಕೇಳ್ತಾ ಇಲ್ಲ. ಹೌದು, ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಬಾರ್ದು ಅಂತ ಅದ್ರ ಮೇಲೆ.
ಹೌದು, ನಾವು ಹೇಳಿದ್ವಿ ನಮ್ಗೆ ಹೆಂಡತಿ ಮಕ್ಕಳು ತೀರಾ ಕೇರ್ ಆಫ್ ಫುಟ್ಪಾತ್ ಆಗಿದಾರಕ್ಕೆ ಒಂದಷ್ಟು ಕೊಟ್ಬಿಡಿ ನಾವು.
Was there any interim order before the trial court, madam?
Pardon, ಇಲ್ಲ ಸ್ವಾಮಿ.
ಥ್ರೂ ಔಟ್ ಸೂಟ್ ಅಲ್ಲಿ ಏನಿಲ್ಲಲ್ಲ
ಇಲ್ಲಿ
ಅವ್ರ ಸೂಟ್ ಅಲ್ಲಿ ಹಾಕ್ದಾಗ ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರೇನಿಲ್ಲ.
ಇಲ್ಲಿ
ಆಯ್ತು ಬರ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ ಅದಾರ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
SQL ಫ್ರೇಮ್ ಮಾಡ್ಬಿಡ್ಬೋದು ಸ್ವಾಮಿ ತಾವು
ಏನಾಗೋದಿಲ್ಲ,
ಮಾಡ್ಬಿಟ್ರೆ admission
think
ಅಂತ ಆದ್ರೆ
ಹ್ಮ್.
ಪೂರ್ತಿ
You
ಕೇಸ್
are not enjoyed any interim relief throughout the original suit as well as in the first
ಅಲ್ಲ
appellate.
SQL ಫ್ರೇಮ್ ಮಾಡ್ಬಿಡ್ಬೋದು ಸ್ವಾಮಿ
ಹಾ?
ಸಬ್ಸ್ಟಾನ್ಶಿಯಲ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಫ್ರೇಮ್ ಮಾಡ್ಬಿಟ್ರೆ
Anyhow they have appeared. ರೆಕಾರ್ಡ್ ಬರ್ಲಿ ವಿಲ್
ಲಾಸ್ಟ್
ಫ್ರೇಮ್
ಟೈಮ್ ಹಂಗೆ
ಸಬ್ಸ್ಟಾಂಟಿವ್
ಆಯ್ತು
ಕ್ವೆಶ್ಚನ್ ಆಫ್
ಸ್ವಾಮಿ,
ಲಾ.
ಅದಕ್ಕೆ ದಯವಿಟ್ಟು
ರೆಕಾರ್ಡ್ ಬೇಕಲ್ಲ ಮತ್ತೆ
ನಾವು ಇದೆಲ್ಲ ಪೇಪರ್ ಬುಕ್ ಎಲ್ಲ
ಕನ್ಕರೆಂಟ್
ಹಾಕ್ಬಿಡ್ತೀವಿ.
ಪೆಂಡಿಂಗ್ ಇದೆಯಲ್ಲ ಮೇಡಮ್.
ಇದೆ ಅಂದ್ರೆ ಈ ದಿಸ್ ಆರ್ ದಿ crucial points which has to be gone through, my lords. That's where we are before your lordships. That's otherwise I wouldn't have.
ಕೊಡಿ ಮೇಡಮ್.
Immediately ನೆ ತಗೊಂಡ್ಬಿಡ್ಬೋದು ಯಾಕಂದ್ರೆ ಇನ್ ವ್ಯೂ ಆಫ್ ದಿ ಮೇಂಟೆನೆನ್ಸ್ ಇಶ್ಯೂಸ್ ಇರೋದ್ರಿಂದ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ತಾವು ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಡ್ಬೋದು ಡೇಟ್. That's where I am requesting. Otherwise I wouldn't have. Charge was created in lieu of maintenance, my lords.
How to the appellant counsel and also the counsel appearing for the respondent.
Substantial question of law that we have framed is at page 15. my lords.
Earlier suit ಯಾವ್ದು ಕಾಂಪ್ರಮೈಸ್?
ಅದರಲ್ಲೇ ಬರ್ದೀನಿ ಸ್ವಾಮಿ, ಪೇಜ್ 15 ಅಲ್ಲದೆ OS 107.
ಹಾ?
OS 107 minutes.
107
Plaint ಕೊಟ್ಬಿಡಿ.
92. ಆಮೇಲೆ ನಾವು ಕಾಂಪ್ರಮೈಸ್ ಆದ್ಮೇಲೆ ಏನೋ ಒಂದ್ ಕೊಂಡ್ಕೊಂಡಿದ್ದೀರ.
98 ಅಲ್ಲಿ ಒಂದ್ಕೊಂಡಿದ್ದಾರೆ.
Prior to ಇದು stated ಆಗಿರೋದು 1980 stated ಆಗಿರೋದನ್ನ subsequent purchases we have purchased the land.
But earlier there was a sale in favor of the your vendor.
ನಮ್ದು ಅಲ್ಲ ಲಿಸ್ಟ್ ಆಫ್ ಸೇಲ್ ಡೀಡ್ಸ್ ಕೊಟ್ಟಿದೀವಿ ನಾವು. ಲಿಸ್ಟ್ ಆಫ್ ಸೇಲ್ ಡೀಡ್ಸ್
ಕೊಡಿ ಎಲ್ಲಿ ಕೊಡಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಿ ನೋಡಿ.
ಲಿಸ್ಟ್ ಆಫ್ ಸೇಲ್ ಡೀಡ್ಸ್ ಕೊಡಿ.
If already sold in the year 1980, madam.
ಅಲ್ಲ they have
How can your husband can enter into a compromise in respect of the property which
That's
was
where,
sold
my lords,
earlier?
it is not just through one kindly see, my lords, he has purchased from different people and there is an admission by Lakshmamma.
Even
the
if
mother,
it is
that
different person also, if already property was sold by your husband prior to this compromise.
ಇಲ್ಲ, from all of them, from different persons he has purchased. And Lakshmamma says,
Exhibit
ಪಾಲುಪಟ್ಟಿನಲ್ಲಿ ನಮ್ಮವ್ರು
P1 sale date dated 22/9/1999. ನಿಮ್ ಸೂಟ್ ಯಾವ ಇಯರ್ ಮೇಡಮ್? Earlier suit compromise date ಯಾವಾಗ?
ಅಲ್ಲ, P-miss was filed on 9/7/97.
97 P-miss.
ಹೌದು.
ಆಯ್ತು.
Sale deed entered into in respect of survey number 109 was 23/3/98.
Question is what was the date of compromise between the husband and wife and children?
That was 19/2007.
19/2007 is this compromise.
ಹೌದು.
ಹೌದಾ?
Judgment passed was 7/10/2003. OS ಅಲ್ಲಿ.
ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್?
OS ನಾವು ಹಾಕಿದ್ವಲ್ಲ ಸ್ವಾಮಿ, P-miss OS ಆಗಿ ಕನ್ವರ್ಟ್ ಆಯ್ತಲ್ಲ ಅದು. P-miss 12 of 97.
ಕಾಂಪ್ರಮೈಸ್ ಯಾವ್ದ್ರಲ್ಲಿ ಆಗಿದ್ದು?
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ.
ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರೋದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲ.
ಹೌದು. OS ಅಲ್ಲಿ ಪರವಾಗಿ ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತು. There was a clear judgment
ಇತ್ತು, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಯ್ತು.
ಹೌದು.
ಆಯ್ತು. ಸೂಟ್ ನಿಮ್ ಪರವಾಗಿ ಡಿಕ್ರಿ ಆಗಿದ್ದೆ ಅವಾಗ?
Suit was decreed on 7/10/2003, my lords.
2003 ಅಲ್ಲಿ.
ಹೌದು.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಇನ್ 2007.
Execution filed in 2004 but compromise on 2007.
ಅದೇ 19/2007.
ಹೌದು.
ಹೌದಾ?
P-miss ಅಲ್ಲಿ ನಾವು ಹಾಕಿದ್ದು 9/7/97. His sale in respect of one of the survey numbers is on 23/3/98. ನಾವು ಕೇಸ್ ಹಾಕಿದ್ಮೇಲೆ ತಗೊಂಡಿದ್ದಾರೆ.
ಯಾರಿಂದ ಕೊಂಡ್ಕೊಂಡಿದ್ದಾರೆ?
ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು
ಅದೇ ಯಾರಿಂದ?
ಶಿವಲಿಂಗಮ್ಮ ರಾಜು ಸಿದ್ದರಾಮಯ್ಯ ಗೌಡ.
ಆಯ್ತು. ಈ ಶಿವಲಿಂಗಮ್ಮ ರಾಜು ವೈಫ್ ಅಂಡ್ ಸನ್ ಆಫ್ ಮರಿಗೌಡ ಇವ್ರು ಯಾವಾಗ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ? ಯಾರಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ ಅವರು?
Suit for declaration without bringing any of these persons as parties, he has simply filed the suit.
Whatever it may be, when there was already a sale in the year 1980 to the vendors of the respondent.
ಇಲ್ಲ. They say, my lords, this is 1980 sale deed is not produced here. It is 1998 sale deed they have
But
produced.
your husband has not sold the property
Yes,
subsequent to the file. ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿ?
98 ಅಲ್ಲಿ 23/3/98.
98 ಅಲ್ಲಿ.
98 ಅಲ್ಲಿ. After filing of the suit, he has sold one property. Before that, he has sold many properties.
ಅದೇ ಯಾವ್ದು?
ರೋಹಿತ್ ಚೌಹಾಣ್
ಕಾಂಪ್ರಮೈಸ್ ಆದ್ಮೇಲೆ ಯಾವ್ದಾದ್ರು ಸೇಲ್ ಮಾಡಿದಾರ ಮೇಡಮ್?
ಕಾಂಪ್ರಮೈಸ್ ಆದ್ಮೇಲೆ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಕೇಸ್ ಹಾಕದ್ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ ಒಂದು. ಕಾಂಪ್ರಮೈಸ್ ಮುಂಚೆ ಮಾಡಿದ್ದಾರೆ ಅಂತಲೂ ಇಟ್ಕೊಳ್ಳೋಣ, ಸೂಟ್ ಹಾಕಕ್ ಮುಂಚೆ ಮಾಡಿದ್ದಾರೆ ಅಂತಲೂ ಇಟ್ಕೊಳ್ಳೋಣ. Based on Rohit Chauhan's judgment, the moment a child is born, he can't be sending my rights also.
What was the
There are
nature
two
of the
children.
property?
Pardon, minutes?
What was the nature of the property, whether an ancestral
It
property
was
or
an ancestral
self-acquired
property. He is also brother's son. My husband's brother's son has taken. Now, our rights, one is my birthright as far as the two children are curtailed. One is wife's right as far as the charge that is created over the property is disturbed. And the second thing that I would like to most humbly submit here is that the husband couldn't have got the compromise deed not binding. And that's where the Supreme Court has also said it can't be taken as not binding ಅಂತ ಕೇಳಕ್ ಬರೋದಿಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. 4 decisions are here, my lords. ಅದು ತಮ್ಗೆ ಈ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬೇಡ ಅಂತ ಅನ್ಕೊಂಡೆ ನಾನು.
What is the finding of trial court?
ಅದೇ ಇದು
Any
compromise
finding that property is an ancestral property ಅಂತ?
ಆತರ ಏನ್ ಹೇಳಿಲ್ಲ. But
when he filed the suit,
he filed the suit
challenging only the judgment and decree.
ಹೌದು, ನಮ್ಮ ಹತ್ರ plaint ಇದೆ ಸ್ವಾಮಿ, plaint.
What is his claim?
My lords, your lordship may kindly
Before
say.
challenging the judgment and decree, there must be a
Plaint
pleading.
copy can I pass on, my lords? Copy of-
Judgment and decree dated 7/10/2013 passed in OS number 107 obtained by
Okay,
defendant number 112 is null and void and same is not binding on him so far as it relates to plain scheduled properties. Whether the plaintiff further proves that the compromise dated between the defendants is null and void as the same not binding on the plaintiff so far as the plain scheduled properties is concerned.
Schedule ಕೊಡಿ. Sale dates notes ಮಾಡಿ.
Absolute owner in lawful possession of the suitable property. ಅದಕ್ಕೆ issue number 3 answer in the affirmative.
ಹೌದು.
Why the trial court comes to the conclusion that he is the absolute owner anta?
Because of the sale deeds. Because of
Sale
the
deed.
sale deeds ಅಲ್ಲಿ.
ಈಗಿನ ಸೇಲ್ ಡೀಡ್ ಪ್ರಕಾರ.
ಹೌದು, ಅವ್ರ ಸೇಲ್ ಡೀಡ್ ಇದೆ ಅವ್ರಿಗೆ. We are not telling that he doesn't have a sale deed. The question is when he files a suit for declaration, when he claims to have purchased from several persons of my husband's family, that's my grandfather's family, the suit for declaration ought to have been filed in a manner known in law, number 1 submission. The second submission would be my husband could not have alienated my shares. That is the children's share is another based on Rohit Chauhan's judgment. Third one is the suit to set aside compromise decree is not at all maintainable and he should have filed in the very same suit itself. He can't be filing here. If he files an independent suit, and there is an
Is it
admission.
your contention in the written statement that the property belongs to the giant family property and they cannot sell the property belongs to the
ಇಲ್ಲ ಅದ್
dependents?
ಅದನ್ನ ಹೇಳಿಲ್ಲ. ಅದನ್ನ ಹೇಳಿಲ್ಲ.
But ಅದ್ ಕೇಳಿಲ್ಲ ಅಂದ್ರೆ ನೀವ್ ಹೆಂಗ್ RSL ಹೆಂಗ್ ಆ ಪಾಯಿಂಟ್ ನ ರೈಸ್ ಮಾಡಕ್ ಆಗುತ್ತೆ?
My lords, the question here is my rights, legal rights cannot be disturbed in a suit.
You would have pleaded the same in the trial court.
Which is filed for disturbing the compromise decree alone.
For the first time, I think you are raising that ground in the second appeal.
That may be one of the things, my lords. The second thing is I'm even let us assume that I'm not urging on that out. In a suit filed for setting aside the compromise decree, my lords, may I just pass on 3 judgments, my lords, which are straight away on the point. Good evening.
Heard the appellant counsel and also the counsel appearing for the respondent and counsel appearing for the appellant would submit that the respondent cannot file an independent suit seeking the relief of setting aside the judgment and decree passed in OS number 107 of 2001 when the respondent is claiming through the right of the party who was a party in the earlier suit in OS number 107 of 2001 and also contend that the rights of the parties cannot be defeated by granting the relief of declaration without ascertaining the rights of the appellants who are also entitled for a share in the suit scheduled property. The council also would vehemently contend that the court below committed an error in declaring that decree in OS number 107 of 2001 and also the compromise in the execution petition for 13 of 2004 are not binding is not correct. And hence matter requires reconsideration. Per contra, the counsel appearing for the respondent would contend that sale deeds are executed in the year 1999, 92, 95, 98, even prior to filing of the PMIS.
Was filed in 97 minutes, one property.
And also the decree is dated 7/10/2003. Prior to that, already all properties were purchased by the respondent, and hence the same is taken note of by the trial court as well as the first appellate court. In reply to the argument, counsel would submit that PMIS was filed on 9/7/1997 and one of the property was sold, that is exhibit P4 on 23/3/1998 subsequent to the filing of PMIS. And if rights of the parties are defeated, the earlier also suit is filed against the husband by the wife and daughter. And the interest of the appellant is prejudiced in view of granting of the judgment and decree. Having heard the appellant counsel and also the counsel appearing for the respondent, and also it is not in dispute earlier, the appellants have filed a suit in OS number 107 of 2001. And prior to that, they have filed the PMIS on 9/7/1997. And subsequent to the filing of PMIS also, one of the property was sold, that is in terms of exhibit P4. And also the decree was passed in 2003, and thereafter execution petition was also filed wherein compromise was entered between the parties. Having urged the ground that when the respondent is claiming the right through the husband and father of the appellants, and question requires for consideration regarding maintainability of independent suit as well as entitlement of the share in the property of the father of the appellant.
2 and 3.
And claim is also that the property is an ancestral and joint family property. And this point requires reconsideration, and hence matter requires to be admitted and substantive question of law has to be framed. Admit the following substantive question of law arises for the consideration of this court. Whether the respondent can maintain an independent suit when he had derived the title through the husband and father of the appellants. Whether the appellants are entitled for a share in the property which was sold in favor of the respondent. In prakara ancestral property na?
Father in the ಬಂದಿರ್ತಕ್ಕಂಥದ್ದು. Rohit Sharma case.
And property is an ancestral and joint family property under section 6 of Hindu Succession Act. Whether the finding of both the trial court as well as the first appellate court against the material and record, whether the judgment and decree of the respective courts amounts to perversity in ignoring the material and record. The registry is directed to get the records and list the matter for final hearing in the 3rd week of August.
We will also file the paper book. We will also file the
Paper book can bekayal. Filing of paper book is dispensed.
Grateful notes.
R. Vijay Kumar or Narayanappa.
Paid.
Partly decreed.
Cost is paid.
ಏನು ಕಾಸ್ಟ್ ಹಾಕಿತ್ತ?
By mistake, it was paid to the Clerks Association, Advocates Clerks Association. I am sorry, madam.
ಆಯ್ತು. ಎಲ್ಲಿಗೆ ಹಾಕಿದ್ರು ಅದು ದುಡ್ಡನ್ನ?
ಇದಕ್ಕೆ ಹೈಕೋರ್ಟ್ ಕ್ಲರ್ಕ್ಸ್ ಅಸೋಸಿಯೇಷನ್ಗೆ ಇವತ್ತು ಕಟ್ಟಿದ್ದಾರೆ.
ಹೈಕೋರ್ಟ್ ಕ್ಲರ್ಕ್ಸ್ ಅಸೋಸಿಯೇಷನ್ ಕಟ್ಟಿದಿರಿ.
ಹೌದು.
ಕಾಸ್ಟ್ ಹಾಕಿದ್ ಯಾರ ಪರವಾಗಿ?
ಇವರಿಗೆ ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅನ್ಸುತ್ತೆ ಬಹುಶಃ. ಐ ಆಮ್ ಸಾರಿ madam, I apologize.
ನೋಡಿ ರಿಜಿಸ್ಟ್ರಿ ಅಂತ ಇದೆಯಲ್ರಿ?
ಸಾರಿ madam, I am sorry.
ರಿಜಿಸ್ಟ್ರಿನೇ ಬೇರೆ, ಕ್ಲರ್ಕ್ ಅಸೋಸಿಯೇಷನ್ ಬೇರೆ. ನೀವೇ ತಪ್ಪು ಮಾಡ್ಕೊಂಡು
ಇಲ್ಲ,
ನಿಮ್
ಇಲ್ಲ,
ಕ್ಲರ್ಕ್ಸ್
ತಪ್ಪು
ಅಸೋಸಿಯೇಷನ್ ದುಡ್ಡು
ತಪ್ಪು
ಕಟ್ಟಕ್ಕಾಗಲ್ಲ. ಸಪರೇಟ್ ಆಗಿ ಕಟ್ಟಬೇಕು. ಅಲ್ಲಿ ನೋಡಿ ವಿಡ್ರಾ ಮಾಡ್ಕೋತೀರಾ ಏನ್ ಮಾಡ್ತೀರಿ ನೋಡಿ.
ಆಗ್ಬೋದು. ಇಲ್ಲ ಅಲ್ಲೇ ತಾವು ಅಪ್ನೆ ಕೊಟ್ರೆ ಅಲ್ಲೇ ಇರಲಿ.
ತಗೊಳ್ಳಿ. ದಿ ಕಾಸ್ಟ್ ಪೇಯ್ಡ್ is not accepted and directed to pay the cost in the registry. ಆಯ್ತು, ಹೇಳಿ ಬೇರೆ ಏನು. ಪಾರ್ಟ್ಲಿ ಡಿಕ್ರೀಡ್ ರಿವರ್ಸ್ ಆಗಿದೆಯಾ?
ಹೌದು.
The appellant counsel is directed to pay the cost within 1 week from today to registry and issue notice against the respondent and call for records.
ಆಗಿತ್ತು, ನೋಟಿಸ್ ಸರ್ವಾಗಿ ಬಂದಿಲ್ಲ.
ಅಲ್ಲ, ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಹೌದು ಆಗಿತ್ತು, ಸರ್ವಾಗಿ ಬಂದಿಲ್ಲ. ಸರ್ವಿಸ್
ಸಫಿಶಿಯಂಟ್ ಯಾರು ಒಬ್ರಿಗಲ್ಲ ಮೇಡಮ್? ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ? ಇಲ್ಲ, ನೋಟಿಸ್ ಬೇಡ, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್.
ಆಗ್ಬೋದು.
List the matter immediately after receipt of the records. Divergent pending ಇದೆ. ಹೇಳಿ ಮೇಡಮ್ ಏನು?
17 ಅಲ್ಲಿ interim order dictate ಆಗ್ಲಿಲ್ಲ.
Interim order ಏನ್ ಮೇಡಮ್?
ಅದೇ ನಾಟ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಂಡ್ ಆಪರೇಷನ್ ಸ್ಟಾಪ್ ಕೇಳಿದ್ವಲ್ವಾ, ತಾವು ನೋಡಿದ್ರಿ ಅದನ್ನ?
ಎಲ್ಲಿ ಅವರು ಇದಾರ ಅದರ್ ಸೈಡ್? ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಪ್ರೆಸ್ ಮಾಡಿ ಮೇಡಮ್. ಏನೇ ಮ್ಯಾಟರ್ ಇಸ್ ಅಡ್ಮಿಟೆಡ್ ಅಲ್ವಾ?
ಅದೇ ಬಟ್ ಏನಂದ್ರೆ ಅಲ್ಲಿ ಹೋಗಿ ಗಲಾಟೆ ಮಾಡ್ತಾರಂತೆ. ನಾವು ಕ್ವಶನ್ ಅದಕ್ಕೆ
ಏನ್ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ?
ಅಂತ ಜಡ್ಜ್ಮೆಂಟ್
ಕರ್ಕೊಂಡ್ ಬನ್ನಿ, ಕರ್ಕೊಂಡ್ ಬಂದ್ರೆ ಅವ್ರ ಪ್ರೆಸೆನ್ಸ್ ಅಲ್ಲಿ ಮಾಡೋಣ ಆರ್ಡರ್. 72 SN ಭಟ್ ಪರೀಕ್ಷಿತ್. ಇದ್ರಲ್ಲಿ ಯಾರು ಇಬ್ರು ಇದ್ದೀರಾ?
ಅಲ್ಲ, ಅದು ನೋಟಿಸ್ ಆಗಿದೆ. ಆನ್ ದಿ ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ನೋಟಿಸ್
R2 is abated ಅಂತ ಆಗಿದೆ.
R1 is concerned, one notice was ordered and London Council
R1 ಆರ್ಡರ್ ಆಗಿಲ್ವಾ?
ಸರ್ವಾಗಿದೆ.
ಯಾರು ಇದಾರಲ್ರಿ ಎಲ್ಲಾರ್ ಸ್ಕೇಲ್ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ.
ಮಿಸ್ಟರ್
ಯಾರ ಮಾಯಣ್ಣ ಕೂಡ ಅಂತ ಅಪಿಯರ್ ಆಗೋರಲ್ಲ.
Please, my request is that, my lord, the exhibit D11 and D12 is required to be looked into. Lordship may kindly order for the calling of records, my lord, because I have taken up a contention that they have released their right. Now what the learned judge has taken that such a document is required registration.
ಆಯ್ತು, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್.
Please.
ನೋಟಿಸ್ ಹೋಗಿಲ್ವಾ? ಯಾರಿಗೆ ಹೋಗ್ಬೇಕು ಮೇಡಮ್? ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂಡ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಎಗೇನೆಸ್ಟ್ R2 ಆಲ್ರೆಡಿ ಅಪ್ಡೇಟ್ ಆಗಿದೆ. R1 ಎಲ್ಲಾರ್ಸ್ ಇದ್ದಾರೆ. 3 to 5 3 to 5 ನೆಸೆಸರಿ ಇದೆಯಾ?
Yes, my lord, they are the
against R3 to 5.
Please.
73 Srinivas V. Service of notice against respondent is held sufficient.
Sufficient, Lord. This is a defendant's appeal, concurrent finding injunction suit. Now, my lord, when the suit was filed, it was my lord, the plaintiff's contention was that he Nada Hanchina Mane and the defendant is opening a window on the side of western side of her property. Therefore, there is an interference. When that is with that contention, suit was filed. Now, my lord, the plaintiff himself have built a house, my lord, like this. And it is a 2-storied house now. ಅಂದ್ರೆ ನಾನು ಬರೀ ಮನೆ ಕಳ್ಸು ಅಂತಂದ್ರೆ ಅವರು ಬರೀ ಅಕ್ಕಪಕ್ಕ ಹೆಂಗಿದೆಯೋ ಹಂಗೆ ಕಳ್ಸಿದ್ದಾರೆ, ವಿಂಡೋನು ಇಲ್ಲ ಅಂತ ತೋರ್ಸಕ್ಕೆ. ಮೇ ಜಸ್ಟ್ ಪಾಸ್ ಆನ್ cause of action does not survive as on today, my lord, because he has demolished his old house and constructed a new house. May just in this photo, my lord. ಪಕ್ಕದ್ದು ಬ್ರೌನ್ ಕಲರ್ ಮನೆ, ಬ್ಲಾಡ್ ಯೆಲ್ಲೋ ಕಲರ್ ಅಲ್ಲ, ಬ್ರೌನ್ ಕಲರ್ ಮನೆ is belonging to the respondent, blood. He has put up 2-storied house now, and now it doesn't survive, blood. Now the cause of action does not survive because when the suit was filed, his contention was that he has got a nada hunch in the money, and my lord, the defendant have put up in the 3rd floor. He has opened a window on the western side of his property with that contention, and therefore water is flowing on his property. With that contention, he sought for an injunction. Now, my lord, the portion, my lord, he has demolished his house and put up a new construction. And my lord, even he has not left any setback. Also, he has constructed and house is completed, and he is residing there from past 3 years. Now, my lord, the cause of action does not survive, my lord. ಹೊಸ ಮನೆ ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರೇನೆ, ನಾಡಂಚಿನ ಮನೆ ಇಲ್ಲ ಈಗ.
ಪ್ರತಿವಾದಿಯ 3ನೇ ಅಂತಸ್ತಿನ ಮನೆ ಕಟ್ಟಡವನ್ನು ಕಟ್ಟಿದ್ದಾರೋ ಇಲ್ಲೋ ಅದನ್ನು ಸಹ ನಾನು ನೋಡಲಿಲ್ಲ. ನಾನು ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ವಾದಿಯ ಮನೆ ಕರೆಸಿದಾಗ ಪ್ರತಿವಾದಿಯ ಮನೆ 2ನೇ ಅಂತಸ್ತನ್ನು ಕಟ್ಟಿರಲಿಲ್ಲ. ಈಗ ನಿಮ್ ಕೇಸ್ ಅವರೇ ಹಂಚಿನ ಮನೆ ಹೊಡೆದಾಕಿ ಬೇರೆ ಮನೆನೇ ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರೇನೆ.
Does not survive, my lord.
Notice soberly, ನೋಡ್. Notice ಹೋಗಿದೆ ಇಲ್ಲ ಅಲ್ಲ ಮೇಡಮ್?
ಹೋಗಿದೆ, health sufficient ಆಗೋಗಿದೆ.
Sufficient.
Health sufficient. My lord, in fact, the respondent is also a court staff.
Huh?
Court staff, my lord, he is a.
Court staff.
Not in this Srirangpatna, he was a court staff. He has already put up and he is no more interested, my lord, because he has already put up a new house. ಅವರು ಸೆಟ್ ಬ್ಯಾಕ್ ಏನು ಬಿಟ್ಟಿಲ್ಲ, ನಾವು ಏನು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಲಿಲ್ಲ. We have not filed any case against him.
Constructed a new house?
My lord,
He also constructed new house?
no, my lord, mine is old house. I constructed in
Yours is old
1984.
house.
1984 is my date of construction. And his construction is 2014-15, my lord.
Suit was filed in the year?
My lord, suit was filed in the year
2010.
2010.
ಮತ್ತೆ?
ಅವ್ರು ಹೊಸದಾಗಿ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ ಈಗ.
ಯಾರು?
ರೆಸ್ಪಾಂಡೆಂಟ್.
ಅವರು ಕಟ್ಟಿದ್ದಾರೆ,
ನಮ್ದೇನಿಲ್ಲ, ನಮ್ದು ನೀವು 1984 ಏನಿತ್ತು ಅಷ್ಟೇ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇದೆ.
ನಿಮ್ಮನ್ನ ರಿಸ್ಟ್ರೈನ್ ಮಾಡಿರೋದು ಏನಕ್ಕೆ ಅಂತ? Defendant is hereby declared restrained from interfering with the peaceful possession and enjoyment of the suitable property.
Yes. Only, my lord, and window open, but that is allegation is.
Windows opened in the common wall.
Yes, my lord.
Within 3 months from the date of this order.
This order. Now, my lord, he has constructed.
But ನಿಮ್ಮ windows ಇದ್ದೇ ಇದೆಯಲ್ಲ?
He has got no, he has not new, he has put up a new construction. His earlier allegation is that.
Constructed, but your windows are there already. Defendant is directed to close the windows opened in the common wall within 3 months.
Common wall window can't be seen because common wall I have what I put. Window can't be seen here.
ಅವ್ರಿಗೆ ಮನೆ ಕಟ್ಟಿಕೊಂಡಿದ್ದಾರೆ ಬೇರೆ ಅಂತ ಆಗೋದಿಲ್ಲ. ನೀವೇನ್ ವಿಂಡೋಸ್ ಹಾಕಿದಿರಿ ಅದನ್ನ ರಿಮೂವ್ ಮಾಡಿ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ.
Yes, my lord.
Call for records ನೋಡ್.
But
list the matter immediately after receipt of records. 75.
Kindly pass over, senior will come.
Pass over ಇಲ್ಲ ಆಗೋಲ್ಲ ಇವತ್ತು.
ಅಲ್ಲ, ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ, will come.
ಅಲ್ಲೇ ಇರಲಿ. List after 2 weeks. Council request for pass over, list after 2 weeks.
ಸೊ ಇದರಲ್ಲಿ ಒಂದು IA3 ಹಾಕಿದ್ದಿ ಪುಟಪ್ ಆಗಿಲ್ಲ ಫಾರ್ ಲಿಸ್ಟ್ ಆಫ್ ಅಡಿಷನಲ್
Submits
ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
that IA3 is filed and hence registry is directed to put up the.
Please.
Lordship must please to observe in the order sheet. Last chance ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಹೌದಾ? ಮತ್ತೆ appeal will be dismissed ಅಂತ ಇದೆಯಲ್ರಿ?
ಅಲ್ಲ, ಹೌದು ಸರ್. ಇದರಲ್ಲಿ ಒಂದು
Finally, 2 weeks time is granted. If the learned counsel appeal doesn't argue the matter on the next date of hearing, appeal will be dismissed.
ಹೌದು, ಇದರಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಇನ್ನು
18 appeal. 2018 appeal.
2 weeks ನಾನು ಬ್ರೀತಿಂಗ್ ಟೈಮ್ ಕೊಟ್ಟು ಐ ವಿಲ್.
ಏನ್ ಬ್ರೀತಿಂಗ್? ಈಗ ಕೊಟ್ಟರದ ಲಿಸ್ಟ್.
ಹೌದು, ಸೀನಿಯರ್ ಬರ್ತಾರೆ.
6 ವರ್ಷ ಬ್ರೀತಿಂಗ್
ಹೌದು, ಹಾಗೆ
ಹೇಳಿ.
ಇದರಲ್ಲಿ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಗೆ IA ನಂಬರ್ 3 ಹಾಕಿದ್ದಿ ಪುಟಪ್ ಆಗಿಲ್ಲ.
ಎಲ್ಲಿ ಪಾಸ್ ಅವರ ಆಯ್ತು ನೋಡೋಣ ಬರ್ಲಿ
ಪ್ಲೀಸ್.
Small mistake has happened, my lord.
ಅನಜಾಕ್ಷಿ ಹೇಳ್ರಿ ಏನು?
Instructing counsel 1,000 rupees cost ಕಟ್ಟಿಲ್ಲ.
Non filing of memo along with.
That will be paid now itself.
Appointment of court commissioner along with statement of.
That appointment of court commissioner may be taken up with the main matter itself, my lord. The parties are negotiating for a settlement. 2 weeks time may be.
ಏನಾಯ್ತು? ಕಾಸ್ಟ್ ಏನಾಯ್ತು?
Cost ಇವಾಗ ಕಟ್ತೀವಿ ಸರ್. 1 o'clock ಕಟ್ತೀವಿ.
ಕಟ್ಬಿಟ್ಟು ಬನ್ನಿ ನೋಡು.
ಅಲ್ಲ, your lordship may adjourn the matter. It will be.
ಕಾಸ್ಟ್ ಕಟ್ ಬನ್ನಿ.
ಆಯ್ತು ಸರ್.
ಈ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಕಮಿಷನರ್ ಇದೆ ಇದ್ರಲ್ಲೇ.
ಹೌದು. ಅಲ್ಲ, along with ಇದು parties are negotiating for settlement. Small boundary dispute, not worth continuing.
ಅವ್ರಿಗೆ ಏನೋ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ ಅಂತಲ್ಲ.
ಒಂದು ಡೇಟ್
ಪಾಸ್ ಓವರ್ ಕಾಸ್ಟ್ ಕಟ್ ಬನ್ನಿ ನೋಡಿ.
For the appellants in this case, in the last occasion, we have
Certainly.
sent a retirement letter to the appellants, my lord.
What happened?
So it has not been served till today.
Last time also very same submission was made, madam. Learned counsel for the appellant files a memo stating that he has dispatched the letter by speed post and then seeks 1 week time to seek instructions to conduct the appeal and produce the copy.
In a transit ಅಲ್ಲಿ ಇದೆ ಸುಮ್ಮನೆ. ಮೂರೂನು ಸರ್ವ್ ಆಗಿಲ್ಲ.
Madam 16/7 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದು ಅದು.
ಇವತ್ತು ಬೆಳಗ್ಗೆದು ಕಾಪಿ ಇದೆ.
ಯಾವಾಗ ಕಳ್ಸಿದ್ರಿ ನೀವು? ಲೆಟರ್ ಕಳ್ಸಿರೋದು ಯಾವಾಗ? ಅವತ್ತೇ ಕಳ್ಸಿದ್ರಿ? ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ ಕಳ್ಸಿದ್ರಾ?
ಇಲ್ಲ, ಬೆಳಗ್ಗೆನೆ ಕಳ್ಸಿದ್ರು.
ಬೆಳಗ್ಗೆನೆ ಕಳ್ಸಿದ್ರೆ ಮತ್ತೆ ಆ ರೀತಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರಿ? Dispatch the letter by speed post anta. The appellant counsel again seeks same on the ground that the notice was dispatched on 16/7/24 and the same is in transit and hence 2 weeks time granted. Non-filing of documents by the council for appellant.
ಪಾರ್ಟಿಗೆ ಹುಷಾರಿಲ್ಲ ಈಸ್ ಅಡ್ಮಿಟೆಡ್ ಇನ್ ಹಾಸ್ಪಿಟಲ್.
ಹಾ ಏನ್ ಹೇಳಿ ಡಿಲೇಗ್ ಹೇಳಿ 1583 ದಿವಸ ಡಿಲೇದ್ ಹೇಳಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಡಿಲೇಗ್ ಬಗ್ಗೆ ದಾಖಲೆ ಕೊಡಿ ಅಂತ ಏನೋ ಕೇಳಿದ್ವಿ. ಅವ್ರು ಅಡ್ಮಿಟ್ ಆಗ್ಲಿ ದಾಖಲೆ ಕೊಡಿ.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡೋದಕ್ಕೆ
Learned counsel for the appellant seeks time to produce the documents with regard to the illness of the appellant. Since there is a delay of 1583 days in filing the appeal.
ಅದನ್ನ ಪಾರ್ಟೀಸ್
97 ಆರ್ಡರ್ ಆಗಿರೋದ್ರಿ ಇಲ್ಲಿವರೆಗೆ ಯಾಕೆ ಕಲೆಕ್ಟ್ ಮಾಡಿಲ್ಲ ನೀವು?
ಪಾರ್ಟೀಸ್
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತಯಾರಾಗ್ತಾ ಇದೆ ಈಗ. ಮತ್ತೆ ಅವ್ನು ಆಲ್ರೆಡಿ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ರೆ ಆ ದಾಖಲೆ ಕೊಡಕ್ಕೇನ್ರಿ? ಆ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಏನ್ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದೇನೆ ಆ ಪೀರಿಯಡ್ ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ದೆ. ನೋ ಗ್ರೌಂಡ್ಸ್ ಡಿಸ್ಮಿಸ್ಡ್. ರೀಸನ್ಸ್ ಏನ್ ಹೇಳಿದಿರಿ ಹೇಳಿ ಫಸ್ಟ್.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್
Last time matter was heard.
Yes, madam.
And thereafter, when the pleading was made with regard to the suffering from joint pain.
ಜಾಯಿಂಟ್ ಪೈನ್ ಆಸ್ತಮಕ್ಕೆ
ಎಲ್ಲಿದೆ ದಾಖಲೆ ಮತ್ತೆ?
ಅದನ್ನ ತರದೇ ಕೇಳಿದ್ವಿ, ಅದು ಇನ್ನೂ ಬಂದಿಲ್ಲ.
The appellant counsel again seeks time. ಏನ್ರಿ ಎಲ್ಲಿದೆ ದಾಖಲೆ?
ದಾಖಲೆಗಳು ಅವರು ಅಪಲೆಂಟ್ ಇಸ್ ನಾಟ್ ವೆಲ್.
ಆಯ್ತ್ರಿ ಇಷ್ಟು ದಿವಸ ಬೇಕು 9ನೇ ತಾರೀಕಿಂದ. ಇವತ್ತೆಷ್ಟು ಡೇಟು? 9ನೇ ತಾರೀಕಲ್ಲಿ ನೀವು ಟೈಮ್ ತಗೊಂಡಿರೋದು. ಇರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಕಲೆಕ್ಟ್ ಮಾಡಕ್ಕೆ ಎಷ್ಟು ದಿವಸ
ಹೇಳಿದ್ದೆ, ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ದೆ ಅವ್ರಿಗೇನು ಹುಷಾರ್ ತಪ್ಪಿದೆ ಅಂತ ಹೇಳಿ.
ಈಗ ಹುಷಾರ್ ತಪ್ಪಿದೆ, ಅವತ್ತೇನಾಯ್ತು ಹೇಳಿ?
ಅವಾಗಿಂದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತಂದ್ಕೊಡ್ಬೇಕು.
9ನೇ ತಾರೀಕಿಂದ ನಾವು ಕೇಳಿರೋದು ಹಳೆ ರೆಕಾರ್ಡ್ಸ್, ಹೊಸ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲ. ಮತ್ತೆ the appellant counsel again seeks time and finally another 2 weeks time granted. Just after 2 weeks.
My lord. This is a
79.
Suit for declaration and injunction, my lord. In this, the suit land is 2 acre 27 gutta.
ರೆಡಿ ಅಲ್ಲ ಮೇಡಮ್? ರೆಡಿ ಇದೀರಲ್ಲ? ನೀವು ರೆಡಿ ಇದೀರಾ ಅಂದೆ? ನಿಮ್ದಲ್ಲ ಅಂದ್ರೆ ನೀವ್ ಯಾರಿಗೆ ಮೇಡಮ್? ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ ಪ್ರಭುಲಿಂಗ ಮೂರ್ತಿ. ರೆಡಿ ಇದೀರಲ್ಲ ಅಂದ್ರೆ ಅಡ್ಮಿಷನ್ಗೆ. ಎಲ್ಲಿ ಪ್ರಭುಲಿಂಗ ಮೂರ್ತಿ? ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ನೀವು ಅವ್ರ ಕೊಲೀಗ? ಆಯ್ತು ಹೇಳಿ, ನೀವು ಇಂಟರ್ಸೆಪ್ಟ್ ಬಿಟ್ವೀನ್ ದಿ ಅಡ್ಮಿಷನ್ appellant and.
In this case, the suit schedule property originally belongs to one Karitimaya. Karitimaya has acquired this property through family partition very long back. The Karitimaya has executed the mortgage deed in favor of one Siddhanjama. And the Karitimaya is died without redeeming the mortgage deed. After the death of Karitimaya, his wife Chikkamma executed the sale deed in favor of Timmaya. In favor of Timmaya. The grandfather of dependent number.
Property originally belongs to Karitimaya. ಹೌದಾ?
ಹೌದು.
ಆಮೇಲೆ
Karitimaya executed the mortgage deed in favor of Siddhanjama.
ಹೌದಾ? ಆಯ್ತು.
Karitimaya died without redeeming the mortgage deed.
Without
redeem the mortgage.
Redeem
the mortgage. After the death of Karitimaya, his wife Chikkamma executed the sale deed in favor of Chittaya. Who is the father of dependent number 3 to 6.
ಚಿಕ್ಕಮ್ಮ ಮಾರಾಟ ಮಾಡಿದ್ರು.
ಚಿಕ್ಕಮ್ಮ ಇವರಿಗೆ
ಚಿಕ್ಕಮ್ಮ ಸೇಲ್ ಮಾಡಿದ್ರು.
ಚಿತ್ತಯ್ಯ ಸೇಲ್ ಮಾಡಿದ್ರು.
ಚಿತ್ತಯ್ಯನ್ಗೆ.
ಹೌದು.
ಆಯ್ತು.
ಆ ಸೇಲ್ ಮಾಡುವಾಗ ಕಂಡೀಷನ್ ಹಾಕಿದ್ರು, ಇದೇನು ಮಾರ್ಟಿಗೇಜ್ ಆಗಿದೆ, ಇನ್ ಫೇವರ್ ಆಫ್ ನಂಜಮ್ಮ ಇದೆ, ಅದನ್ನ ರಿಡೀಮ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅನ್ನೋದ್ರೆ 500 rupees ಅವ್ರ ಕಡೆ ಬಿಟ್ಟು
ರಿಡೀಮ್ ಮಾಡ್ಕೊಳಕ್ 500 rupees ಬಿಟ್ಟಿದ್ರು.
ಬಿಟ್ಟು ಮಾರಾಟ ಆಯ್ತು. ಮಾರಾಟ ಆದ್ಮೇಲೆ ಆಮೇಲೆ ಇವರು ಚಿತ್ತಯ್ಯ ಅನ್ನೋರು
ಚಿತ್ತಯ್ಯ ರೆಡೀಮ್ ಮಾಡ್ಕೊಂಡ್ರ?
ಮಾಡ್ಕೊಂಡ್ರು ಸರ್.
ಆಗಿದೆ.
ಮಾಡ್ಕೊಂಡ್ರು.
ಯಾವಾಗ?
ಇದು ಇನ್ ದಿ ಇಯರ್ 1959 ಅಲ್ಲಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್.
1959 ಅಲ್ಲಿ. ಆಯ್ತು.
ರೀಡಿಂಗ್ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ ಇದು ಚಿತ್ತಯ್ಯ ಅಂಡ್ ಇಸ್ ಸನ್ಸ್ ಆರ್ ಇನ್ ಪೀಸ್ಫುಲ್ ಪೊಸಿಷನ್ ಅಂಡ್ ಎಂಜಾಯ್ಮೆಂಟ್ ಆಗಿದ್ದಾಗ ಈ ಪ್ಲೇಂಟಿಫ್ ಅಂಡ್ ಡಿಪೆಂಡೆಂಟ್ 1 and 2 ನೋ ವೇ ಕನ್ಸರ್ನ್ ಟು ದಿ ಸೂಟ್ ಪ್ರಾಪರ್ಟಿ, ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ suit without impleading the dependent number 3 to 6. ಇವ್ರನ್ನ ಮಾಡ್ಲೇ ಇಲ್ಲ ಒರಿಜಿನಲ್.
3 to 6 ಯಾರು ಇವರು?
3 to 6 ಚಿಲ್ಡ್ರನ್ಸ್ ಆಫ್ ಚಿತ್ತಯ್ಯ. ಅವನಿಗೆ
ಡಿಫೆಂಡ್ ನಂಬರ್ 1 and 2 ಯಾರು ಮತ್ತೆ?
1 and 2 ಅವರು ಮಾರ್ಟಿಗೇಜ್ ಇವರು ನಂಜಮ್ಮನ್ ಮಕ್ಕಳು, ಸಿದ್ಧಂಜಮ್ಮನ್ ಮಕ್ಕಳು. ಮಕ್ಕಳು. ರೆಕಾರ್ಡ್ಸ್ ಆರ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಇನ್ ದ ನೇಮ್ ಆಫ್ ಸಿದ್ಧಂಜಮ್ಮ ಆನ್ ದ ಬೇಸಿಸ್ ಆಫ್ ಮಾರ್ಟಿಗೇಜ್ ಡೀಡ್.
ಆಯ್ತು.
ಹಂಗಾಗಿ ಆ ಪ್ಲೇಂಟಿಫ್ ಮತ್ತೆ ಡಿಪೆಂಡೆಂಟ್ 1 and 2 ದೇ ಹಾವ್ ಫೈಲ್ಡ್ ದಿ ಸೂಟ್. ಆಗ ಅಂಡ್ ದೇ ಹಾವ್ ಸೂಟ್ ಇಸ್ ಡಿಕ್ರೀಡ್. ಅದು ಡಿಕ್ರೀಡ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಅದು ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ಸೂಟ್ ನಾವು ಹೋಗಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಿವಿ, ನಮ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡಿ ಅಂತಂದೇಳಿ. ಇಂಪ್ಲೀಡ್ ಮಾಡಿದ್ರು. ಇಂಪ್ಲೀಡ್ ಮಾಡಿದ್ಮೇಲೆ ಬಟ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಸರ್ವ್ಡ್ ದಿ ಕಾಪೀಸ್ ಆಫ್ ದಿ ಸೂಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್, ನಾಟ್ ಇಶ್ಯೂಡ್ ದಿ ಸೂಟ್ ಸಮನ್ಸ್. ಬರಲೇ ಇಲ್ಲ. ಹಾಗಾಗಿ ನಾವು ವಿತೌಟ್ ವಿ ಆರ್ ನಾಟ್ ಅನ್ಏಬಲ್ ಟು ಫೈಲ್ ದಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಆ ಕೇಸ್ ಇತ್ತ ಇಲ್ಲ?
ಕೇಸ್ ಇತ್ತು. ಕೇಸ್ ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ಸೂಟ್ ಅನ್ನೇ ನಾವು
ಕೇಸ್ ನಂಬರ್ ಏನದು?
ಕೇಸ್ ನಂಬರ್ OS ನಂಬರ್ 211 of 2004.
ಸರಿ ರೀ, ನೀವು ಆ ಕೇಸಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿ ನೀವೇ ಇಂಪ್ಲೀಡ್ ಆದ್ಮೇಲೆ ನೀವು ಕಂಟೆಸ್ಟ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ವಾ?
ಇದು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕಾಪಿನೇ ಕೊಟ್ಟಿಲ್ಲ ಅವರು.
ಕೊಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರೆ ನೀವು ಆಲ್ರೆಡಿ ರೆಕಾರ್ಡಿಗೆ ಬಂದಿದ್ರಲ್ವಾ?
ರೆಕಾರ್ಡಿಗೆ ಬಂದಿ ಸರ್.
ಇನ್ಸಿಸ್ಟೆಡ್ ದಿ ಕೋರ್ಟ್ ಟು ಡೈರೆಕ್ಟ್ ದೆಮ್ ಟು ಫರ್ನಿಶ್ ದಿ ಕಾಪಿ ಆಫ್ ದಿ ಪ್ಲೇಂಟ್.
ಕೊಟ್ಟಿಲ್ಲ ಅವರು. ನಮಗೆ ಸೂಟ್ ಸಮನ್ಸ್ ಇಶ್ಯೂ ಆಗ್ಬೇಕಾಗಿತ್ತು. ಇಂಪ್ಲೀಡ್ ಆದ್ಮೇಲೆ ಸೂಟ್ ಸಮನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ. ಹಾಗಾಗಿ ನಾವು
ನೀವೇ ಇಂಪ್ಲೀಡ್ ಆಗಿದಿರಲ್ರಿ, ನೀವೇ ಹೋಗಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಮತ್ತೆ
ಅದು
ನೀವೇ ಇಂಪ್ಲೀಡ್ ಆಗಿದಿರಲ್ಲ, ನೀವು ಕಂಟೆಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ ಆಮೇಲೆ ಇಂಪ್ಲೀಡ್ ಆದ್ಮೇಲೂ?
ಇಲ್ಲ ಮಾಡಿದ್ವಿ, ಕಂಟೆಸ್ಟ್ ಮಾಡಿದ್ವಿ. ಬಟ್ ಅದು ಇದು
ಕಂಟೆಸ್ಟ್ ಮಾಡಿದಿರಿ ಅಂತೀರಿ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿಲ್ಲ ಅಂತೀರಿ. ಏನ್ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ.
ಹಾಗೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿಲ್ಲ ಸರ್ ಪ್ಲಾಂಟಿಫ್. ನಾವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪ್ಲಾಂಟಿಫಿಂಗ್ ಮಾಡಿಲ್ಲ. ಹಾಗಾಗಿ ಸೂಟ್ ಡಿಕ್ರಿ
ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿಲ್ಲ, ನೀವು
ಹಾಕಿಲ್ಲ.
ಮತ್ತೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಸೂಟ್ ಡಿಕ್ರಿ ಆಯ್ತು. ಸೂಟ್ ಡಿಕ್ರಿ ಆಗಿದ್ದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ. ಚಾಲೆಂಜ್ ಆದ್ಮೇಲೆ ಇನ್ ದಿ ಅಪಿಲೇಟ್ ಸ್ಟೇಜು ನಾವು ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಅಪಿಲೇಟ್ ಫಸ್ಟ್ ಅಪಿಲೇಟ್ ಕೊಟ್ಟು ನಾಟ್ ಅಟ್ ಆಲ್ ಕನ್ಸಿಡರ್ ಮೈ ಅಪ್ಲಿಕೇಶನ್. ಅದೇ ಈ ಸ್ಟೇಜಲ್ಲಿ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತಂದೇಳಿ ಹೇಳಿದ್ದಾರೆ.
ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಾ?
ರಿಜೆಕ್ಟ್ ಮಾಡಲಿ. ಅದು ಇಟ್ ಈಸ್ ನೋ ವೇ ಕನ್ಸರ್ನ್ ಅಂತಂದೇಳಿ ಮಾಡಿದ್ದಾರೆ ಸರ್.
ನೋ ವೇ ಕನ್ಸರ್ನ್.
RA page number, kindly see the
presence of the proposed respondents. ನೀವು ಪ್ರಪೋಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅದರಲ್ಲಿ?
ಪ್ರಪೋಸಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆ, ಇಂಪ್ಲೀಡ್ ಆಗಿದ್ವಿ.
ಅಪೀಲ್ ಅಲ್ಲಿ ನೀವೇ ಪಾರ್ಟಿ ಅಲ್ಲೇನ್ರಿ? ಅಪೀಲ್ ಯಾರು ಹಾಕಿದ್ದು?
ಅಪೀಲ್ ನಾವೇ ಹಾಕಿದ್ವಿ.
ನಿಂಗಪ್ಪ ಅಂದ್ರೆ?
ಹೌದು,
ನೀವೇ ಹಾಕಿರೋದು?
ಹೌದು.
ಮತ್ತೆ ಇಲ್ಲೇನ ಪ್ರಪೋಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅಂತ ಇದೆ?
ಹೌದು, ಪ್ರಪೋಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ಲ, ಇಂಪ್ಲೀಡ್ ಆಗಿದೆ ಸರ್. ಆನ್ ದ ಸೇಮ್ ಡೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ ದಿವಸ ಸೇಮ್ ಡೇನೆ ಇಂಪ್ಲೀಡ್ ಆಗಿದೆ. ಅಡ್ಮಿಟ್ ಅಲವಾಗಿದೆ, ಅಲ್ಲಿಗೆ ಇಂಪ್ಲೀಡ್ ಆಗಿದೆ. ಅಮೆಂಡೆಡ್ ಪ್ಲಾಂಟ್ ಕೂಡ ಹಾಕಿದ್ದಾರೆ. Kindly see the para number 28 of the first appellate court. 28 in page number 38. Idrally, the appellant has filed IA number 7 before the court seeking permission to implead the applicants as additional respondent. The application is accompanied by the affidavit of the applicant. The appellant has stated that during the pendency of the appeal, the respondents have sold the suit's property.
ಅದು ನೀವು ಪ್ರಾಪರ್ಟಿ ಯಾರು ಸೇಲ್ ಮಾಡಿದಾರೆ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿ ಅಂತ ಕೇಳಿದಿರಿ?
ಹೌದು ಸರ್. ಇಲ್ಲಿ ಪಾಯಿಂಟ್ ನಂಬರ್ 4 ಪೇಜ್ ನಂಬರ್ 14. The learned counsel for the appellant, while conversing the argument, has filed IA number 7 under order 41 rule 27 of CPC and sought permission of the court to adduce additional evidence by producing additional documents. I have perused the said application, accompanied affidavit and the documents. The documents sought to be produced and certified copies of the registered sale deed, redemption deed, copy of the will, RTC, etc., and mutation register. The grounds urged by the appellant in the appeal memorandum is reiterated by the appellant in the affidavit filed along with the said application. This court has already observed that the appellant had an opportunity before the trial court to contest the suit by filing the written statement. The appellant had an opportunity to produce the documents before the trial court, but he has not done so. Now, before this appellate court, The appellant has filed the said documents and failed to receive the additional evidence. If the documents sought to be produced are received by this court cannot rely on the said document. ಅವನೇನು ಮಾರ್ಕ್ ಮಾಡ್ಲಿಲ್ಲ, ಏನು ಮಾಡ್ಲಿಲ್ಲ.
What is the error in the order?
Additional documents ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾಗಿದೆ.
ಸರಿ ರೀ, ನೀವೇ ಸೋ ಮೋಟೋ ಇಂಪ್ಲೀಡ್ ಹಾಕಿದ್ರಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಹೌದು ಸರ್.
WS ಹಾಕಿಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿಲ್ಲ,
ಹೌದು.
ಕಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ಆರ್ಡರ್ 41 ರೂಲ್ 27 ಏನ್ ಹೇಳುತ್ತೆ?
ಅದೇ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಬಹುದು. ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್.
ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ತಗೊಳ್ಬೇಕಾದ್ರೆ ನೀವೇನ್ ಮಾಡ್ಬೇಕ್ರಿ? What it says 41 rule 27 AA. You have to establish that what is prevented in you producing the documents. ನೀವೇ ಸೋ ಮೋಟೋ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ರೆಕಾರ್ಡಿಗೆ ಬಂದು ನೀವು WS ಹಾಕ್ತಲೇ ಕೇಸು ನಡೆಸ್ತಾ ಹೋದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? That is the reason only given by the first appellate court. ನೋಡಿ
ಅಲ್ಲ, ರೆಕಾರ್ಡ್ ಬರ್ಲಿ ಬರ್ರಿ.
ಏನ್ ರೆಕಾರ್ಡ್ ಬರ್ಬೇಕು?
ರೆಕಾರ್ಡ್ ಕಾಲ್ಫಾರ್ ಆಗಿ. ರೆಕಾರ್ಡ್ ಕಾಲ್ಫಾರ್.
ಯಾವ ರೆಕಾರ್ಡ್ ಕಾಲ್ಫಾರ್ ಮಾಡ್ಬೇಕ್ರಿ?
ಎರಡು ಕೋರ್ಟ್ ಕಾಲ್ಫಾರ್ ಆಗಿ ಫೈನಲ್ ಇಯರಿಂಗ್.
Sorry, heard this matter is listed for admission and I heard the counsel for the appellant. The appellant counsel would immediately contend that even though an application is filed to implead the subsequent purchaser as parties to the proceedings and the same was dismissed. And also counsel would submit that an application is filed under order 41 rule 27 before the first appellate court. And the same was also rejected. The counsel also would vehemently contend that the additional documents which have been produced before the first appellate court clinches the issue between the parties. And in view of non-considering the IAS and not giving any opportunity before the first appellate court, and the same causes prejudice to the rights of the appellants herein. And also would contend that no opportunity was provided to the defendant number 3 to 6 who are the appellants herein. And dismissal of both the IAS is erroneous and the same requires its interference. Counsel for the respondent is also present and says both the courts have not committed any error in decreeing the suit and granting the relief of declaration and for permanent injunction.
We are seeking only remand the case. Remand the case for proceedings.
ರಿಮಾಂಡ್ ಎಲ್ಲ ನೀವು ಬಂದಾಗೆಲ್ಲ ರಿಮಾಂಡ್ ಮಾಡಕ್ಕಲ್ರಿ? ಈ ಪ್ಲೇಂಟಿಫ್ ನಂಬರ್ 1 and 2 ಹೇಗೆ ರಿಲೇಟಿವ್ಸ್ ಇವರಿಗೆ ಕರಿತಿಮ್ಮಯ್ಯಗೆ?
ಕರಿತಿಮಯ್ಯ ಅವ್ರ ಮಕ್ಕಳು, ಕರಿತಿಮಯ್ಯ ಮಕ್ಕಳು ಅವರು. They are the sons of ಕರಿತಿಮಯ್ಯ.
ಅವ್ರು ಯಾವಾಗ ರಿಡೀಮ್ ಮಾಡಿದ್ದಾರೆ ಪ್ರಾಪರ್ಟಿನ? ಅವರೇ ರಿಡೀಮ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ?
ಅವರು ನಾವೇ ರೆಡಿ ಮಾಡಿ ಅಂತ ಸುಳ್ಳು ಹೇಳಿ ಅವ್ರು ಮಾಡಿದ್ದಲ್ಲ. ಎಕ್ಸಿಬಿಟ್ P4 ಅಲ್ಲಿ ನಾನ್ ರೆಡಿ ಮಾಡಿರೋದು ನಮ್ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್. Exhibit P, kindly see the exhibit P.
Copy RTC mortgage deed, lease deed. ಅಷ್ಟೇ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿರೋದು?
ಹೌದು ಸರ್. ಅಲ್ಲ, ಇದು ಎಕ್ಸಿಬಿಟ್ P4 ನೋಡಿ ಸರ್. ಅದು ಅವರು ತಪ್ಪು ಹೇಳ್ತಿದಾರೆ ಅವ್ರು.
P4 ಏನದು? ಲೀಸ್ ಡೀಡ್,
ರಿಡಿಮಿಷನ್ ಡೀಡ್.
ಲೀಸ್ ಡೀಡ್ ಅಂತ ಇದೆ.
ಅಲ್ಲ ಲೀಸ್
ರಿಡಂಪ್ಷನ್ ಡೀಡ್.
ರಿಡಂಪ್ಷನ್ ಡೀಡ್
ನಿಮ್ ಪ್ರಕಾರ ನೀವೇ ರಿಡೀಮ್ ಮಾಡ್ಕೊಂಡಿದ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಿ.
ನಾವೇ ಮಾಡ್ಕೊಂಡಿದ್ದ, ಅವ್ರು ಮಾಡ್ಕೊಂಡಿಲ್ಲ, ಅವ್ರು ಮಾಡ್ಕೊಂಡಿದ್ರು ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
ಚಿಕ್ಕಮ್ಮ ನಿಮಗ್ ಸೇಲ್ ಮಾಡಿದಾಗ
ಅವ್ರು ಸೇಲ್ ಮಾಡಿದಾಗ ನಮಗೆ ಕಂಡೀಷನ್ ಬಂತದು. ಅದು
ಕಂಡೀಷನಲ್ ಸೇಲ್ ಡೀಡ್ ವಾಸ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ವಿತ್ ಎ ರೈಟ್ ಟು ರಿಡೀಮ್ ದಿ ಪ್ರಾಪರ್ಟಿ.
ಹೌದು ಸ್ವಾಮಿ,
ಹೌದಾ?
ಹೌದು. ಅದ್ರ ಪ್ರಕಾರ ನಾವು ರಿಡಿಮ್ಷನ್ ಮಾಡ್ಕೊಂಡಿದ್ವಿ.
ಮತ್ತೆ ನೀವು ದಾಖಲೆ ಏನು ಹಾಕ್ತವ್ರು ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಅದು ಎಕ್ಸಿಕ್ಯೂಟ್ P4 ಅಲ್ಲಿ ಇದೆ, ಅವರು ಅದನ್ನ ಮಿಸ್ ರೀಡ್ ಮಾಡ್ತಿದ್ದಾರೆ. ಎಕ್ಸಿಕ್ಯೂಟ್ P4 ಮೇಲೆ ಖಂಡಿತ ಎಕ್ಸಿಕ್ಯೂಟ್ P4 ಅಲ್ಲಿ ಅವರು 1900
ಕಾಪಿ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಎಕ್ಸಿಬಿಟ್ P4 ಕಾಪಿ ಇದೆಯೇನ್ರಿ?
ಇದೆ ಸ್ವಾಮಿ, ಇದೆ.
ಕಾಪಿ ಇದೆಯಾ ಅಂದೆ?
ಇದೆ ಇದೆ ಇದೆ.
ಕೊಡಿ ನೋಡೋಣ ಏನಂತ.
ಸಿದ್ಧಾಂತಮ್ಮ ನಮಗೆ ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ವಿ, ನಾವು ಅವ್ರ ಕಡೆಯಿಂದ ಮಾಡ್ಕೊಂಡಿರೋದು. ಸಿದ್ಧಾಂತಮ್ಮ ಕಡೆ ನಾವು ರೀಡಿಂಗ್ ಮಾಡಿದ್ವಿ, ನಮಗೆ ರೀಡಿಂಗ್ ಮಾಡಿ ಕೊಟ್ಟಿರೋದು ಅವರು. ಚಿತ್ತಯ್ಯನವರಿಗೆ. ಚಿತ್ತಯ್ಯ ಇಸ್ ಅವರ್ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್. ನಾವು ರೀಡಿಂಗ್ ಮಾಡಿರೋದು ಅವರಲ್ಲ, ಅವರು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅವರೇ ರೀಡಿಂಗ್ ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅವರು.
ವೇರ್ ಇಸ್ ಯುವರ್ ಸೀನಿಯರ್ ಮೇಡಮ್? ಪಾಸ್ ಓವರ್ ಮಾಡ್ಬೇಕಾ ಏನು? ಪಾಸ್ ಓವರ್. You have relied upon the document of exhibit P4 under which they got redeemed the property, but no redemption in favor of you, but trial court granted decree in favor of you based on exhibit P4. How could it be? ಕಾಸ್ಟ್ ಆಗ್ತೀನಿ, ರಿಮೈಂಡ್ ಮಾಡ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ಕೋರ್ಟ್, ಅಪಲೇಟ್ ಕೋರ್ಟ್. ಏನ್ ಮಾಡಿರಿ? ಏನಾರು ಸಿಕ್ತೇನ್ರಿ?
ಒಂದೇನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಲ್ಲಿ
ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ.
ಹೌದು ಹೌದು,
ಸಿಂಗಲ್ ಅಪೀಲ್.
ಹೌದು, ಆಫೀಸ್ ಇದರಲ್ಲಿ ಅಲ್ಲ, ಬೇರೆ ಕೇಸ್ ನಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ. ನನಗೆ ಅದು ಇಂಟರ್ನೆಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿಯೂ ಸಿಗ್ತಾ ಇಲ್ಲ.
ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ?
My lord, the office has raised maintaining single appeal. I was told Mr. Justice Satyanarayana has held that appeal is single appeal is
maintainable.
Maintainable ಅಂತ. ಅದು ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಕೇಸಿಗೆ ಮಾತ್ರ ಅಂತ ಅನ್ಸುತ್ತೆ, ಯಾಕಂದ್ರೆ ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಲ್ಲಿ ಬಂದದ್ದು. ಸೊ ಐ ಆಮ್ ಟ್ರೈಂಗ್ ಟು ಸರ್ಚ್ ಇಟ್, ಐ ಆಮ್ ನಾಟ್ ಏಬಲ್ ಟು ಫಿಗರ್ ಇಟ್ ಔಟ್.
ನೋಡಿ ಸರ್ಚ್ ಮಾಡಿ
ಪ್ಲೀಸ್ ಮೇಡಮ್.
Appellate counsel again 6 times, finally 2 weeks time granted, list after 2 weeks.
Please.
Partly decreed, absent, partly decreed, 1/3, modified, 1/3 share.
Please, ma'am.
ಹೇಳ್ರಿ ಏನು?
It's a suit for partition filed by respondent number 1 and 2 before the court below, represented by third respondent. The facts of the case is that, please, my lord, fourth respondent is the owner of the property and he has gifted property in the name of his sons, the respondent number 6 and 7. Respondent and 6 and 7 have sold the property in two sale deeds.
Originally property belongs to whom?
Respondent number 4, Shahjahanandappa.
Raja?
Shahjahanandappa, the respondent number 4. He has gifted that property in the name of respondent number 6 and 7, the sons of Shahjahanandappa.
R4 to R6.
Yes, please, 6 and 7.
6 and 7.
These
Gift-
6 and 7 together, respondent number 4 have sold the property in the name of two sale deeds, one in the name of appellant herein.
Once
and
already gift was made in favor of R6 and R7, how R4 can join along with R6 and R7?
No, for selling the property, he has also signed as a consenting witness.
Consenting witness.
Yes.
Ah.
So respondent number 6 and 7 have sold the property acquired by them by way of gift in the name of appellant herein and also in the name of respondent number 8. Two sale deeds were there. Respondent number 1 and 2 being daughters of respondent number 7, Venkatesh. They have filed the suit for partition, claiming that we are also having a share in that property. My father has sold the property without taking our signatures like that. They have filed the suit for partition. In fact, the property belongs to Shahjahanandappa. That is a self-acquired property. That fact is not considered by the court below, and decree has been granted. One more appeal is also filed before this honorable court by other respondent number 8 herein. That is RSA.
Oh, 8 also filed.
Yes, madam.
Other connected RSA.
Yes, madam.
What is that number?
2570 of 18.
2570
70
of
bar
18.
18, bar 18. This may be
And the same
connected
is
with
pending.
that also on the, in
The
that
appellant
case.
counsel submits that arising out of the common judgment passed in both the RAs. Another RSA 2570 of 18 is also pending, and hence registry is directed to put up the
Along.
same along with this appeal.
In that case, interim order is there. This way.
ಯಾವ್ದ್ರಲ್ಲಿ?
RSA 2570.
ಅದ್ರಲ್ಲಿ ಏನಂತಿದೆ interim
Interim
order?
order not to proceed with the court orders. ಹೋಗ್ತಾ ಇದೆ.
Not to?
ಅದೇ,
ಈಗೇನ್ FDP ಇರ್ಬೇಕು ನೋಡಿ. FDP ನ ಏನು?
FDP ಹಾಕಿರ್ಲಿಲ್ಲ ನಾವು ಇದು ಹಾಕೋ ಕಾಲಕ್ಕೆ ನಾವಿಲ್ಲಿ ಕೇಳಿರೋದೇನಾದ್ರೆ
ಅಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಇದೆ?
ಪ್ಲೀಸ್ ಟು ಸ್ಟೇ ದ ಆಪರೇಷನ್ ಆಫ್ ದ ಜಡ್ಜ್ಮೆಂಟ್.
RSA 2570 of 18 ಅಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಇದೆ? ಕಾಪಿ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಇಲ್ಲ
ಮತ್ತೆ
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ಸ್ ಇದೆ ಅಂದ್ರು.
ಆಯ್ತು, ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಅದೇ ನಿಮಗೂ ಅಪ್ಲೈ ಆಗ್ತದಲ್ವಾ? ಪೋಸ್ಟ್
ಇದು-
ಮ್ಯಾಟರ್ ಟುಗೆದರ್ ಇನ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹಾಕ್ಬಿಡಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬೇಕಾ ಅಪ್ ಟು 2 weeks ಬೇಕಾ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ಬೋದು.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಯ್ತು.
ನೋಟಿಸ್ ಕೂಡ ಆರ್ಡರ್ ಮಾಡಿ.
ನೋಟಿಸ್ ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ
ಆಗಿದೆ
ನೋಟಿಸ್.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಎಗೇನ್ಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್.
Hearing for petitioner, madam. Petitioner, madam. Appellants in this case, madam. Kindly have this matter next week, madam. My senior is engaged in.
ಅವ್ರಿಲ್ಲ. Appellant counsel seeks time. Counsel for respondent is also absent. Disturb to 2 weeks.
Much obliged.
85 Naveed Ahmad.
Suit for partition. Lords, it is partly, Lords, it is a.
1/5 share was granted earlier.
Yes, Lords. I'm Lords in the appellate court, Lords, it was, Lords reversed.
Reverse the same.
Yes, Lords. Lord, the only issue, Lords, with regard to.
To notice against respondent and also call for records. 1 second. Set aside and the suit of the plaintiff is dismissed. Call for records and
Obliged.
amended,
Amended,
document.
I will file it in the counter, Lord, it is ready.
The counsel submits that he is going to file.
Can I file it?
The amended appeal memo in the registry. The registry ಹಾಕ್ಬಿಡಿ.
I will file it.
I prefer 2 weeks time this matter, my lords.
We want
Settlement ಗೆ 2 weeks.
settlement ಏನ್ರಿ? Other side
ಅದ್ ಮಾತಾಡ್ತಾ ಇದ್ದೀವಿ ಸ್ವಲ್ಪ.
other side service ಆಗಿದೆ ಬಂದಿಲ್ಲ.
ಆಗಿದೆ ಅದೇ ಸ್ವಾಮಿ ಅದು ಇಂಟ್ರೆಸ್ಟ್ ಎನ್ಹಾನ್ಸಿಂಗ್ ಆಫ್
Appellant counsel seeks time list up to 2 weeks.
ಸಾರಿ ಮೈ ಲಾರ್ಡ್ಸ್ ಐ ವಾಸ್ ನಾಟ್ ದೇರ್ ಇನ್ ಸೀರಿಯಲ್ ನಂಬರ್ 69 ಅದೇ ಸೆಟಲ್ಮೆಂಟ್ ಒಂದಿತ್ತು ಅದು ಮಾತಾಡ್ತಾ
ಏನಾಯ್ತು? 69
ಅದ 2 weeks ಆಯ್ತು ನಾನು ಇರ್ಲಿಲ್ಲ ಅವಾಗ.
ಡೇಟ್ ಹೋಗಿದೆಯಾ?
ಹೋಗಿದ್ದೇವೆ.
ಈಗೇನ್ ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಅಲ್ಲ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ಅಂತ ಹೇಳಿ ಐ ವಾಸ್ ನಾಟ್ ಪ್ರೆಸೆಂಟ್.
ಡೇಟ್ ಹೋದ್ಮೇಲೆ ಆಯ್ತು. 88 ಕಾರ್ತಿಕ್ ವಿ ಹಾಲೇಶ RG.
Appellant.
ರಂಗನಾಥ್ R, FDP allowed. ಹೇಳಿ.
DP is
counsel.
only challenging the final decree drawn.
Hmm.
I have failed in all the courts.
Hmm.
The point that was canvassed by me in the trial court is
Hmm.
whether multiple preliminary decrees could be drawn.
Hmm.
Now I make a statement that supplementary decrees can be drawn,
Hmm.
so long as there is a change circumstances that is.
Hmm.
Here that
What is the change circumstances now?
they wanted to give her more share
Hmm.
only because her date of birth was not properly noticed earlier.
Hmm.
Then they gave a school certificate and found out
Hmm.
that she was born subsequent to 1956.
Hmm.
Therefore, the share that was given got enlarged.
Hmm.
Therefore, I don't have much of a case
Hmm.
to argue before this court.
Hmm.
But the point is, the person who is before the court is around 85 years.
Hmm.
She's fighting against the mother.
Hmm.
The reason for her mother fighting against their thing, there is a place for ದೇವಸ್ಥಾನಕ್ಕೆ ಅಂತ ಒಂಚೂರು ಜಾಗ ಬಿಟ್ಟಿತ್ತು, ಅದು ತಾಯಿಗೆ ಹೋಗಿತ್ತು.
Hmm.
ಈಗ ಅದು ಈ ಮಕ್ಕಳಿಗೆ ಹೋಗುತ್ತೆ.
Hmm.
She doesn't want that to go to the daughter. So ಏನಾರ ತಾವು ಮೀಡಿಯೇಷನ್ ಮಾಡಿದ್ರೆ ಇನ್ನು ಕೇಸು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಳ್ಳೋಂತ ಕೇಸ್ ಅಲ್ಲ ಇದು.
Hmm.
ಇದೇನಿದ್ರು ಹಿಂಗೆ ವಯ ಮೀಡಿಯಾ ಮಾಡಿ ಅವ್ರಿಗೆ ದುಡ್ಡು ಕೊಟ್ಟು ದೇವಸ್ಥಾನ ಜಾಗ ಉಳಿಸ್ಕೊಳ್ಳೋಂಥದ್ದು ಪ್ರಯತ್ನ ಮಾಡ್ಬೋದು.
ಅಂದ್ರೆ ಪ್ರಾಪರ್ಟಿ
ಪ್ರಾಪರ್ಟಿ ಇಸ್ ಗಿವನ್.
ಇಂಟೆಂಟ್ ಟು ಗೋ ಗಿವ್ ಇಟ್ ಟು ದಿ ಟೆಂಪಲ್.
ಅಂದ್ರೆ ನಮ್ಮ ಮನೆ
ಹ್ಮ್.
ಮನೆ ಮೊದ್ಲು ಆಗಿತ್ತು, ಈಗ ಅವ್ರಿಗೆ ಶೇರ್ ಜಾಸ್ತಿ ಆಗಿದ್ರಿಂದ ಅವ್ರಿಗೆ ಹೋಯ್ತದೆ, ಅವ್ರಿಗೆ ಒಂಚೂರು ಹೋಯ್ತು, ನಮ್ಗೂ ಹೋಯ್ತು, ಏನೂ ಮಾಡಕ್ ಆಗಲ್ಲ.
Hmm.
I would rather give my daughter some money
Hmm.
and retain the property
Hmm.
if an opportunity is given. Otherwise, as a matter of right, I can't come and say any number of supplementary preliminary decrees cannot be drawn anta ಇಲ್ಲಿ ಮಾಡಕ್ ಆಗಲ್ಲ. There is a direct, that's the law. Law is any number of decrees.
ಏನ್ರಿ ಕರ್ದ್ ಮಾತನಾಡ್ತೀರಾ ನೋಡಿ. ಇದು ಸೂಸೈಡಲ್ ಪ್ರಾಪರ್ಟಿ ಓನ್ಲಿ ದಿ ಹೌಸ್
ಅಲ್ಲ, ಇದು ಲ್ಯಾಂಡ್ಸ್.
ಲ್ಯಾಂಡ್ಸ್.
ಹಾ.
ಹಾ.
So ಅದರಿಂದ ನಾನು I don't want to fight with my daughter. I'm aged 85.
ಹ್ಮ್.
Just want to sort out my
ಏನ್ರಿ
page 49.
86 year old.
Page 49. ನಾಲ್ಕೈದು ಲ್ಯಾಂಡ್ ಇದೆ.
ಐದಾರು ಶೆಡ್ಯೂಲ್ ಎಲ್ಲ ಇದೆ.
ಹಾ, ಇದೆ.
ಕಡಿಮೆ ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆ.
ಇದೆ ಎಲ್ಲ ಕಮ್ಮಿ ಎಕ್ಸ್ಟೆಂಟ್. I want to give her money, sort out.
ನೀವ್ಯಾರ ಮತ್ತೆ 12th 13 to 16 ಯಾರೋ ಇದಾರಲ್ಲ, ಪ್ರಸನ್ನ ಶೆಟ್ಟಿ.
ಅದೇ ಅವರೇ, ಅವರು ದೇ ಫೈಲ್ಡ್ IA 8.
ಬರ್ತಾರ ನೋಡ್, ಅವ್ರು ಬಂದ್ರೆ ಮಾತನಾಡಿ. ಇಲ್ಲ ನೀವೇ ಮಾತನಾಡಿ, ಅವ್ರ ಹತ್ರ ಆಗಲ್ಲ.
IA 8 ಹಾಕಿದ್ರು
ಹಾ.
under order 20 rule 18.
ಹ್ಮ್.
That application is allowed. I challenged it in RA. I lost it.
ಹ್ಮ್.
I've been losing because supplementary preliminary decrees can be drawn.
You both sit together and counsel also the concerned person. Take a decision. ಏನ್ ಪಾಸ್ ಓವರ್ ಮಾಡ್ಬೇಕಾ ಅಥವಾ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಲ?
ಒಂದು ಡೇಟ್ ಕೊಡು.
ಒಂದು ಡೇಟ್ ತಗೊಳ್ಳಿ. The counsel appearing for the appellant would suggest for settlement in the matter, since the appellant is 86-year-old and counsel for the R1, R2, R4 to 8, R10, R11, 13 and 16, 13 to 16. He is not before the court and his junior counsel is before the court. He is unable to take any decision with regard to the settlement is concerned, and hence list this matter up to 2 weeks.
Great.
Ananda KMR Vijay Kumar.
Kindly place for 2 weeks time. Kindly place for 2 weeks time. ಎರಡು ವಾರ ಟೈಮ್ ಕೊಡಿ ಸ್ವಾಮಿ. ಸೀನಿಯರ್ ಸ್ವಲ್ಪ ಹೆಲ್ತ್ ಅಪ್ಸೆಟ್ ಆಗಿದೆ.
ಯಾಕ್ರಿ?
ಅವ್ರಿಗೆ ಹೆಲ್ತ್ ಅಪ್ಸೆಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಏನೋ ಡೈವರ್ಜೆಂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಲ್ವಾ?
ಹೌದು ಸ್ವಾಮಿ.
Decreed as owner and permanent injunction was granted. Appeal ಅಲ್ಲಿ ರಿವರ್ಸ್ ಆಗಿದೆ. Call for records, issue notice. ಏನ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ನೋಡಿ. ನೋಟ್ ಆಫೀಸ್ ಹ್ಯಾಸ್ ರೈಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇನ್ ಸಿಪಿ ನಲ್ಲ ನಿಮ್ದ್ರಲ್ಲಿ. SPF holder copy to be produced ಆಫ್ಟರ್ ದಿ ವಕಾಲತ್ ಅಂತಿದೆ. ಮೋಸ್ಟ್ಲಿ ನಿಮ್ ವಕಾಲತ್ ಕೇವಿಯೇಟರ್ ಸೈನ್ ಮಾಡ್ರ GPA ಹೋಲ್ಡರ್ ಕಾಪಿ ಹಾಕ್ಬೇಕಲ್ಲ. ಹಾ, counsel for respondent is directed to file the copy of SPA since office has raised the objection. Madhusudan Rao Suyog Harle.
Maybe kindly taken up next week, my lord.
ಯಾಕ್ರಿ ಆಗ್ಲೇ
Next week, Martin.
appellant counsel seeks time, list the matter up to 2 weeks. 93 Rajeshwara PN, Manjunath DM.
Suit for partition, madam.
1/4 in 1/3 share of the father ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು.
ಏನ್ ಎರರ್ ಏನೋ?
Error ಏನು ಅಂತಂದ್ರೆ the courts will not justify by holding that respondent number 1 and 2, that is plaintiff 1 and 2 are entitled share in the suit produced through they have admitted the case of defendant number 2, that is late Nanjunai, by filing adoption memo in OS number 184 of 84 with respect to prior partition and in view of the admission made in para 7 page 17 of cross examination of PW1 is not considered by that.
ಏನ್ ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ?
Madam. Page 17, madam. Page 17 of partition, madam. Trial court records has not come, madam. I will, ನಾನು OS 186 of 84 ಅನ್ನು ವಿಭಾಗ
OS 186 ಅಂತ ಬೇರೆ ಇದೆಯಾ?
ಹೌದು, OS 186 of 84 ನಾನು OS 186 of 84 ಅನ್ನು ವಿಭಾಗ ಕೋರಿ ಇದೇ ಕೋರ್ಟ್ ನಲ್ಲಿ ದಾಖಲು ಮಾಡಿದ್ದೆ ಅಂದ್ರೆ ಸರಿ. ಸದರಿ ದಾವೆಯನ್ನು ನನ್ನ ಅಣ್ಣನ ವಿರುದ್ಧ ಮಾತ್ರ ದಾಖಲು ಮಾಡಿದ್ದೆ ಅಂತ ನುಡಿದಿರುತ್ತಾರೆ. ಸದರಿ ದಾವೆಯಲ್ಲಿ 1 ಮತ್ತು 2ನೇ ವಾದಿಯನ್ನು ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ ನುಡಿದಿರುತ್ತಾರೆ. ಏಕೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ಅಂದ್ರೆ ಹೆಣ್ಣು ಮಕ್ಕಳಿಗೆ ಭಾಗ ಇಲ್ಲ ಅಂತ ಹೇಳಿದರು, ಆದ್ರಿಂದ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂತ ನುಡಿದಿರುತ್ತಾರೆ. OS 186 per 84 ರಾಜನ ಮತ್ತು ಇತರರು ಇದ್ದಾರೆ ಅಂದ್ರೆ ರಾಜನ ಮಾತ್ರ ಪಾರ್ಟಿ ಆಗಿದೆ, ಇತರ ಇತ್ತೀಚೆಗೆ ನುಡಿದಿರುತ್ತಾರೆ. ಸದರಿ ಈಗ ಯಾವಾಗ ವಜಾ ಗೊತ್ತಿಲ್ಲ ಅಂತ ನೋಡಿದ್ದಾರೆ, ಹಿಂದೆ ಆಗಿದ್ದೆವು. ಆದ್ದರಿಂದ OS 186 ಊರ್ಜಿತವಾಗುವುದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಕೋರ್ಟ್ಗೆ ಹಾಜರಾಗಿರಲಿಲ್ಲ, ಆದ್ರಿಂದ ಅದು ವಜಾ ಆಗಿರ್ತದೆ ಅಂದ್ರೆ ಸರಿ. ನನ್ನ ತಾಯಿ ಮತ್ತು ನನ್ನ ಅಣ್ಣ ಬಂದು ಬೇಡ ಮಕ್ಕಳು ಮದುವೆ ಆದ್ಮೇಲೆ ಭಾಗ ಕೊಡುತ್ತೆ ಅಂತ ಹೇಳಿದರು. ಜೊತೆಗೆ ನನ್ನ ತಾಯಿ ವಿಷ ಕೊಡೋದು ಸಾಯಿ ಅಂತ ಬೆದರಿಕೆ ಹಾಕಿದ್ರು. ಅದರಿಂದ ಸದರಿ ದಾವೆಯಲ್ಲಿ ಕೋರ್ಟ್ಗೆ ಹಾಜರಾಗಿಲ್ಲ ಅಂತ ನುಡಿದಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಏನಾದರೂ ಬರವಣಿಗೆ ಇದೆಯಾಗಿಲ್ಲ ಇಲ್ಲ ಅಂತ ನೋಡಿದಿರುತ್ತಾರೆ. ಸದರಿ ದಾವೆಯಲ್ಲಿ ವಾಪಸ್ ಪಡೆದುಕೊಳ್ಳೋದು ಸಲ್ಲಿಸಿದ್ದಾರೆ ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ ನೋಡುತ್ತಾರೆ. ಈ ರೀತಿ ಅರ್ಜಿ ಮೈಲಾಡ್ ನೆಕ್ಸ್ಟ್ ಪೋರ್ಷನ್ ಮೈಲಾಡ್, ಈ ದಾವೆಯಲ್ಲಿ OS 186 84 ಅನ್ನು ಮರುಸ್ಥಾಪನೆ ಮಾಡುವಂತ ಕೋರಿ ನಾನು ಯಾವುದೇ ಅರ್ಜಿಯನ್ನು ದಾಖಲು ಮಾಡಿಲ್ಲ. ನಾನು ಮನೆಯ ನಂಬರ್
ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಅದೇನ್ ಮೆರಿಟ್ ಮೇಲೆ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ, ಹೌದಾ?
ಹೌದೌದು.
ಆಯ್ತು, ಮತ್ತೇನು?
ಮತ್ತೆ ಇದೇನು ಅಂತಂದ್ರೆ ನಮಗೆ ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 17 ಅಲ್ಲಿ ಮೈಲಾಡ್ it is admission that there was a prior partition.
What is your ground in second appeal counsel?
Prior partition ಆಗಿತ್ತು ಅಂತ ನಾವು ಹೇಳ್ತೀವಿ.
Prior partition ಆಗಿಲ್ವಲ್ಲ, ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರು ಕೂಡ ಅದೇನು ಮೆರಿಟ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಆಗಿಲ್ವಲ್ಲ, ಅಡ್ಜುಡಿಕೇಶನ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ ಇದೆ page 17 of the cross examination page 17 ಮೇಡಮ್.
ಈಗ ಓದಿದ್ರಲ್ಲ ಅದೇ ಅಲ್ವಾ, ಅದೇನು ಡಿಸೈಡ್ ಆಗಿಲ್ಲ ಮೆರಿಟ್ಸ್ ಮೇಲೆ. Earlier suit.
ಇಲ್ಲ ಆಗಿದೆ.
Plaintiff number 3 herein had filed suit in OS number 186 of 1984. ಹೌದಾ?
84. ಇದರಲ್ಲಿ
ಎರಡು ಒನ್ ಅಂಡ್ ದಿ ಸೇಮ್ ಅಂತ ನಿಮ್ಮ ಎಕ್ಸಿಬಿಟ್ D and 6 ಅನ್ನ ರಿಲೇ ಮಾಡ್ತೀರಿ, ಹೌದಾ?
ಅಡಾಪ್ಷನ್ ಮೆಮೋ ಫೈಲ್ ಮಾಡಿದ್ರು ಅಂತ. ಅಡಾಪ್ಷನ್ ಮೆಮೋ ಫೈಲ್ ಮಾಡಿದ್ರು. ಅಡಾಪ್ಷನ್
ಮೆಮೋದಲ್ಲಿ ಏನಂತ ಮಾಡಿದ್ರು?
ಅಡಾಪ್ಷನ್ ಮೆಮೋ ಫೈಲ್ ಮಾಡಿದ್ವಿ ಅಂತ ಇದೆ.
ಏನ್ರಿ ಅರ್ಲಿಯರ್ ಸೂಟ್ ಅಲ್ಲಿ ನೀವೇನೋ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ ಅಂತ ಅಡಾಪ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಂತಲ್ರಿ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ಎಕ್ಸಿಬಿಟ್ D12 when the suit was filed in OS number 186 of 1984. Plaintiff number 1 and 2 have adopted the written statement filed by the second deceased defendant herein. It stated that there was already a partition on 8/8/1974 and the third plaintiff claimed that there was family arrangement and separate kitchen and residence but sought partition. Both the courts below committed perversity in holding that there is no partition at all. Earlier ನೀವು ಸೂಟ್ ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ಪಾರ್ಟಿಷನ್ ಇದ್ದಾಗ ಮತ್ತೆ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಹಾಕ್ತೀರಿ ನೋಡಿಲ್ಲ ಇಬ್ರು ಬಂದು ಇಲ್ಲಿ ಓದಿರೋ ಏನ್ ಮಾಡೋದು
ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಮಾಡಿ.
Respondent counsel 6 times list this matter after 2 weeks.
In the meantime, call for record.
Records ಹಾಕ್ಬೇಕು ಹೇಳಿ ನೀವು ಫಸ್ಟ್ ಹೇಳಿ.
ಅದರಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಎಲ್ಲ ಹೇಳಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ.
ಆಯ್ತು ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್
Please.
ರವೀಂದ್ರ ಪ್ರಸಾದ್ ಚಂದ್ರಶೇಖರ್.
The appellant seeks for an week's accommodation. Week's accommodation.
Okay.
Inconvenience.
Declared owner confirm ಆಗಿದೆಯಲ್ರಿ? Declared as owner and permanent injunction was granted. Why one time?
Nothing is left.
Why one time ಅಂದೆ?
Revenue court ಇದಾಗಿದೆ. It has gone in favor of respondent. ಅವರೇ ಹೇಳಿದ್ದಾರೆ.
Weeks.
Why one time break counsel ಹೇಳಿ reason ಹೇಳಿ.
Reason.
21 ಅಲ್ಲಿ ಹಾಕಿದ್ರು.
Hello.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದಕ್ಕೆ 3 years.
ಇದು ನಿಮ್ ಪುಣ್ಯ ಬರೀ 3 ವರ್ಷದಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಆಗಿದೆ 6 ವರ್ಷ.
No, that's court fees concern, my lord, there was a pending long.
ಆಯ್ತು ಹೇಳಿ ಏನ್ ಗ್ರೌಂಡ್ ಏನ್ ಹೇಳಿ.
No, thing is, may be taken up tomorrow.
What is your defense in the written statement?
Written statement that was not considered, my lord, that the contention was not raised ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಮತ್ತೆ
ಅಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ may be taken up tomorrow.
Counsel 6 times, counsel for respondent present, list after 2 weeks. Srihari. Dismissed, confirmed.
My lords, I'm seeking time. I could not go through, my lords. I could not go through. I'm seeking time.
Appellant counsel 6 times, counsel for respondent present, list after 2 weeks.
I will
serve ಮಾಡಿಲ್ವಾ?
I will serve it.
Appellant counsel is directed to serve the copy of the appeal memo on the counsel for the caveator.
Please.
Forthwith. Next. Sidmalappa C. Shankar Reddy. ಅವರೇ ಅಲ್ವಾ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಅಲ್ವಾ? ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಟೈಮ್ ಕೇಳಿದ್ರಿ, ಇವತ್ತು ಅವರೇ ಇಲ್ಲ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಅಬ್ಸೆಂಟ್, ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪ್ರೆಸೆಂಟ್, ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks. MB Chandrachud. Dismissed OS 160 of 2012, OS 92.
Plaintiff's appeal. Suit for declaration and injunction. There were 2 suits filed by the plaintiff as well as the defendant number 1.
Both. OS 160 of 2012 and OS 92 of 2013.
The trial court holds that I am in possession of the property, I have put up the construction. However, the suit has been dismissed on the ground I did not prove the title. As well as the defendant also not proved the title. The appellate court reversed the finding on the ground mandatory injunction is enough to sought for declaration of possession is concerned. An application has been filed before the appellate court for amendment of the plaint. That has not been allowed. However, the decree has been granted for the possession is concerned. Kindly see paragraph.
But dismissal of OS is confirmed. OS number 160.
ಇನ್ನೊಂದು ಅಪೀಲ್ ಇದೆ. ಇನ್ನೊಂದು ಅಪೀಲ್ ಇದೆ.
ಹಾಕಿದಾರೆ ಈಗ?
ನಾನೇ ಹಾಕಿದ್ದೆ.
ನೀವೇ ಹಾಕಿದಿರಿ? ಎಲ್ಲಿದೆ ಅದು ಹೇಳಿ. ಎರಡು ಒಟ್ಟಿಗೆ ಲಿಸ್ಟ್ ಮಾಡೋದು. RSA ನಂಬರ್?
RSA ನಂಬರ್ ಇಲ್ಲಿದೆ.
ಏನು ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ? ನೀವು RA 64 ಮೇಲೆ ಹಾಕಿದಿರಿ ಈಗ.
ಹೌದು. RSA ಇನ್ನೊಂದು, ಐ ಆಮ್ ಸಾರಿ.
RA 19 ಮೇಲೆ ಒಂದು ಹಾಕಿದಿರಾ?
RSA
ಹ್ಮ್
19 ಒಂದು ಹಾಕಿದ್ದೀನಿ, ಅದನ್ನ
ನಮ್ಮಲ್ಲೇ ಗೊತ್ತಾಗುತ್ತೇನ್ರಿ ನೋಡ್ರಿ ಇದ್ರಲ್ಲಿ.
ಎರಡು ಒಂದೇ ದಿವಸ ಫೈಲ್ ಮಾಡಿದ್ದು.
ಒಂದೇ ದಿವಸ 1822.
ಹೌದು.
Open ಮಾಡಿ ನೋಡೋಣ. RA 19 of 2019 on the file of Senior Civil Judge and Principal JMFC KGF. RA 19 of 2019. OS ಬೇಕಾ?
OS number 92 of 13.
OS ಇನ್ನೊಂದು 92 ನಾ?
No.
92 of 13.
OS 160 of 12. ಎರಡಿದೆ. 160 of 12.
160 of 12 ಅದು. The counsel appearing for the appellant would submit that another RSA is filed against the common judgment passed in RA number 19 of 2019 and RA number 64 of 2020. And hence list the other RSA along with this RSA. A number code, number collect ಮಾಡ್ಕೊಂಡು ನೋಡಿ ನೀವೇ ತಗೊಂಡು ನೋಡ್ತೀರಿ ನೋಡಿ.
ಮಧ್ಯಾಹ್ನ
List up to 2 weeks.
please.
99. BS Nagraj. Dismissed and confirmed ಹೇಳಿ.
Next week ಮೇಲೆ. Next week ಮೇಲೆ.
ಎಲ್ಲರಿಗೂ ಮೂಡ್ ಹೋಗ್ಬಿಡ್ತಾ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 time list up to 2 weeks. 100. ಅಲಾ ಬಕ್ಸಾ.
Plaintiff's appeal, my lord.
ಹ್ಮ್
Plaintiff number 1 is the widow and appellant number 1 is the widow and other appellants are the children, my lord.
ಹ್ಮ್
Respondent number 1 is the GPA holder of my deceased husband, my lord.
ಹ್ಮ್
He executes sale deed after the GPA is cancelled in favor of the respondent number 2, my lord.
GPA was cancelled on what date?
It was cancelled in 2009. Yeah, 31st August 2009, my lord.
31/8.
31/8/2009, my lord.
9.
Yes, my lord.
Sale was made on.
Sale deed is executed in 2010, my lord. Sale deed.
That is on 15/3.
Please, my lord. 15/3/2010.
Cancellation of sale deed ಅಂತ ಇದೆಯಲ್ರಿ ಇಲ್ಲಿ.
ಹೌದು sir. Suit is for cancellation of the
against the
sale deed.
defendants for cancellation of
Please,
sale deed dated 15/3.
15/3.
Ah.
My husband died on 28/12/2011, my lord.
Hmm.
Now, my lord, the defendant's respondent's contention is, my lord, at the time of execution of the GPA,
Hmm.
the GPA which was executed, my lord, is irrevocable GPA. My lord, the GPA may be perused, my lord, it is not an irrevocable, no consideration, no possession was delivered, my lord.
Hmm.
Only a mere word in the GPA, my lord, irrevocable anta ಇಲ್ಲಿ one word ಇದೆ ಸ್ವಾಮಿ. But based on that, my lord, without,
ಅವಾಗೆಲ್ಲ ಹಂಗೆ ಸೇಲ್ ಮಾಡ್ತಾ ಇದ್ದಿದ್ದು.
please, my lord,
ಸೇಲ್ ಮಾಡಕ್ಕೆ ಡಿಫಿಕಲ್ಟೀಸ್ ಇದ್ರೆ
please, my
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಸೇಲ್ ಡೀಡ್.
No, my lord, the sale, my
ಮಾಡ್ಕೊಟ್ಟು
lord, the sale agreement is fabricated where, my lord, defendant, respondent number 1, he sets up an agreement in favor of his own wife, my lord.
Hmm.
In the year 2000, the sale consideration is 1,50,000 shown, my lord.
Hmm.
Now in the year 2010, my lord, he sells the property for 1 lakh rupees lesser than the price which was agreed in 2010, my lord.
Hmm.
That too, which agreement that he has set up for his own wife.
ಕ್ಯಾನ್ಸಲೇಷನ್ ಯಾವ ರೀತಿ ಮಾಡಿದ್ರಿ? ಯೂನಿಲೇಟರಲ್ ಕ್ಯಾನ್ಸಲೇಷನ್
By registered
Attention of
agreement,
defendant that it
registered
was-
cancellation and legal notice is issued, my lord. Lord, the
It
court
was
did
not
not.
only executed for execution of the decree passed in OS number 85/95, but also sale of property in
Yes,
favor
ma'am.
of prospective purchaser.
This
And also
doc,
for certain other purposes, but
Yes,
not
ma'am.
for the purpose as deposed by the DW1.
these documents, my lord, by 41 rule 27, my lord, were produced, my lord. The first appellate court, my lord, has rejected, my lord. Those GPA execution decree OS ಅಲ್ಲಿ ಇವ್ರಿಗೆ GPA ಕೊಟ್ಟಿದೀವಿ ಅಂತ he had not at all acted upon. We filed those all certified copies, my lord. The court 4127 applications is rejected, my lord. Complete fraud was played by the respondent 192, my lord, to take away the property rights of a widow, my lord. First appellate court, my lord, whatever the judgment was passed by the trial court, my lord, the same paragraph number 17, ಹಂಗೆ copy paste ಮಾಡಿ ಹಂಗೆ ಬರ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಈ judgment is right ಅಂತ ಸುಮ್ನೆ ಬರ್ಬಿಟ್ರು ಸ್ವಾಮಿ. Issue number 1, 2, 3, 4 and 6 ಎಲ್ಲ ಸರಿಗಿದ್ದಾವೆ. Additional number ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆ, ಲಾಜಿಕ್ ಆಗೇ ಇದೆ ಅಂತ ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ. Para number 7, it has not appreciated in the manner, my lord. Mainly, my lord, irrevocable GPA ಇಲ್ಲ ಸ್ವಾಮಿ. Have carried the certificate of the exhibit, my lord.
ನಿಮ್ಮ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಇರ್ರಿವೋಕಬಲ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಅಂತ.
My lord, now that needs to be interpreted, my lord, nomenclature, my lord, different, my lord, not even single rupee sale consideration. The possession is
Then
given,
why
my
you
lord.
have executed the irrevocable power of attorney if you have not received the sale consideration?
Lord, now document,
Huh?
my lord, document
What
itself
made
is,
you to execute the irrevocable power of attorney?
lord,
Huh?
uneducated illiterates, my lord.
You're uneducated.
Now the word, my lord, in the head on the document, my lord, it is not mentioned, my lord. In the middle, my lord, somewhere he has included the word irrevocable, my lord. Now that ought to have been appreciated by the trial court and the, my lord, the first appellate court, my lord. Whether the documents needs to be interpreted, my lord, whether there is a coupled of interest, my lord. Property,
ನ್ಯೂಸ್ ಪೇಪರ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
newspaper ಅಲ್ಲಿ it is not given, my lord. Legal notice ಕೊಟ್ಟಿದ್ದಾರೆ, GPA ಇದು ಮಾಡಿದ್ದಾರೆ ಕ್ಯಾನ್ಸಲ್.
ಸರ್ವಿಸ್ ಆಗಿರೋದಕ್ಕೆ ಏನೋ ದಾಖಲೆನೇ ಕೊಟ್ಟಿಲ್ವಲ್ಲ, ನೀವು ನೋಟಿಸ್ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ ಹೇಳ್ತೀರಿ.
My lord, the document is produced, my lord. Exhibits were produced, my lord. He now, he says,
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಸಾಲದ್ರಿ, ಜಾರಿ ಆಗಿರೋದಕ್ಕೆ ಏನಿದೆ?
but whatever the address that was,
ನೋಟಿಸ್ ಕಾಪಿ ರೆಡಿ ಮಾಡ್ಬಿಟ್ಟು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಆಗ್ತದ?
ಅದು GPA ದಲ್ಲಿ ಏನ್ ಅಡ್ರೆಸ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ, that same address is
ಸರ್ವಿಸ್ ಇದೆಯೇನ್ರಿ? ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ
post.
ಬಿಫೋರ್ ವಿಡ್ರಾಯಲ್? ಇಲ್ಲ ಅಂತಾನೆ ಕೋರ್ಟ್ನವ್ರು ಬರ್ದಿರೋದು.
My lord, it is here, my lord. Post registered document, my
ಕೊಡಿ
lord.
ಕೊಡಿ
To the
ಅದೇನ್
post,
ನೋಡೋಣ.
my lord. Main GPA was not interpreted, my lord. Nomenclature of the document was not read, my lord, properly, my lord.
ಏನಿದೆ ಇದ್ರಲ್ಲಿ? ಏನ್ ತೋರಿಸಿದ್ರಿ ನೀವು?
That is what is the post that we have sent to the.
ಪೋಸ್ಟಲ್ ಲೆಟರ್ ಇದು.
ಹೌದು, legal notice is 1 page earlier, my lord. 1 page
ಜಾರಿ
earlier.
ಆಗಿದೆಯಾ?
Please, my 1 page earlier legal notice is also there, my lord.
ಲೀಗಲ್ ನೋಟಿಸ್ ಇದೆ ರೀ, ಇದು ಜಾರಿಯಾದ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ ರೀ ಇಲ್ಲಿ?
ಅವ್ರ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಅದು ಕವರ್ ಬಂದಿದೆ ಸ್ವಾಮಿ.
That's what the court has observed.
Now, only since he has the knowledge of the cancellation, my lord, immediately he registers the sale deed, my lord. If not, my lord, from the year 2010, my lord, he would have executed the document, my lord. After the cancellation, my lord, knowledge only, my lord, immediately he cancels, he registers the sale deed, my lord. This, my lord, the surrounding circumstances are not considered, my lord. Needs to be appreciated by this court, my lord. Irrevocable GPA Allah anta ಹೇಳ್ಬಿಟ್ಟು nomenclature document if perused, my lord, it could be demonstrated, my lord. That too, the agreement of sale itself was not produced before the court, my lord, as an exhibit.
Irrevocable power of attorney ಕೊಟ್ಟು right to sell the property also you have given. Now you are telling that the same is cancelled ಅಂತ without Suit was also filed in 2013.
2010 sale deed, my lord, 13 it is filed, my lord.
That's all. Totally ಏನಿಲ್ಲ.
My lord, notice
The
may be
appellant
issued at
counsel
least,
and
my
also
lord.
the counsel appearing for the
My lord, notice is not ordered, my lord.
respondent. Huh?
Notice no, ಇನ್ನ ಹೋಗಿಲ್ಲ ಸ್ವಾಮಿ, delay.
Please ಹೋಗಕ್ಕೆ ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ.
My lord, now
Matter is listed for
GPA may be
admission, I
perused, my
heard.
lord, if you honor peruse as GPA, my lord. GPA may be perused.
Factual matters of case of plaintiff before the trial court while seeking the relief of declaration and permanent injunction,
My lord, may I request to peruse the GPA, my lord.
read the trial court to cancel the sale deed dated 15/3/2010 executed by defendant number 1 in favor of defendant number 2.
My lord, may have it tomorrow, my lord.
The factual
I
matters
rely
of
on
the
the
case of
judgment,
the
my lords.
plaintiff is that the plaintiff number 1 is the widow of late Muniappa and the plaintiff number 2 and 3 are the sons of Muniappa.
My lord, may have it tomorrow, my lord. I
Died on
rely on the judgment, my lord.
28/12/2011.
Nomenclature of document needs to be looked
It is
into, my lord.
contended that half portion of suitable property is ancestral property of Muniappa and other half portion of the suitable property was purchased by Muniappa from Rangappa,
My lord, may I
Govindappa
request for
and
tomorrow, my
Basappa
lord.
under separate sale deeds. Muniappa was in possession of the suitable property and after his death plaintiffs by playing Kandayam are in possession of the suitable property.
My lord, may
It
at
is
least
also
pass over the
contended
matter, my
that
lord.
one Venkat Ramanappa being the adjacent land owner on the northern side of the suitable property illegally constructed the building there. In this regard, for declaration and mandatory injunction, Muniappa instituted OS 85 of 1989 on the file of civil judge and JMFC Ramanagara against Venkat Ramanappa. The said suit was decreed in favor of Muniappa on 7/4/2000. It is also contended that land Muniappa preferred execution petition to execute the said decree on 28/7/2000 and the court passed order for demolition of the illegal construction through the court commissioner. It is contended that defendant number 1 and late Muniappa were friends. The defendant number 1 had knowledge of the proceedings in OS number 85 of 1999 and the execution case. As such, Muniappa requested the defendant number 1 to assist Muniappa and accordingly defendant number 1 promised Muniappa that he would demolish the illegal construction and recover the possession from the Venkat Ramanappa. Then the husband of the plaintiff number 1 Muniappa executed general power of attorney with respect to the suitable property on 21/8/2000. It is also contended that said power of attorney only for the purpose for which was executed. But the defendant number 1 has acted beyond the purpose of the said general power of attorney. Hence, Muniappa cancelled the registered general power of attorney on 31/8/2009 and also issued the legal notice on 13/1/2010 to the defendant number 1. The defendant number 1 intentionally has not received the said notice. The defendant number 1 had no right to deal with the said suitable property as Muniappa had cancelled the power of attorney on 31/8/2009. In spite of it, defendant number 1 executed sale deed in favor of defendant number 2 on 15/3/2010. It is contended that plaintiffs are in possession and enjoyment of the suitable property and defendants never in possession. The defendants appeared and filed the written statement admitting the relationship between the plaintiff and late Muniappa. However, it is contended that suitable property consisted of a small house and vacant land. Late Muniappa had taken kata in respect of the said property. It is also contended that Venkat Ramanappa was the owner of the adjacent property to the said property and he had encroached upon a portion of the property. Also, filing of the suit is also admitted. However, it is contended that on 27/2000, late Muniappa entered into an agreement of sale in respect of the suitable property with the wife of the first dependent for consideration of ₹1,25,000. On the date of the sale agreement, late Muniappa received ₹50,000 advance consideration from the wife of the first dependent At that time, there was an ex parte decree obtained by late Muniappa against Venkataramanappa for removal of encroachment from a portion of the plain scheduled property. Since Venkataramanappa was an influential person, late Muniappa found it difficult to get the decree executed. As such, late Muniappa approached the defendant number 1 after entering into the sale agreement with the wife of the first defendant to get the decree executed by meeting the cost of removal by whatever means permissible in the course of execution. Late Muniappa then executed the registered irrevocable power of attorney in favor of the defendant. In pursuance of the power of attorney, first defendant was required to get the decree executed and encroachment removed by incurring the cost, which was to be recovered by sale of the suitured property and also for recovery of rupees 50,000 paid earlier as under the agreement of sale dated 27/2000.
Lord, the agreement is
The
not
first
produced,
defendant
my
took
lord.
steps in the execution in the third week of August 2000. And he entered the work of removal of encroachment to Gopalagoda, who was required to assist the commissioner appointed by the court. The said Gopalagoda engaged about 100 skilled workers and also a JCB and a Tata Sumo vehicle with a driver by name Ramesha for the safety of the first defendant was appointed. At the time of execution of delivery warrant, driver Ramesha remained at a distance spot into a Tata Suma in which the defendant number 1 had kept his brief case containing his documents such as original agreement dated 27/2000 and cash rupees 40,000. One Srinivasa Gowda, who was ill disposed towards the first defendant, tried to create a scene at this time of execution of delivery warrant and sent some messages to the driver Ramesha and made him to go to the spot by leaving the car. The said Srinivasa Gowda, taking advantage of the absence of the driver, took away the car and brought the car back at midnight to the house of the first defendant at Hesragatta. And on verification, it was found that the briefcase was missing and cash and some documents, including the original agreement, were lost by the first defendant. In this regard, the second defendant lodged a complaint and defendant number 1 incurred an expenditure of rupees 1,50,000 for execution of the delivery warrant. And this was recoverable by the first defendant out of the sale proceedings of the property as agreed at the time of the execution of general power of attorney. The defendant number 1 on 15/5/2009 entered into an agreement to sell with the second defendant for the sale of the suitural property as late Muniappa failed to reimburse the first defendant the cost incurred by him in the execution of the delivery warrant and to repay the advance received by him under sale agreement dated 27/2000. The consideration for sale agreement is dated 15/5/2009 was rupees 1 lakh. On 15/3/2010, defendant executed the sale deed in favor of second defendant and appropriated the sale consideration towards the refund of the advance as well as the expenses incurred in the execution case. That late Muniappa was still due to pay to the first defendant towards balance of expenses incurred executing delivery warrant. Accordingly, the first defendant got issued the registered letter dated 34/2010 to Muniappa demanding rupees 55,000 along with interest at 18% per annum. The said letter was received by Muniappa, but he neither paid balance with interest nor repudiated the transaction of sale nor brought to the notice of the first defendant about the so-called cancellation of general power of attorney till his death on 28/12/2011. The trial court, taking into note of pleadings of the plaintiff and defendant, also framed the issues and also additional issues and allowed the parties to lead evidence. The trial court, having considered both oral and documentary evidence available on record, and not accepted the case of the plaintiff and accepted the defense of the defendant regarding execution of irrevocable power of attorney and dismissed the suit. Being agreed by the said judgment and decree of the trial court, an appeal is filed in RE number 19/20. And first appellate court, also having considered the grounds urged in the appeal memo, framed the point for consideration, particularly with regard to the execution of GPA and also the execution of sale deed in favor of defendant number 2 by defendant number 1, and comes to the conclusion that defendant number 2 is the bona fide purchaser of suitural property for the value, and also judgment and decree of the trial court is justifiable and justifiable. And also comes to the conclusion that defendant number one proved that late Muniappa executed irrevocable GPA dated 18/8/2000 with right to sell the suit scheduled property. And dismiss the appeal filed by the appellant. Being agreed by these two concurrent judgment, the present appeal is filed. And main contention of the counsel appearing for the appellant that GPA was cancelled and the sale deed was executed subsequent to the cancellation of the general power of attorney. And both the courts failed to take note of the material on record while answering the issues and also the point for consideration. The counsel also vehemently contend that even appellate court also committed an error in rejecting the application filed under Order 41 Rule 27. And sale deed was executed in the year 2010 and approached the court in the year 2013, which is well within the limitation under Article 59 of the Limitation Act. And even in spite of it, the first appellate court committed an error in coming to the conclusion that suit is barred by limitation, and hence this court has to admit and frame substantive question of law. Having heard the appellant counsel and also on perusal of material available on record, and trial court also while answering the issues taken note of the very execution of irrevocable power of attorney. And no dispute with regard to the execution of GPA in favor of the first defendant. By the said Muniappa. And no doubt, trial court also while answering issue number one comes to the conclusion that half of the suit scheduled property was purchased by Muniappa and the remaining half was got by him in a partition. And even answered the issue number two as negative, since the pleading made by the plaintiff in paragraph number 5 and 6 of the plaint has not been proved. And also answered the issue number 3 that as negative in coming to the conclusion that before cancellation of the power of attorney, no notice was served. And also comes to the conclusion that power of attorney is issued is also an irrevocable power of attorney. And the specific contention was also taken by the defendant in the written statement that the same is irrevocable power of attorney, and also specifically pleaded with regard to the earlier decree and taking up possession by filing an execution petition. And in paragraph number 27, trial court comes to the conclusion that exhibit P3 recitals is very clear that power of attorney is an irrevocable general power of attorney.
Lot consideration is not
And
given
also
under the GPM.
Power of sale is also given in terms of the said power of attorney. And the exhibit P4 cancellation. And cancellation of GPA. The exhibit P4 is the power of attorney.
P4 is cancellation
And
of
P4
GPM.
cancellation, P3 is the power of attorney.
Please, yeah.
And exhibit P4 is the cancellation of GPA dated 31/8/2009. And no doubt legal notice was issued to the defendant number 1 on 31/1/2010. But the same was not served. And the same has been discussed in paragraph number 35 of the judgment of the trial court. And when the document was executed and the same was registered by giving a power to sell the property, and the very contention that the power of attorney is given for other purpose and not for the purpose of selling of the property was not accepted by the trial court. Even first appellate court also, having reassessed the material available on record, taken note of section 200 of
Contention, my lord.
202 of Contract Act, while answering point number 2 and 3 in elaborate discussion was made, even discussing the scope of section 202 of Indian Contract Act. And also taken note of in terms of exhibit P3 was executed with a right to sell the suit scheduled property. And the same has not been cancelled or terminated in view of provision under section 202 of Indian Contract Act. And hence answered the point number 2 as negative and point number 3 in the affirmative. The first appellate court also not only considered the question of fact and also the question of law while dismissing the appeal, and elaborate discussion was made. And also taken note of sale deed executed by D1 in favor of D2 based on the power of attorney, and the power of attorney is a irrevocable power of attorney. And when such finding is given by the
Lord, kindly peruse to the GPA, my lord. No sale consideration or the possession is given, my lord.
GPA ನಲ್ಲಿ ಯಾರು ಬರೀತಾರ್ರಿ ಅದನ್ನ?
My lord, if that comes only the irrevocable GPA coupled with interest ಆಗೋದು ಸ್ವಾಮಿ, as per the
Once you have
contract act.
executed irrevocable power of attorney, that means you have received the consideration and all.
My lord, that should come from the agreed document, my lord, not even evidence is led
Counsel,
with
you have
regarding
argued,
to.
I heard, and dictating the order, don't interfere with. And appellate court also in detailed considered even point for consideration, point number 9 also.
Lord, the trial, first appellate court
answer
and
the
trial
same
court
as
also
lately
ignored the
as
same, my lord. If this court also
affirmative.
ignores in the same manner, my lord.
And there is a concurrent finding with regard to the factual aspect and as well as the question of law. And when such being the case, I do not find any ground to admit and frame any substantive question of law. And hence, no ground is made out to invoke section 100 of CPC in view of the discussions made up by Pasi Palangoda. Appeal is dismissed.
Appellant, madam. Kindly next week, madam, today. Morning going for morning.
In mediation not settled,
Settle ಆಗಿಲ್ಲ sir.
appellant counsel 6 time and counsel for Kevetar counsel is present, list after 2 weeks.
Entry model will be extended.
Entry order ಇದೆಯಾ?
Yes, sir. Third
Entry
party
order
case.
extended till next date of hearing.
Yes.
Date after 2 weeks.
Yes.
RSA. Ramanujaya. Appellant counsel absent, list after 2 weeks. Ravi Shankar.
Here for 20 for appeal, concurrent finding, suit for declaration and cancellation of settlement and for execution. The power of attorney was executed by Surnana Adiga in favor of Sushila Somay. On the basis of power of attorney, a seal deed was executed in favor of the appellant on 23/1/2012. In the meantime, the Surnana Adiga principal has executed a settlement deed in favor of the wife, settling all the properties which was a subject matter of this. Now, therefore, a suit for declaration of my title and also for cancellation of the settlement deed was filed. The contention that the power of attorney cannot be revoked because under section 207 or 208 there is no revocation of power of attorney. The trial court as well as the first appellate, they actually the execution of power of attorney not disputed, execution of the sale deed is not disputed. The contention is that since the settlement deed was earlier to the sale deed, therefore the under section 3 of TP Act there is a notice, therefore there is a revocation of. without considering section 207 and 208. You will also may kindly see section 207 and 208. There should be an express revocation of power of attorney by the principal. This has been considered in recent judgment. It was disposed on 9/7/24, my lord. 207 and 208 by the Supreme Court. It is only on the basis, both the court has heard only on the basis of section 3. Section 3, bro, TP Act does not, it is only under section 207 and 208. Para 21, you will also. Para 16 only, 207 and 208 is extracted. And the trial court as well as appellate court relied upon the decision in Ratan Biswas that has been considered in this case. Para 21 is the implication of section 207 and 208. 207 and 208 has been considered by both the courts. In the absence of particular mode of suggested for revocation of authority of an agent, the manner adopted by the principal to revoke the authority of the agent must be one which is clearly unequivocally communicated to the parties to be effected such revocation that the agent authority has been withdrawn. In the framework of section 207 and 208 of the Act, the revocation or renunciation of the authority may be made by the express words or may be implied from the words and conduct of the principal, which is inconsistent with the continuance of agency. This is one facet of renunciation or revocation of authority of an agent. The other facet is governed by section 208 of the Act. 208 provides that for effective time and date of termination of the agent's authority and third parties. From the plain reading of section 208 infers that giving a effective to revocation upon the twin condition being satisfied, the communication to the agent, this is the important, communication to the agent, knowledge to a third party, one who deals with or likely to deal with the agent. Then the revocation of authority becomes known to the agent and the said third parties. Therefore, there is revocation ಮಾಡಿದೀವಿ ಅಂತಾನು contention ತಗೊಂಡಿಲ್ಲ. Then next, in other words, an idea in the mind of a principal to revoke cannot be considered as an implied revocation or renunciation of agency. There ought to be an act conduct of the principal which implies that the agency is revoked or withdrawn. If the revocation is expressed, such as a publication in the newspaper, public notice, advertisement, communication to the agent, the parties who deal with the agent have reasonable opportunity to know the revocation of the agency. ಇದ್ಯಾವುದು ಇಲ್ಲ. Section 3 of TP Act ತಗೊಂಡು ಅವರು both the court has held that it is a notice to the world, therefore the attorney will have a notice ಅಂತ.
Revocation of ಏನು? Settlement.
Power of attorney ಅಲ್ಲ, power of attorney.
Power of attorney who has executed?
Suryanarayana and Suryanarayana Adiga and his children have executed. Thereafter, they settle the property in favor of defendant, who is the wife of Suryanarayana Adiga.
Issue is also not framed with regard to the
Revocation. ಹೌದು. Section 3 ಮಾತ್ರ ಹೇಳ್ತಾರೆ. Section 3 since the settlement deed is registered, it is a notice to the world ಅಂತ. But agency ಇದ್ದಾಗ
yes, call for records, issue notice.
Interim order may be granted.
Interim order ಏನು?
Injunction ಕೇಳಿದೀನಿ. You will also may kindly see
dismiss ಆಗಿರೋ suit confirm ಆಗಿದೆ. What is
ಎರಡು ಕಡೆ in both the court ಅಲ್ಲಿ status quo ಇತ್ತು. You will also may kindly see the
status quo ಇದೆಯಾ?
ಇದೆ.
Read ಮಾಡಿದೀರಾ ನಿಮ್ಮ ಐಎನಲ್ಲಿ?
ಹೇಳಿದೀನಿ. Para 3 you will also may kindly see of the affidavit. I have also stated the date of the order. When I submit that I am in possession and enjoyment of social. Paragraph 3 of the affidavit of the enlargement.
I am in possession along with the suit applications.
The trial court initially issued a notice on the said application, and after its appearance or responded by order dated 19/4/2013, directed both the party maintenance of the suit. I said thereafter trial court dismissed the suit and I have challenged the same in appeal. First appellate court in the said appeal also.
Heard the appellant counsel on IA 1 of 2022, and counsel would submit that the appellant is in possession of the social property, and both the trial court as well as the first appellate court granted an order of status quo on 19/4/2023 and 8/7/2020 respectively, and hence An order of temporary injunction is to be granted and taking into note of amendments made in paragraph number 3 and 4 of the affidavit, and also sworn affidavit that there was an order of status quo by both the courts, it is appropriate to maintain the status quo till the next date of hearing.
It is a plaintiff's appeal, my lord. These two aspects have been ignored. The suit is for declaration of title and
Urgency
declaration.
ಇದೆಯಾ ಆಮೇಲೆ ಮಾಡ್ಬೋದು? Urgency ಇದೆಯಾ ಅಥವಾ?
ಆಮೇಲೆ ಮಾಡು.
ಹ್ಮ್
ವೆರಿ ಸಿಂಪಲ್ ಮ್ಯಾಟರ್ ಮೇಲೆ ರಿಟ್ ಹಾಕಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ defendants amongst themselves, including my property, plaintiff's property, get it settled in the before the Lok Adalat. That has been challenged. The first appellate court negative my
where it is challenged?
my lord,
Where it is settled and whether in
before the Lok Adalat, my lord. They
independent
filed a suit.
independent suit
House
is filed.
96. Issue has been framed regarding that.
He is the owner in possession of social property as an independent party entry compromising your party.
How this present plaintiff was not the party to that.
Not the party.
Party.
Ah.
He filed a suit after coming to know that.
About
The
the
trial court
compromise.
also dismissed the suit and first appellate court also. First appellate court
What the
observed
relief
that
you have sought in the original suit? Declaration of his title and also to declare that the compromise decree passed in OS number not binding. Reasoning ಏನು dismiss ಮಾಡಿದ್ಕೆ?
my lord, I directly draw your attention, my lord. Plaintiff
Erection of compound walls so and so.
issue number 2, my lord. Findings on page number.
Whether the plaintiff proves that the defendants are interfering with possession ರೀ ಅದು. Reasons ಏನು ಅಂದ್ರೆ dismissal writ ಹಾಕ್ಬೇಕು ಅಂತಾನ.
Writ ಹಾಕ್ಬೇಕು ಅಂತಾರೆ. If it is the interest, a party interested to the compromise, that holds good, my lord. That too before the same court, they have to challenge it by filing an application of fraud or influence.
Issue notice. Call for records. H. Mohan Kumar.
But the appellants before this honorable court are the defendants before the trial court. Respondent plaintiff filed a suit for recovery of money of rupees 4,08,500. It was the case of the plaintiff before the trial court that there had been a rental agreement between the plaintiff and the defendants. And the plaintiff had paid rupees 3 lakhs in advance. And he had purchased the furnitures for hotel business to the tune of 1,91,500. And he could not run the business for more than 2.5 months. And he vacated the premises and served a notice to the defendants. Lord, the defendants specifically contended that there was no agreement,
no
rent agreement.
No rent agreement.
There was no rent agreement between the parties. That had not been taken into consideration by the trial court. The trial court, by comparing
So
this.
the rent agreement, how you have delivered the possession in favor of the plaintiff? What is the basis for delivery of possession? If you admits the rent agreement, receipt of advance of rupees 3 lakhs will come to the light. That's why you have taken the contention that no rental agreement.
Not that the trial court, by comparing the signatures of the defendants in the wakalat as well as the agreement, comes to the conclusion that the the execution of the agreement has
Agreement.
been proved.
Yes. Court can compare under section 73 of the Evidence Act. What is the wrong?
My lord, the
What is the error in passing such an order? You made an attempt even to, to the extent of denying of your own document. That's what the observation. Yes, counsel, what is the error in the order? Concurrent finding with regard to the ಏನಿಲ್ಲಲ್ಲ grounds?
Lord, my contention is that the trial court ought not to have compared the signatures and concluded
ಮತ್ತೇನ್ ಮಾಡ್ಬೇಕಿತ್ತು ಹೇಳಿ?
that should have been referred to an expert opinion.
Then what about section 73? An attempt was made to make wrongful gain by denying the very signature available in the rental agreement. That's the reason only court has invoked section 73. ಏನಿಲ್ಲ ತಗೊಳ್ಳಿ. Heard the appellant
In
counsel.
addition to that, madam. Yes.
That is the only ground you have urged. Ought not to have invoked section 73 ಅಂತ. ಹೌದಾ?
In addition to that, madam, the plaintiff claims that he has purchased, he had purchased the furnitures for the purpose of hotel business, but he has sold the entire furnitures to the vendor of the furniture, and he has collected money from the vendors of the furnitures. And that has not been taken in consideration. And I have made an application for production of additional documents.
That's all. ಏನಿಲ್ರಿ ಕೇಸಲ್ಲಿ ಏನಿಲ್ಲ ಅಡ್ಮಿಟ್ ಮಾಡಕ್ಕೆ. Heard the sorry matter is listed for admission and I heard the counsel appearing for the appellant. The factual matters of case of the plaintiff before the trial court in the suit that there was an agreement between the plaintiff and defendants on 1/6/2008 and he has paid rupees 3 lakh to the defendants. And also he had invested an amount of 1,95,000 for improvement of a hotel. And also it is his contention that defendants have threatened the plaintiff to vacate the suit premises. And hence he filed the suit for the relief of recovery of money. And defendant filed a written statement and denied the very execution of rental agreement dated 1/6/2008. And also even disputed receipt of rupees 3 lakh. And also plead their unawareness as to the alleged investment made by the plaintiff to a tune of rupees 1,91,500. The trial court having given opportunity to both the counsel, both the parties, and also having considered both oral and documentary evidence, comes to the conclusion that the agreement is between the parties in existence and also even invoke section 73 of Evidence Act to compare the same and comes to the conclusion that there was an agreement. And having considered the material on record, including the spending of amount of rupees 43,741, granted the relief of the recovery of money to the tune of rupees 2,61,247 with 6% interest. Being agreed by the judgment and decree of the trial court, an appeal is filed in RA number 63 of 2018. And first appellate court having considered the grounds urged in the appeal memo, framed the point for consideration whether the trial court properly appreciated the oral and documentary evidence available on record, and whether the judgment and decree of the trial court requires interference. And on reassessing the both oral and documentary evidence available on record and also taking into note of the rent agreement and also compared the same with the wakalat, which is marked as exhibit P10. with agreement exhibit P1 and taking into note of the material on record also confirmed the judgment of the trial court in coming to the conclusion that trial court has not committed an error. Being agreed by the judgment and decree of the trial court as well as the confirmation order, present appeal is filed by the appellant counsel and main contention urged by the appellant counsel that invoking of section 73 of Indian Evidence Act for comparing the document exhibit P1 B and P1C as well as exhibit P10A is a erroneous approach and ought not to have compared the same and ought to have sent the document for the handwriting expert. And also contend that the trial court committed an error in coming to the conclusion that the plaintiff has proved for investing a tune of rupees 43,747 for the improvement of the hotel. And the very approach of the trial court as well as the first appellate court is erroneous. Having heard the appellant counsel and also on reasoning given by the trial court as well as the first appellate court, when the appellant denied the very execution of document exhibit P1, and when the signature is also marked through the witnesses, and also when the trial court compared the signature available in the wakalat as well as in the exhibit P1 comes to the conclusion that the signature available in exhibit P1 and exhibit P10 both are one and the same. No doubt there is a force in the contention of the appellant counsel that if any dispute and it is highly impossible for the court to compare the same, then court ought to have sent the document to the handwriting expert. But when the court is able to compare the same, that is signature available in exhibit P1 and exhibit P10, and both appear to be that of the same person, the court can exercise the power under section 73 of the Evidence Act. The court adopted the comparing of the signature, having entrusted with the job of the court to compare the same under section 73 of Evidence Act. I do not find any error committed by the trial court and also the first appellate court in considering both oral and documentary evidence available on record. Even appellant gone to the extent of denying his own signature. It is nothing but an attempt is made to make a wrongful gain. And hence I do not find any force in the contention of the appellant counsel that both the courts have committed an error in comparing the signature available in exhibit P1 and also exhibit P10 Wakalatnama. And hence I do not find any ground to admit and frame any substantive question of law. In view of the discussions made up, I pass the following order. Second appeal is dismissed. Next, 108. Urgency ಏನಿಲ್ಲಲ್ಲ? Next week? Entry ಮಾಡಿದ್ಯಾ? For want of time, list this matter in the next week. Interim order granted earlier is extended till next date of hearing.
appear for the respondent, my lord. ಸ್ವಲ್ಪ ಎಮರ್ಜೆನ್ಸಿ ಉಂಟು my lord ನಮ್ಮ
ಇದರಲ್ಲಿ ಏನು ಸ್ಟೇ ಏನಿಲ್ಲ
ಅಲ್ಲ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅವರು ಸಹ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಗಿದ್ದಾರೆ.
respondent
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಏನ್ ಬೇಕಾದ್ರೂ
is
ಮಾಡಬಹುದು.
very sick and aged lady, my lord. ತುಂಬಾ ಸಿಕ್ ಆಗಿದ್ದಾರೆ, ಇವತ್ತು ನಾಳೆ ಎಲ್ಲಿದ್ದಾರೆ? aged lady respondent.
ಆಯ್ತು ನೋಡೋಣ, ಮಧ್ಯಾಹ್ನ ಟೈಮ್ ಸಿಕ್ಕಿರ after the special bench, then I will see. ಆಯ್ತು, remaining matters at 2:30.
ಆಯ್ತು ಸರ್.
Remaining ಹೌದು ಹೇಳಿ.
Next week.
ಯಾವ್ದ್ರಿ ಹೇಳಿ? ಯಾವ
113 ಮಿಲಾನ್.
113.
Yes, Milan.
MB ಚಂದ್ರಚೂಡ್.
Yes, Milan. Next week.
ನೀವ್ಯಾರಿಗೆ?
I am for the K-Waiter.
K-Waiter counsel seeks time, appellant counsel present and
ಸಬ್ಮಿಷನ್
ಇಲ್ಲ ಅದೇನಾಗಿಲ್ಲ ಸ್ವಾಮಿ, ಇನ್ನ ಏನಾಗಿಲ್ಲ.
ಏನು ಮಾಡಲ್ವಾ?
ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲ ಮಾಡಲ್ಲ, ಏನು ಆಗಿಲ್ಲ, ಅದು
ಏನು ಆಗಿಲ್ಲ, ಬೇಡ.
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ. ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ.
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅಷ್ಟೇನೆ. ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮಾಡ್ರಿ ದಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Oblige.
110 ಹೇಳಿ. ನೀವ್ಯಾರಿಗೆ ಕನೆಕ್ಟೆಡ್? ಯಾರು ಸಂಕೇತ ಎಣಗಿದಾರ? ಕೇಳ್ತಾರೆ, ಕೊಡ್ಬೋದಾ? Appellant counsel in RSA 1923 of 23/6 time and counsel for the appellant in other appeal also present and list this matter after 2 weeks.
Submission, my lord. Serial number 51, my lord. Serial number 5162 arising out of same common order, my lord. The lordship has posted the serial number 15 for admission and ordered a notice in serial number 62, my lord. It is arising out of same common order. In serial number 62, there is IA for stay.
ಅವಾಗ್ಲೇ ಹೇಳ್ಬೇಕಿತ್ತಲ್ಲ.
My apologies, my lord.
ಆಯ್ತು ಈಗೇನ್
Not to interfere with agricultural law.
ಆಗಿದೆ ಅಷ್ಟೇ ದೊಡ್ಡ ಸರ್.
But both the petitions may be tagged along with.
ಯಾವ್ದು ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್.
Please. 51 and 62, my lord.
ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. 51 and 60.
2, my lord.
62.
Please.
List the both are arising out of the common judgment and hence both list the matters together.
Grateful.
36 ಅದೆಲ್ಲ ಆಮೇಲೆ ನೋಡೋಣ, ಈಗಲ್ಲ ಮಧ್ಯಾಹ್ನ.
My lord, pass,
ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ರೆ ಈಗ ಏನ್ ಮಾಡಕ್?
passed over matter. Serial number 75, passed over matter. I filed a list of additional document, kindly directly register to put up the matter.
ಪಾಸ್ ಓವರ್ ಯಾರು ಮಾಡಿಸ್ಕೊಂಡಿದ್ರು?
My lord,
ಪಾಸ್ ಓವರ್ ಯಾರು ಮಾಡಿಸ್ಕೊಂಡಿದ್ರಿ?
ಅದು ಲಾಸ್ಟ್ ಅಕೇಶನ್
ಇವತ್ ಪಾಸ್ ಓವರ್ ಯಾರು ಮಾಡಿಸ್ಕೊಂಡಿದ್ದು ಅಂತ ಕೇಳಿದೆ.
ಅದರ್ ಸೈಡ್ ಮಾಡ್ತಿದ್ದೆ.
ಅದರ್ ಸೈಡ್
ಹೌದು.
ಅವ್ರಿಗೆ ಅರ್ಜೆನ್ಸಿ ಇರ್ಬೋದು. ಇದಾರ ಅದರ್ ಸೈಡ್? ಮತ್ತೆ ಅದರ್ ಸೈಡ್ ಪಾಸ್ ಓವರ್
ಅರ್ಜೆನ್ಸಿ ಅದ ಲಾಸ್ಟ್ ಅಕೇಶನ್
ಕೌನ್ಸಿಲ್ ಅವ್ರು ಇದಾರೇನ್ರಿ? ಇದ್ರೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ, ಏರ್ ಮಾಡ್ತೀನಿ ಇಬ್ರದನ್ನು.
117.
ಪಾಸ್ ಓವರ್ ಅವ್ರು ಕೇಳ್ದಾಗ ನೀವು ಬಂದಿಲ್ಲ, ಅವ್ರ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಡೇಟ್ ಕೇಳಿದ್ರೆ ನಾಟ್ ಫೇರ್ ಯುವರ್ ಪಾರ್ಟ್.
My lord, 117, my lord.
ಏನಾಗ್ಬೇಕು ಹೇಳಿ?
Reporting of settlement ಅಂತಿದೆ.
ಏನಾಯ್ತು?
There is no chance of settlement.
ಅದರ್ ಸೈಡ್ ಇದಾರ?
ಇದಾರೆ.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ಲಿಲ್ವಾ?
ಆಗ್ಲಿಲ್ಲ.
ಆಯ್ತು ತಗೊಳ್ಳಿ. ಬೋತ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್. ಅದೇನ್ ಪಾರ್ಟ್ ಏನಾರ ಆಗಿದೆಯಾ?
ಇಲ್ಲ. For final.
Both council submits that there is no say element of settlement and hence list after 2 weeks.
Please.
ಯಾವ್ದ್ರಿ? ಈಗ ಏನ್ ಮಾಡಕ್ ಅಲ್ರಿ? ಏನಾಗಿದೆ ಈಗ? ಆರ್ಡರ್ ಏನಾಗಿದೆ ರೀ ಅದು? ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅಂತ ನೋಡ್ರಿ. ಈಗ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ರೆ ಈಗ ಏನ್ ಮಾಡಕ್ಕಲ್ಲ? ಲಾಸ್ಟ್ ಈಗ ಪೇಡ್ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡೋಣ? ಹೋಗಿ ಇವತ್ತು ಹೋಗಿ ಕಟ್ಕೊ ಬಂದ್ರ ಡಿಸ್ಮಿಸಲ್ ಆದ್ಮೇಲೆ? ಆಯ್ತು, ಏನ್ ಮಾಡಂಗಿಲ್ಲ, ವಿಕಾಲ್ ಹಾಕೊಳ್ಳಿ.
One not seven.
ಸಂದೇಶ್ ನಾಡಿಗ. ಇದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಅಲ್ಲ ಆ ತರ ನೋಟ್ ಮಾಡಿದಾರ? ಓಕೆ ಓಕೆ, ರೈಟ್, ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್. ಹಲೋ ಸರ್, ಕಲಬುರಗಿ ಬೆಂಚಿಂದ. ಹಲೋ, ಆಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆ ಮೇಡಮ್? ಆಡಿಯೋ ಕೇಳ್ತಾ ಇದೆಯಲ್ಲ ಮೇಡಮ್ ಕಲಬುರಗಿ ಬೆಂಚಿಂದ? ಇಲ್ಲ ನಿಮ್ಗೆ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಹಲೋ
ಹಲೋ ಮೇಡಮ್, ಆಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆ.
ನಿಮ್ ಬೆಂಚಿಂದ ಯಾವ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹೆಸರೇನು ಸರ್?
ಗವರ್ಮೆಂಟ್ ಅವಲಕ್ಕಿ ಅಲ್ಲ ಕಲಬುರಗಿ ಬೆಂಚಿಂದ
ಹಾ.
ಮೇಡಮ್, ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆಲ್ಲ ಮೇಡಮ್ ಜೊತೆ.
ಗೊತ್ತಾಯ್ತು. ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಅಂದೆ?
ಇಲ್ಲ
ಯಾರು
ಗೊತ್ತಿಲ್ಲ
ಇಲ್ವಾ?
ಮೇಡಮ್, ಇಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಮೇಡಮ್, ಟೆಕ್ನಿಷಿಯನ್.
ಆಯ್ತು ಸರಿ, ಓಕೆ.
ನೋಡಿದ್ರೆ ಕೇಸ್ ಮಾಡಿಲ್ಲ. ಮೊಬೈಲ್ ಫೋನ್ ಇಲ್ಲ, ಬೇಕಿತ್ತು ಮೊಬೈಲ್ ಮರ್ಡರ್ ಮಾಡಿದ್ರೆ ಅಂತ ಮಾಡಿ ಹೇಳ್ತಾರೆ. ಇದು ಮೋಟರ್ ಸೈಕಲ್ ತಗೊಂಡಿದ್ದಾರೆ, ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು ಮನೆಗೆ ಬರ್ತೀವಿ, ಮನೆಗೆ ಬಂದು ಸತ್ತಿದ್ವಿ. ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು ಸರೆಂಡರ್ ಆಗ್ತದೆ. ಮದುವೆ ವಿಷಯ 2 ಗಂಟೆ ಕೊಡೋದು ಯಾವುದಿದ್ರು ಮತ್ತು ಗೌರ್ಮೆಂಟ್ ಶಾಲೆ ಅಷ್ಟೊಂದು ಸಾಕ್ಷಿ ಮಾಡಲಿಲ್ಲ. ಅದು ಆಯ್ತು, ಬಂದು ಸಾಕ್ಷಿ ಮಾಡ್ಬೇಕಲ್ಲ. ಮನೆ ಬಂದೆ ಬಿದ್ದಿತ್ತು, ಏನೋ ಊಟಕ್ಕೆ ಬಂದೆ. ಕಷ್ಟನಾಗಿತ್ತು ಕಂಪ್ಲೇಂಟ್ ಬಂದು ಇದನ್ನೇ ಬರೋಣ ಅಲ್ಲೇ ಇಶ್ಯೂ ಯಾರಂದ್ರೆ ಏನು ಹೋಗ್ತಾರೆ ಬರ್ತಾರೆ. ಫೋಟೋ ಸರ್
ಸರ್ ಮೇಡಮ್ ಬಂದಿದ್ದಾರೆ.
ಮಾಡಿ ಇಲ್ಲ, ಡಿವಿಷನ್ ಬೆಂಚ್ ಮಾಡ್ತದೆ. ಫೈಲ್ ಕೊಡ್ತಾ
ಅಲ್ಲಿ ತೋರಿಸಿ ಅಂತ ಹೇಳಿ, ಅಲ್ಲಿ ವಿಡಿಯೋ ಆರ್ಗ್ಯುಮೆಂಟ್ ವಿಡಿಯೋ ಇಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದು ಅವ್ರು advocates ದು ವಿಡಿಯೋ ಇಲ್ಲ ಎಲ್ಲಿದೆ?
ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆ ಒಂದು.
ಇಲ್ಲಿ ತೋರಿಸ್ಬೇಕಲ್ಲ ನಮ್ಗೆ ತೋರಿಸ್ತೀವಿ ವಾಯ್ಸ್ ಬಂದ್ಮೇಲೆ ಅಷ್ಟೇ ಹೋಗ್ಬೇಕು. ಆಯ್ತು ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಕೊಡಿ 20.
ಇದೆ MD.
ಆಮೇಲೆ ಕ್ಯಾಮೆರಾ
ಹಾ?
ಸಾರಿ ಇಲ್ಲ ಪ್ರೊನೌನ್ಸ್ ಇಟ್ afterwards after that.
Yes,
Please.
Pertains to
Bangalore bench.
Bangalore.
Principal bench.
Bangalore and Kalburgi. I have read the papers.
Please.
You assist the court. What are the grounds you
Yes,
are
yes,
relying upon?
Yes. My lord, the gist of the complaint, I will take your lordship page number 10. The complainant PW1 is the husband of the deceased.
He came to know through someone else and lodged the complaint.
None of them are eyewitness. He had gone to outside for buying a motorcycle on that day. But history is different. I will take your lordship to one paragraph of the gist, page number 10.
Charge sheet.
ಹೊಸದುರ್ಗ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿಯ ಅಡವಿ ಸಿಂಗನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ಸಾಕ್ಷಿ 1 ಮತ್ತು ಕಾಲಂ 12 ನಮೂದಿಸಿ ಆರೋಪಿ ಒಬ್ಬರಿಗೊಬ್ಬರಿಗೆ ಸ್ನೇಹಿತರಾಗಿದ್ದು, ಆರೋಪಿಯು ಆಗಾಗ್ಗೆ ಸಾಕ್ಷಿ 1ರ ಮನೆಗೆ ಸ್ನೇಹ ವಿಶ್ವಾಸದಲ್ಲಿ ಬಂದು ಹೋಗುತ್ತಿರುವಾಗ ಸಾಕ್ಷಿ 1ರವರ ಹೆಂಡತಿಯಾದ ಅಂಬಿಕಾಳೊಂದಿಗೆ ಹೀಗೆ 2 ವರ್ಷಗಳಿಂದ ಅನೈತಿಕ ಸಂಬಂಧ ಇಟ್ಟುಕೊಂಡಿತ್ತು. ಆರೋಪಿ ಮತ್ತು ಸಾಕ್ಷಿ 1ರವರ
You can use mic. Other.
Oh, sorry, other my lords will not be able.
Madam can hear.
I know.
Yes, I can hear him. Yes.
Please, my lord.
Yes.
ಆರೋಪಿ ಮಧ್ಯೆ ಗಲಾಟೆಗಳು ನಡೆದಿದ್ದರಿಂದ ಇಟ್ಟುಕೊಂಡಿದ್ದು ಆರೋಪಿ ಮತ್ತು ಸಾಕ್ಷಿ 1ರ ಹೆಂಡತಿ ಅಂಬಿಕಾಳು ಹೊಲದಲ್ಲಿ ಜೊತೆಗೆ ಮಲಗಿದ್ದ ಸಾಕ್ಷಿ 1ರ ಸಿಕ್ಕಿ ಬಿದ್ದಿದ್ದು. ಈ ವಿಚಾರದ ಸಾಕ್ಷಿ ಮತ್ತು ಆರೋಪಿ ಮಧ್ಯೆ ಗಲಾಟೆಗಳು ನಡೆದಿದ್ದರಿಂದ ಸಾಕ್ಷಿ 1 ಮತ್ತು ಮೃತಳ ಅಂಬಿಕಾಳು ಆರೋಪಿಯ ಸಹವಾಸವನ್ನು ಬಿಟ್ಟಿದ್ದು. ಈ ವಿಚಾರವು ಊರಿನ ಜನರಿಗೆಲ್ಲ ಗೊತ್ತಾಗಿ ಆರೋಪಿಯ ಮರ್ಯಾದೆ ಹೋಗಿರುತ್ತದೆ ಮತ್ತು ಆರೋಪಿಯ ಜೊತೆಯಲ್ಲಿ ಮೃತ ಅಂಬಿಕಾಳು ಸಹಕರಿಸುತ್ತಿಲ್ಲ ಎಂಬ ದ್ವೇಷದಿಂದ ಆರೋಪಿಯು ಅನೈತಿಕ ಸಂಬಂಧ ಇಟ್ಟುಕೊಂಡಿದ್ದ ಸಾಕ್ಷಿ 1ರವರ ಹೆಂಡತಿಯಾದ ಅಂಬಿಕಾಳನ್ನು ಕೊಲೆ ಮಾಡಿ ಸಾಯಿಸುವ ಉದ್ದೇಶದಿಂದ ಹರಿತವಾದ ಚಾಕುವನ್ನು ತೆಗೆದುಕೊಂಡು ದಿನಾಂಕ 22/8/14 ಮಧ್ಯಾಹ್ನ 1:25 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಆರೋಪಿ ಸಾಕ್ಷಿ 1ರವರ ಮನೆ ಹತ್ತಿರ ಹೋಗಿ ಮನೆಯಲ್ಲಿ ಅಂಬಿಕಾಳನ್ನು ಬಿಟ್ಟು ಬೇರೆ ಯಾರೂ ಇಲ್ಲದೆ ಇರುವುದನ್ನು ಗಮನಿಸಿ ಮನೆಯ ಒಳಗಡೆ ಹೋಗಿ ಅಡುಗೆ ಮನೆಯ ವಸ್ತಿಲ ಬಳಿ ಇದ್ದ ಅಂಬಿಕಾಳನ್ನು ಹಿಡಿದುಕೊಂಡು ಆಕೆಯ ಕುತ್ತಿಗೆಯ ಬಳಿ ಚಾಕುವಿನಿಂದ ಬಲವಾಗಿ ಕೊಯ್ದು ತೀವ್ರ ಸ್ವರೂಪದ ರಕ್ತಗಾಯಗೊಳಿಸಿ ಕೊಲೆ ಮಾಡಿ ಸಾಯಿಸಿ ಮನೆಯಿಂದ ಹೊರಬಂದು ಅಂಬಿಕಾಳನ್ನು ಕೊಲೆ ಮಾಡಿ ಸಾಯಿಸಿರುತ್ತೇನೆಂದು ಕೂಗಾಡಿ ಅಂಬಿಕಾಳನ್ನು ಕೊಲೆ ಮಾಡಿ ಸಾಯಿಸಿದ ಬಗ್ಗೆ ಆರೋಪಿ ಸಂಬಂಧಿಸುವ ಮೊಬೈಲ್ ನಂಬರಿಗೆ ಫೋನ್ ಮಾಡಿ ವಿಚಾರವನ್ನು ತಿಳಿಸುತ್ತಾರೆಂದು ತನಿಖೆಯಿಂದ ದೃಢಪಟ್ಟ ಮೇರೆಗೆ ಆರೋಪಿಯ ವಿರುದ್ಧ ಕಲಂ 302 IPC ಅಡಿಯಲ್ಲಿ so and so. Now only the information is the mobile phone used by the accused to communicate to PW1 husband.
Yes.
But even though the investigating officer has collected several evidence and seized several material, the mobile phone is not neither seized nor collected for analyzing with the forensics laboratory. Mobile phone is not at all there. Besides, there is lot of discrepancy between the gist written by the police in the complaint and Exhibit P1 complaint. If at all that version has to be believed, the PW1 and the deceased are living together with the father, mother, and 2 children. One child is going to the local.
Parents of PW1 or deceased parents?
Parents of PW1.
PW1.
PW1. Who is PW7 in the, according to the complaint itself, 2 children are there. One is studying in nursery and one is in the primary school. At this particular time, when the incident has happened, definitely there should have been the presence of one of the child in the house. They say at the home, when there was nobody, the murder has taken place. There is absolutely no evidence to the extent that this was seen, even at least by the children, minor, whatever may be. They could have been examined, or one child is nursery child, definitely cannot be in the nursery school at about 1 o'clock. It is not that they are sent to the high profile school like we in the Bangalore city, that they go in the early morning and come afternoon. It's nothing like that.
Yes.
Local school. That has not been examined, and all of them, all other witnesses examined also, to the extent that it is just a hearsay. Even the PW7 father is a hearsay evidence. Absolutely, my humble submission is, because my lords are sitting on video conference, not like I do not want to consume large time of the honorable court to take every item of the case, entire Facebook like paper book like any other criminal appeal. Here, the sentence is life. Already he has spent 6 years, 7 years at the young age. 2 children are there. One is studying in PUC boy. The girl, I am told that 12 years she has completed. The responsibility casts upon the father. So when there is no sufficient evidence, my humble submission is, what I draw the inference is that, my lords, the murder is committed by the husband himself, having seen the illicit relationship between the deceased and accused, perhaps has passed on the liability or the accusation to the, because there is some evidence to the extent that they were having some kind of relationship. And if my lords are pleased to see that they were seen in the hola field, agricultural land, having together, spending time together. But exactly, if we read the complaint exhibit P1, it is she left the company of the accused. Having left the company of the accused became violent and committed the murder, is the first version. If we see exhibit P1 written complaint, the version is totally different. Exhibit P1, page number 169. ನಾನು ಮೇಲ್ಕಂಡ ಗ್ರಾಮದಲ್ಲಿ ಹುಟ್ಟಿನಿಂದಲೂ ವಾಸವಾಗಿದ್ದು, ದಿನಾಂಕ 25/3/2000 ಹೊಸದುರ್ಗ ತಾಲೂಕು ಬೆಲಕನಹಳ್ಳಿ ಗ್ರಾಮದ ರಂಗಪ್ಪ ತಂದೆ ರಾಮಪ್ಪ ಇವರ ಮಗಳಾದ ಅಂಬಿಕಾ ಇವಳನ್ನು ನಮ್ಮ ಪದ್ಧತಿಯ ಪ್ರಕಾರ ಬೆನಕನಹಳ್ಳಿಯಲ್ಲಿ ನನ್ನ ಮಾವನವರು ಮದುವೆ ಮಾಡಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ವಿವಾಹ ಆದಾಗ ಇಲ್ಲಿವರೆಗೂ ನಾನು ನನ್ನ ಹೆಂಡತಿ ಚೆನ್ನಾಗಿದ್ದು ಸುಖ ಸಂಸಾರ ಮಾಡಿರುತ್ತೇವೆ. ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ದೇರ್ ಇಸ್ ನೋ ಕ್ವಾರಲ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ಇಲಿಸಿಟ್ ರಿಲೇಶನ್ಶಿಪ್. ನಮಗೆ ಇಬ್ಬರು ಗಂಡು ಮಕ್ಕಳಿದ್ದಾರೆ. 1ನೇ ಮಗ ವರುಣ 1ನೇ ತರಗತಿ ಓದುತ್ತಿದ್ದಾನೆ. 2ನೇ ಮಗ ಶಿಶುವಿಹಾರದಲ್ಲಿ ಓದುತ್ತಿದ್ದಾನೆ. ನನ್ನೊಂದಿಗೆ ನನ್ನ ಮಕ್ಕಳು ಹಾಗೂ ವಯಸ್ಸಾದ ನನ್ನ ತಂದೆ ತಿಮ್ಮಪ್ಪ ಮತ್ತು ತಾಯಿ ಚಂದ್ರಮ್ಮ ಒಟ್ಟಿಗೆ ಒಂದೇ ಮನೆಯಲ್ಲಿ ಸುಖವಾಗಿ ವಾಸ ಮಾಡುತ್ತಿದ್ದೆವು. ನನ್ನ ತಂಗಿ ಭಾಗ್ಯರನ್ನು ಹುಣವಿನಡು ಗ್ರಾಮದಲ್ಲಿ ಕಲ್ಲೇಶ್ವರ ಅವರಿಗೆ 90 ವಿವಾಹ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. ಸೊ ಮದರ್ ಅಂಡ್ ಫಾದರ್ ಆರ್ ಟುಗೆದರ್. Father is PW7. PW7 says that on that day he had gone to the daughter's house and came to know that the murder has taken place, and then he came back. By the time he comes back, police had gathered. So my submission is that, my lords, it is, my lord, the probability is impossible to say that there is no eyewitness. At least children. The best witness would have been to examine the children of the deceased, which has not been done. And I will not trouble your lordship editing all the evidences because they are all outsiders. PW7 I may read father. Page number 114. ಮೃತ ಅಂಬಿಕಾ ನನಗೆ ಗೊತ್ತು. He does not say she is the daughter-in-law. PW1 ಮಂಜಪ್ಪ ನನಗೆ ಮಗ ಆಗಬೇಕು. ನನಗೆ means that is recorded. I know the accused. I know the like that may be. ನನಗೆ 2 ಜನ ಗಂಡು ಮಕ್ಕಳು, ಅವರ ಹೆಸರು ಮಂಜಪ್ಪ, ಭಾಗ್ಯಮ್ಮ. ಭಾಗ್ಯವನ್ನು ಇವಳನ್ನು ಹೊಸದುರ್ಗ ತಾಲೂಕಿನ ಹುಣವಿನಡು ಗ್ರಾಮಕ್ಕೆ ಮದುವೆ ಮಾಡಿ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಅವಳು ಗಂಡನ ಮನೆಯಲ್ಲಿ ಇರುತ್ತಾಳೆ. ಆರೋಪಿ ರಂಗನಾಥ ನನಗೆ ಗೊತ್ತು. ಅವನು ನಮ್ಮ ಊರಿನವನು. ನಮ್ಮ ಮನೆಯಲ್ಲಿ ನಾನು, ನನ್ನ ಮಗ PW1 ಮಂಜಪ್ಪ, ಅವನ ಮಕ್ಕಳು ಮೃತ ಶ್ರೀಮತಿ ಅಂಬಿಕಾ ಕೂಡಿಕೊಂಡು ವಾಸ ಮಾಡುತ್ತಾ ಬಂದಿರುತ್ತೇವೆ. PW1 ಮಂಜಪ್ಪ ಮತ್ತು ಅಂಬಿಕಾ ಇವರ ಮದುವೆ 8-9 ವರ್ಷಗಳ ಹಿಂದೆ ಆಗಿರುತ್ತದೆ. ಅಂಬಿಕಾ ಇವಳಿಗೆ 2 ಗಂಡು ಮಕ್ಕಳು ಇರುತ್ತಾರೆ. CW9 ಚಂದ್ರಮ್ಮ ನನಗೆ ಹೆಂಡತಿಯಾಗಬೇಕು. ಅವಳು ದಿನಾಂಕ 1/9 ತೀರಿಕೊಂಡಿದ್ದಾಳೆ. ಆಫ್ಟರ್ ದ್ಯಾಟ್ ಆರೋಪಿ ರಂಗನಾಥ ನನಗೆ ಸಂಬಂಧಿಕನಾಗಬೇಕು. ಅಂದು ಘಟನೆ ದಿವಸ ಅಂದರೆ ಈಗ 3 ವರ್ಷದಿಂದ ನಾನು ನನ್ನ ಚಂದ್ರಮ್ಮ ಕೂಡಿಕೊಂಡು ನನ್ನ ಮಗಳ ಊರಾದ ಹೊಸದುರ್ಗ ತಾಲೂಕು ಹುಣವಿನಾಡು ಗ್ರಾಮಕ್ಕೆ ಬಾಗಿನ ಕೊಡಲು ಹೋಗಿದ್ದೆವು. ಅಂದು PW1 ಮಂಜಪ್ಪ ಮೋಟಾರ್ ಬೈಕ್ ಖರೀದಿ ಮಾಡಲು ಹೊಸದುರ್ಗಕ್ಕೆ ಹೋಗಿದ್ದನು. ನನ್ನ 2 ಮೊಮ್ಮಕ್ಕಳು ಶಾಲೆಗೆ ಹೋಗಿದ್ದರು. ಮನೆಯಲ್ಲಿ ಅಂಬಿಕಾ ಒಬ್ಬಳೇ ಇದ್ದಳು. ಅಂದು ಆರೋಪಿ ನನ್ನ ಸೊಸೆ ಅಂಬಿಕಾ ಜೊತೆ ಲೈಂಗಿಕ ಕ್ರಿಯೆ ಮಾಡಲು ಹೋಗಿದ್ದ. ಅದಕ್ಕೆ ಅವಳು ಒಪ್ಪಿಲ್ಲ. ಹೀಗಾಗಿ ಆರೋಪಿ ರಂಗನಾಥ ನನ್ನ ಸೊಸೆ ಅಂಬಿಕಾಳನ್ನು ಚಾಕು ಸಹಾಯದಿಂದ ಕೊಲೆ ಮಾಡಿದ್ದಾನೆ ಅಂತ ವಿಷಯ ತಿಳಿಯಿತು. ನನ್ನ ಅಣ್ಣನ ಮಗ ಚಂದ್ರಪ್ಪ ನನಗೆ ಫೋನ್ ಮಾಡಿ ವಿಷಯ ತಿಳಿಸಿದ್ದರಿಂದ ನಾನು, ನನ್ನ ಹೆಂಡತಿ CW9 ಚಂದ್ರಮ್ಮ ಕೂಡಿಕೊಂಡು ನಮ್ಮ ಗ್ರಾಮಕ್ಕೆ ಬಂದೆವು. ನಾವು ಕೃತ್ಯ ಸ್ಥಳಕ್ಕೆ ಅಂದರೆ ನಮ್ಮ ಮನೆಗೆ ಬಂದಾಗ ಮನೆಯಲ್ಲಿ ರಕ್ತದ ಮೊಡವಿತ್ತು, ಅಂಬಿಕಾಳ ಹೆಣ ಇತ್ತು, ಅವಳ ಕುತ್ತಿಗೆ ಚಾಕು ಇತ್ತು, ಸೊಂಡ್ಸು. ಪೊಲೀಸರು ಬಂದಿದ್ದರು. ನಮ್ಮ ಮನೆಗೆ ಆಗಾಗ ಬಂದು ಹೋಗ್ತಿದ್ರು. ಮೊದಲು ಆರೋಪಿ ಮತ್ತು ಮಂಜಪ್ಪ ಚೆನ್ನಾಗಿದ್ದರು. ಘಟನೆಗಿಂತ ಪೂರ್ವದ 1 ದಿವಸ ಅಂಬಿಕಾ ನಮ್ಮ ಜಮೀನಿಗೆ ಕೆಲಸಕ್ಕೆ ಹೋದಾಗ ಆರೋಪಿ ಅವಳ ಜೊತೆ ಅಕ್ರಮ ಇಟ್ಟುಕೊಂಡಿದ್ದು ಲೈಂಗಿಕ ಮಾಡುತ್ತಿದ್ದ. ಅದನ್ನು PW ಮಂಜಪ್ಪ ನೋಡಿದ್ದನು. ಆ ವಿಚಾರವನ್ನು PW ನನಗೆ 5 ಗಂಟೆಗೆ ಹೇಳಿದ್ದನು. ಆ ವಿಚಾರ ನಾವು ಆರೋಪಿಯನ್ನು ಕರೆಸಿ ಈ ರೀತಿ ಸಂಬಂಧದೊಳಗೆ ಹೆಣ್ಣು ಮಕ್ಕಳ ಜೊತೆ ಅನುಚಿತೆ ಮಾಡುವುದು ಸರಿಯಲ್ಲ, ನಮ್ಮ ಮರ್ಯಾದೆ ಪ್ರಶ್ನೆ ಅಂತ ಹೇಳಿದ್ದರು. ಇದಾದ 1 ವಾರಕ್ಕೆ ಕೊಲೆ ಮಾಡಿದ್ದಾನೆ. ಬಟ್ ಇಫ್ ವಿ ಸಿ ದ ಅದರ್ ಕಂಪ್ಲೇಂಟ್, ದೇ ಸೇ ಇವನು ಸಹವಾಸವನ್ನು ಬಿಟ್ಟಿದ್ದಕ್ಕೆ ಕೋಪಗೊಂಡು ಅವಳು ಸಹವಾಸವನ್ನು ಬಿಟ್ಟಿದ್ದಕ್ಕೆ ಕೋಪಗೊಂಡು ಕೊಲೆ ಮಾಡಿದ್ದಾನೆ. ಸೊ ಮೈ ಸಬ್ಮಿಷನ್ ವಿಲ್ ಬಿ ದಿಸ್ 1 week time cannot be believed, because in the complaint itself they say that the Ambika had left the company of the deceased accused. So considering all these aspects of matter, in the absence of any specific evidence, to the extent that the other material produced and taken in evidence are not relevant at all for this case, because if at all the message goes by telephone, he was not able to tell the telephone number in the cross-examination. The learned judge writes that in the present days, people do not write the phone number, they write the name. It is so in case of certain civilized society people, not all. Left to me, myself, without there being any help of my fellow friends or colleagues, even I will not be able to address the Honorable Court by video conference. That is the status with the little aged people and the youngsters. Perhaps the grandson going to school would have done better on the telephone, mobile phone. That is not there in this case, and the learned judge's finding is totally unacceptable, my lord. Will not satisfy the requirement of law to bring the accused to the punishment, that too to the extent of life. Only now without my lord said, my lords have already read the papers. Instead of my lord repeating what I can say, my lord, even by considering the fact that 6 years have already been spent in jail, whether it is necessary to keep him further for the same thing, to sustain the lifelong punishment, and without there being parents to the children. Small age children are there, male and maklu. So these aspects may be considered, because I will not trouble your lordship reading all the evidence and
Yes.
and the accused may be, there is no material at all to say that.
Yes.
But after reading several times, I still find in my mind, it may be the PW1 himself killing and passing on if at all one version, seeing some few of the cases, if at all he telephones to the husband PW1 that he has committed the murder of his wife, immediately he would have gone and surrendered before the police also, holding the knife in his hand and going in front of the police station. ಒಂಥರ ಪೌರುಷ ಮಾಡ್ಕೊಂಡು police station ಹೋಗಿ surrender ಆಗೋ possibility ಇತ್ತು. If at all that has to be believed. So my submission is that there is absolutely no evidence to that extent. And
Yes.
ಸಾಹೇಬ್ರೆಲ್ಲ ಓದಿದ್ದಾರೆ.
About the incident. The Lordships, he has spoken on the version what his wife had told him. The Lordship throughout his evidence have cleared correct. The wife told him that he used to come to the house, he threatened me. That's why he ended up having relationship. He does not confess about having relationship with the accused. Your Lordships, at the end of the day, motive being is that she might have resisted the accused. Continuing the relationship. And since your Lordships, it's come to the notice of all the villages also, comes out in the evidence of PW1 clearly where it states that he had advised accused and his wife both.
Can the council speak through the mic?
Use mic, madam.
Please, your Lordships. And PW1 is very clear in his evidence. He might have not wanted to speak about the extramarital relationship between the deceased and the accused. But even there are many witnesses who are from the same village, your Lordships, who speak about the extramarital relationship between the accused and the deceased. Your Lordships, that might be the motive where the deceased might have resisted. Your Lordships, otherwise there would be no reason for the accused to kill the deceased. Your Lordships, apart from that, there are 5 witnesses who have seen with regard to extrajudicial confession, your Lordships, who speak about the accused going in the motorbike, announcing that he has killed the wife. And immediately after, your Lordships, within the distance of the house is very close by, which is also part of the evidence which has come out. They go and immediately see there are already people and the deceased is there, your Lordships. The way he has mentioned, PW1 evidence alli, ಕೂರಿಸ್ಬಿಟ್ಟು ಕತ್ತು ಕೊಯ್ದ್ಬಿಟ್ಟು ಬಂದಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. That is exactly how the deceased body was found in the spot.
Extrajudicial witnesses overall?
Overall, your Lordships, there are 5 witnesses, your Lordships.
Extrajudicial confession.
PW3, PW5, PW6, PW9, and PW12, your Lordships.
12, okay.
12. And 13 also.
Any recovery at the instance of the
There is a recovery of blood-stained clothes, your Lordships, and as well as
shirt, knife, and
knife,
also the
right.
banian
Please, your Lordships.
belongs to the accused.
Accused itself. Exhibit P10 and P13, your
Exhibit
Lordships.
P36 FSL report.
That is also bloodstains.
That is report FSL.
Report is positive, your Lordships.
One
Exhibit
shirt, one banian,
P36.
one knife.
Please, your Lordships. It's found bloodstain. And your Lordships, the accused used to visit the house of the deceased when nobody was in the house.
Yes.
Your Lordships, whether the children, obviously he knew since he was a relative of PW1, he was aware of the timings of the house. So he used to come only when there were no people in the house. So look, the extramarital affair that the defense counsel is talking about, your Lordships, that the accused used to come to the house of the deceased when nobody was there in the house. He would not come if there are children. They say he used to come, speak, talk, ಊಟ ಮಾಡ್ಕೊಂಡು ಎಲ್ಲ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ರು.
Any last witnesses seen?
Lordships, there is no last witnesses, your Lordships. The witness,
Anybody witnessed the accused going to the house of the victim
no, your
and
Lordships.
coming out from the house?
ಆ ತರ ಇಲ್ಲ, but there are witnesses.
Last seen witnesses are illa.
ಆ ತರ ಇಲ್ಲ. But there are witnesses who've spoken about telling, we used to see accused going to the house of the deceased when nobody was around. ಹೋಗ್ತಾ ಬರ್ತಾ ಇದ್ರು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
That is all.
That is all. To that extent, there is evidence, your Lordships. Lordships, motive is established, your Lordships, because the other villages of the witnesses who clearly speak about the telling that even the entire villages knew that there was relationship between the accused and deceased. PW1 has advised them and there is evidence to that extent. Lordships, to that extent, motive is established. And also, your Lordship, since the deceased was resisting after 2 years of relationship, the deceased started resisting the accused. That's why he has murdered her. And to the extent, your Lordships, right after the incident, he goes on the bike announcing that he has killed. And the manner he has killed, he also, with PW1 evidence al barutte. ಕೂರಿಸ್ಬಿಟ್ಟು ಕತ್ಕೊಯ್ದು ಬಂದಿದೀನಿ ನಿನ್ ಹೆಂಡ್ತಿದು ಅಂತ ಹೇಳ್ತಾರೆ. It's exactly the same way the body is found. And immediately, Your Lordships, there are a lot of witnesses who've seen the body.
When he called and told that he only committed the murder,
Your Lordships,
that too through a mobile phone, why the investigating officer has not seized the mobile?
Your Lordships, with these witnesses, Your Lordships, that part of the evidence is only, he's not seized the mobile, Your Lordships, the call detail records are not taken. But Your Lordships, the presence of the accused to that extent, only on that ground cannot be taken away, Your Lordships. PW1 also has immediately gone to the spot. And as, even if he's received phone call, Your Lordships, he's immediately gone and he has seen the way the deceased accused had mentioned that he has killed. It is the same way. That mere not having call detail records, Your Lordships, does not itself take away the presence of the accused from the scene of the offense. There are there are witnesses who speak about extrajudicial.
According to you, here there is an extrajudicial confession
Please, Your Lordships.
as well as the recovery at the instance of the
Of the
accused.
accused. And also, Your Lordships, there are witnesses who speak about the advice that they have advised both the deceased as well as the accused regarding the relationship.
Illicit relationship.
Please, Your Lordships. To that extent, Your Lordships, the deceased might have withdrawn her consent from having any further relationship with the accused. That is sufficient motive for the accused to have murdered. And Your Lordships, these witnesses also speak about that PW1 was threatened by the accused that Nimna, I'll take care of you or your wife. There is threat. There is threat also, Your Lordships, by the accused, which some of the witnesses have spoken to that extent. And PW1, Your Lordships, when he was passing by, that's when the accused had passed right in front of him on the bike. PW1's evidence is that nan ಗುರಾಯಿಸ್ಕೊಂಡು ನೋಡ್ಕೊಂಡು ಕೋಪದಲ್ಲಿ ಹೋಗಿದ್ದಾನೆ ಅಂತ ಹೇಳ್ತಾರೆ. That means, Your Lordships, that there was ill will that had been developed between PW1's deceased and accused. There is sufficient material, Your Lordships, for the accused's conviction, Your Lordships.
That's all?
That's all.
Only one submission.
Yes.
The learned public prosecutor stated about the visiting of the accused to the house on a motorcycle. The police, in the course of investigation, should have at least found some mark of the motorcycle. There is absolutely no evidence to that extent. Some mark on the roadside of the tire mark or whatever it is. I do not say about the CC camera like the present day. Some mark of the motorcycle, there is absolutely no evidence. And MO1 to MO8. This is only the cloth on the body of the deceased or on the body of a person. Which cannot have.
What do you say with regard to the incriminating evidence against your client that his shirt and also the bunion and knife was recovered or stained with blood?
Yes, but it does not show that it belongs to him. It was his.
Not belongs to him, that is the blood group of the deceased.
Yes.
Blood group of deceased, A group blood.
Yes, it may have been committed by the PW1 himself. There is a probability. If at all the version of the
I am asking,
please,
how to overcome the blood stains found on the body of the accused? That is the blood
accused of the deceased.
Yes. Bunion, shirt, and also the knife, which was used for committing the murder.
Yes.
How you have to overcome that?
To overcome that, my lords may kindly see, it's a village. If at all the version has to be believed, that there used to be a illicit relationship and there was warning, etc., etc., there would have been hue and cry and a complaint before the police also would have been done. Till the date of the death, not a single instance of approaching the police against the accused. So in the absence of which, my lord, even other material.
Ordinary prudent man will not go to the police station saying that my wife is having illicit relationship with so and so.
No. Illicit relationship, my lord, he may not say that the other person is troubling my wife. That much even panchayati, etc., take place in a village like this place.
telling somebody that no, because all other witnesses are telling that. There used to be, there's some information about the illicit relationship, whether by consent or otherwise, I'm not able to canvass. Absolutely, if the version is seen, it is, if at all that has to be seen, it was continuous and by consent. That is a different aspect. We are on 302. To establish that the evidence available is not sufficient, that too in the absence of the evidence of the children, or at least speaking something about them, whether they were in the school or at the home at that particular time. And it is not that before the accused and motorcycle showroom, they say that he has gone to purchase a motorcycle. In that event, there should be some corroborative evidence to the extent that a showroom person also would have been examined, saying that he had come on that day at this particular time, deposited the money for buying a motorcycle, and we have delivered or we are going to deliver. That's also not there. So, though as many as 19 witnesses have been examined, it will definitely not establish the case of the prosecution. And in the circumstances like this, the accused is entitled to be enlarged on by an order of acquittal, please.
Lordships, evidence of PW 18 may be seen regarding the call detail records, Your Lordships. PW 18, page number 160.
Is there any call report, call record is also marked?
Lordships, call detail records.
PW?
Exhibit P35. Your Lordships.
PW?
PW 18, Your Lordships, page number 163.
DYSP.
DYSP, Your Lordships.
PW 18, device.
PW 18, please, Your Lordships. ದಿನಾಂಕ 24/8/2016 ಆರೋಪಿಗೆ ಸೇರಿದ ಫೋನ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಇದರ ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ಕೇಳಿ ಸರ್ವಿಸ್ ಪ್ರೊವೈಡರ್ ಇಂದ ಪಡೆಯಲು ಮಾನ್ಯ ಅರ್ಜಿ ಕೊಟ್ಟಿರುತ್ತೇನೆ, ಅದನ್ನು ನಿಪಿ 34 ಅಂತ ಗುರುತಿಸಲಾಯಿತು. ಈ ಪ್ರಕಾರ ಮಾನ್ಯ SP ಅವರು ಆರೋಪಿಗೆ ಮೊಬೈಲ್ ಸಂಬಿಸಿದ ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿರುತ್ತಾರೆ, ಅದನ್ನು ನಿಪಿ 35 ಅಂತ ಗುರುತಿಸಲಾಯಿತು. ಅದು PW1 ಮಂಜಪ್ಪ ಘಟನೆ ದಿವಸ ಹೊಸದುರ್ಗಕ್ಕೆ ಹೋಗಿದ್ದ. ಆ ವೇಳೆಯಲ್ಲಿ ಆರೋಪಿ ಫಿರ್ಯಾದಿದಾರನ ಮನೆಗೆ ಹೋಗಿ ಅಂಬಿಕಾ ಇವಳನ್ನು ನನಗೆ ಅನೈತಿಕ ಸಂಬಂಧಕ್ಕೆ ಸಹಕರಿಸುತ್ತಿರಲಿಲ್ಲ, ಹೀಗಾಗಿ ನಾನು ಅವಳನ್ನು ಕೊಲೆ ಮಾಡಿದ್ದೇನೆ ಅಂತ ಹೇಳಿದ್ದನು. ನಿಪಿ 35 ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ದಾಖಲೆಯಲ್ಲಿ ಆರೋಪಿ ಫಿರ್ಯಾದುದಾರನಿಗೆ ಮಧ್ಯಾಹ್ನ 1:26 ಫೋನ್ ಮಾಡಿದ್ದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆ ಭಾಗವನ್ನು ನಿಪಿ 35 ಅಂತ ಗುರುತಿಸಲಾಯಿತು. ಅದರಲ್ಲಿ ಫಿರ್ಯಾದಿದಾರರು ಹೊಸದುರ್ಗ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಹತ್ತಿರ ಇದ್ದ ಬಗ್ಗೆ ಗೊತ್ತಾಗುತ್ತದೆ. With regard to call detail records.
Call detail P35.
To establish, Your Lordships, regarding that accused had made a call from the accused phone number.
Immediately
itself.
after committing the murder, he
He has
called the complainant and also informed.
Please, Your Lordships. And that is the timing that the extra witnesses who mentioned, who have spoken about the accused extrajudicial confession, that is the time that even those witnesses also mention, Your Lordships. Around 1:15 ಸುಮಾರು ಅಂತಾನೆ ಹೇಳ್ತಾರೆ.
1:26 ಫೋನ್ ಮಾಡಿದ್ದಾನೆ.
And even the witnesses, Your Lordships, who
ಫಿರ್ಯಾದಿದಾರ ಹೊಸದುರ್ಗ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಹತ್ತಿರ ಇದ್ದ ಬಗ್ಗೆ ಗೊತ್ತಾಗುತ್ತದೆ.
Please, Your Lordships. To show that even PW1 was not in the house at the where on doubt of PW1 is being cast upon by the defense. This also shows, Your Lordships, PW1 was not in the house, not near in the premises at all. He had gone to purchase the bike. Oh, Your Lordships, now it is for the defense to explain how the blood-stained clothes, knife, and also, Your Lordships, regarding the how they will overcome extrajudicial confession, Your Lordships, of these 5 witnesses. The timing mentioned by extrajudicial witnesses and the call detail records are one and the same, Your Lordships. There are around 5-6 witnesses who speak about the accused announcing that have killed PW1's wife. And more importantly, Your Lordships, the way he has killed, he has stated and he has told PW1 ge phone alli. That's the same way the body was found. ಕೂತ್ಕೊಂಡು ತಲೆ ವಾಲಿರೋ ತರ ಇದೆ. So that's the state the body was found, sitting position ಅಲ್ಲಿ. So there is corroboration, even call detail records wise also, Your Lordships, which the defense had taken.
Yes. That's all.
That's all.
P34 is only a requisition letter as with showing the number.
P34, 35?
P35 is regarding this banyan.
That is the report.
35 is by FSL. 35
FSL.
Deputy Director Regional Forensic.
Call details alva.
ಕಾಲ್ ಡೀಟೇಲ್ ಅಲ್ಲ, ಇದು ನೋಡಿ ಬ್ಯಾಂಗಲ್ಲು, ಬ್ಲಡ್ ಸ್ಯಾಂಪಲ್, ನೈಟಿ, one petticoat, shirt, banian, knife.
36 is
35 ಮಾಡಿದಾರ್ರಿ ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ದಾಖಲೆಯಲ್ಲಿ ಆರೋಪಿ ಫಿರ್ಯಾದನಿಗೆ
ಇದು ಹೇಳ್ತಾ ಇದೆ. In the judgment,
35 ಎಲ್ ಇದೆ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ.
Sir, paper.
You go to page number 163, paragraph number 5. That is the evidence of IO. ಈ ಪ್ರಕಾರ ಮಾನ್ಯ SP ಇವರು ಆರೋಪಿ ಮೊಬೈಲ್ಗೆ ಸಂಬಂಧಿಸಿದ ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಅದೊಂದು ನಿಶಾನೆ P30 ಆಯ್ತು. ಮಂಜಪ್ಪ ಘಟನೆ ದಿವಸ ಹೊಸದುರ್ಗಕ್ಕೆ ಹೋಗಿದ್ದ. ಆ ವೇಳೆಯಲ್ಲಿ ಆರೋಪಿ ಫಿರ್ಯಾದರನ್ನ ಮನೆಗೆ ಹೋಗಿ, ಅಂಬಿಕಾ ಇವಳು ನನಗೆ ಅನಧಿಕ ಸಂಬಂಧಕ್ಕೆ ಸಹಕರಿಸುತ್ತಿಲ್ಲ, ಹೀಗಾಗಿ ನಾನು ಅವಳನ್ನು ಕೊಲೆ ಮಾಡಿದ್ದೇನೆ ಅಂತ ಹೇಳಿದ್ದನು. ನಿಶಾನೆ P35 ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ದಾಖಲೆಯಲ್ಲಿ ಆರೋಪಿ ಫಿರ್ಯಾದರನಿಗೆ ಮಧ್ಯಾಹ್ನ 1:26ಕ್ಕೆ ಫೋನ್ ಮಾಡಿದ್ದು ಕಂಡು ಬರುತ್ತದೆ. That is also the case of the complainant that he called and told him that he went and committed the murder of his wife.
yes, if I can see, my lord.
And also even location also he speaks about that he was in Hosadurga bus stand, complainant, the accused.
Yes.
Not accused, PW1.
PW1.
PW1
No,
was
he
at
went to buy a
Hosadurga. That
motorcycle.
means he was not in the house.
He went to buy a motorcycle.
Hmm.
If it is so, there should have been a motorcycle showroom person also should have been brought in evidence to say, to establish that. P35, my lords, if I can, P36, sorry. 34, 35 ಇಲ್ಲ ಇಲ್ಲಿ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ. ಇಲ್ಲ.
Yes, sir.
ಹೌದು. All details. ಗೊತ್ತಾಯ್ತು ನೋಡಿದ್ರೆ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ. But the phone is not seized.
To that extent, even your lordship's post-mortem report also supports the case of the prosecution. Page number 199. Cardiorespiratory failure resulting from hemorrhage shock due to homicidal injury to carotid artery and trachea. Which is, the report is on page number 202, your lordships, the opinion.
199.
Incised wound present at anterior part of the neck measuring 10 centimeter into 6 centimeter. Trachea is cut, sternocleidomastoid muscles is cut, and wound is in the middle and both sides of the trachea.
Homicidal injury to carotid artery
Please, your lordship.
and trachea. The case of the prosecution also that
Please, your lordship.
he inflicted injury on the neck.
And the witnesses who've seen the dead body also mention about the injuries to the neck, your lordships. Who've all witnessed, all the witnesses who've seen the deceased body, they mention about the injury being only to the neck.
That's all.
Please.
Injuries are accepted, but nothing to show that he has done that. He has caused the injuries. I somehow after reading also feel that PW1 himself out of vengeance or some kind of fit of anger has done it and then passed on it to
But he was not at the spot, counsel, in terms of the mobile.
it says so.
He
but
was in the
outside.
Hosadurga bus stand. Now how you can say that he committed murder?
May not be the corroborating same time. Because children.
You have to see the location
Yes.
of the person
Yes.
at the time of incident where he was there.
The children having a small children going to school at that particular time, invariably will have to be at home. That is not.
School ಹೋಗಿರ್ತಾರೆ ಅವಾಗ ಒಂದೂವರೆ ಯಾರು ಇರ್ತಾರೆ? ಒಂದು
ನರ್ಸರಿ
25
ಸ್ಕೂಲ್
ಮನೆಯಲ್ಲಿ.
11 ಗಂಟೆಗೆ ಬಿಟ್ಬಿಡ್ತಾರೆ. ನರ್ಸರಿ ಸ್ಕೂಲ್ 11 ಗಂಟೆಗೆ ಬಿಟ್ಬಿಡ್ತಾರೆ.
ಆಯ್ತು
ಆಟ
ನೋಡಿ.
ಆಡ್ತಾರೆ.
See.
Please.
Yes, madam.
Yes.
Heard, reserved.
Please. 6 years already spent. That may be considered.
Yes, madam, thank you.
Yes, thank you.
Single will continue. From Paso.
Next one, passed over matter 26.
The suit for partition, the parties have now reporting their compromise. All the parties are present.
26. Habeas are for R2. What about R1?
R1 is, somebody is already filing wakalat for R1, they undertook.
Venkata Lakshmamma. You are appearing for R2.
R2.
So who is filing wakalat for R1?
Madam. He is present.
Point number 1, my lord. Committed to file wakalat.
For R1 na?
R1.
Oh, your good name?
Nataraj.
Natraj.
Please.
Counsel Sri Natraj. Files wakalat for R1.
Compromise sign ಮಾಡಿ.
Natraj, Donkannanavara. Files wakalat for R1. Parties ಎಲ್ಲ ಇದಾರಾ?
ಎಲ್ಲರೂ ಇದ್ದಾರೆ.
Compromise petition ಇಲ್ಲೇ ಇದೆ. Sketch also annexed regarding compromise. What are the terms of the compromise?
Terms of that is basically this, item number 2 and 5, partition suit. It is respondent number 2 is claiming exclusive right. Now they have.
Respondent number 2.
2.
Earlier claimed exclusive right.
Exclusive right. Other properties are family properties. Now even 2 and 5 also incorporated in the partition. Compromise and shared in different portion. And female members.
As per the sketch.
Yes, sir.
Sketch number 1 ಪ್ರಕಾರ ಯಾರಿಗೂ ಗೊತ್ತಿದ್ದು ಐಟಮ್ ನಂಬರ್ 1 and 2 ಸರ್ವೆ ನಂಬರ್ 4 ಅಲ್ಲಿ.
Sketch 1 ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಒಂದು ಸ್ಕೆಚ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 4 ಇದು ಒಂದ್ ಪೋರ್ಷನ್ ಇವ್ರಿಗೆ ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಇದೀವಿ. ಅನುಭವದಾರ ಕೃಷ್ಣಯ್ಯ ಅಂಡ್ ಗಂಗಾಧರ.
Second portion respondent 2 ಗೆ.
ಅದೇ ಗಂಗಾಧರಯ್ಯ.
ಇನ್ ಸ್ಕೆಚ್ ನಂಬರ್ 2 ನಲ್ಲಿ
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಫಸ್ಟ್ ವೆಂಕಟಪ್ಪ ಅಂತ ಇದೆ, ಕೃಷ್ಣಯ್ಯ ಅಂತ
ಅಲ್ಲ, ಗಂಗಾಧರಯ್ಯ ಸನ್ ಆಫ್
ನಂಬರ್ 8 ಹೋಗುತ್ತೆ. ಐಟಮ್ ನಂಬರ್ 1 ಅದರಲ್ಲಿ ಅಲ್ಲ, ಅನುಭವದಾರ ಹೆಸರಾ?
ಅನುಭವದಾರ ಗಂಗಾಧರಯ್ಯ ಸನ್ ಆಫ್ ವೆಂಕಟಪ್ಪ.
ಈಗ ಹೋಗೋದು ಮತ್ತೆ ಯಾರಿಗದು?
ಅಲ್ಲ, ಇವಾಗ ಕೊಡ್ತಾ ಇರೋದು, ಇವಾಗ ಅವರಿಗೆ ಕೊಡ್ತಾ ಇರೋದು.
ಯಾರಿಗೆ ಕೊಡ್ತಾರೆ? ಬಟ್ ಅದೆಲ್ಲ ನರೇಟ್
ಮಾಡಿದೀವಿ ಎಲ್ಲ.
ಕಾಂಪ್ರಮೈಸ್
ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಎಕ್ಸ್ಪ್ಲೈನ್ಡ್.
All parties curse. The appellants 1 to 8 are present. And also the respond number 1 and 2 present. The parties have filed the compromise petition. And in terms under order 23 rule 3 of CPC. And amicably settled the same. Describing the allotment of properties to the respective parties, showing the same as A2 schedule ಎಷ್ಟು ಬರ್ತದ್ರಿ?
A2
E ನಾ? A to E. ಹೌದಾ?
A to E.
A to E. ರಾಜಿ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? ರಾಜಿ ಪ್ರಕಾರ ಎ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಯಾರಿಗೋಗುತ್ತೆ?
A scheduled property, my lord,
ಅವ್ರು ಹೇಳ್ಬೇಕು, ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ. ಯಾರು? ವೆಂಕಟಲಕ್ಷ್ಮಮ್ಮ ಯಾರು? ನೀವಾ? ನಿಮ್ಗೆ ಯಾವ್ದು ಏನ್ ಬರುತ್ತಮ್ಮ ನಿಮ್ಗೆ?
ಏನ್ ಬರುತ್ತೆ ಅಂತ ಕೇಳ್ತಾ ಇದಾರೆ. ಕಾಂಪ್ರಮೈಸ್ ಪ್ರಕಾರ ನಿಮ್ಗೆ ಏನ್ ಬರುತ್ತೆ ಅಂತ ಕೇಳ್ತಾ ಇದಾರೆ.
ರಾಜಿ ಪ್ರಕಾರ ನಿಮ್ಗೆ ಏನ್ ಬರುತ್ತಮ್ಮ? ಎಷ್ಟ್ ಕೊಟ್ಟಾರಮ್ಮ? ಎಷ್ಟೋ ಅಂತ ಹೇಳಂಗಿಲ್ಲ. ಹಾ? 1 ಲಕ್ಷ. ಇಲ್ಲ 4 ಲಕ್ಷ ಅಂತ ಇದೆ. ಫಾರಂ ಆಫ್ ಕ್ಯಾಶ್
ಶೇರ್ ಆಗಿದೆ ಅದು 4
ಈಚ್ ರುಪೀಸ್ 1 lakh to ಶ್ರೀಮತಿ ವೆಂಕಟಲಕ್ಷ್ಮಮ್ಮ. ಆಮೇಲೆ
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1
ಸುಬ್ಬಮ್ಮ.
ಅಪಲೆಂಟ್ ನಂಬರ್ 1
ಸುಬ್ಬಮ್ಮ ಯಾರು? ನಿಮ್ಗೆ ಎಷ್ಟಮ್ಮ ಬಂತು? 1 ಲಕ್ಷ. ಆಮೇಲೆ ನರಸಮ್ಮ ನೀವಾ? ನಿಮ್ಗೂ 1 ಲಕ್ಷನಮ್ಮ. ಶ್ರೀಮತಿ ಜಯಮ್ಮ ನಿಮ್ಮೂನು 1 ಲಕ್ಷ ಬಂದಿದೆಯಾ? ನೆಕ್ಸ್ಟ್ ಬಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಐಟಮ್ ನಂಬರ್ 1 ಯಾರಿಗೆ ಹೋಗ್ತದ್ರಿ? ಅಲಾಟೆಡ್ ದ ಶೇರ್ ಆಫ್ ಶ್ರೀ ಕೆ.ವಿ. ಗಂಗಾಧರಯ್ಯ. ನೀವ ಗಂಗಾಧರಯ್ಯ? ನಿಮ್ಗೆ ಏನ್ ಆಸ್ತಿ ಬಂದಿದೆ ರೀ ಕಾಂಪ್ರಮೈಸ್ ಪ್ರಕಾರ? ಸರ್ವೆ ನಂಬರ್ 2 ಎಕರೆ 6 ಗುಂಟೆ ಸರ್ವೆ ನಂಬರ್ 4ರಲ್ಲಿ. ಮತ್ತೆ ಯಾವ್ದಿದೆ ಸರ್ವೆ ನಂಬರ್? 3/11 ಎಷ್ಟು? 8 ಗುಂಟೆ. ಆಮೇಲೆ ಸರ್ವೆ ನಂಬರ್ 71/1B ನಲ್ಲಿ 29 ಗುಂಟೆ. ಸರ್ವೆ ನಂಬರ್ 27/2ರಲ್ಲಿ 31 ಗುಂಟೆ. ಆಮೇಲೆ ಸರ್ವೆ ನಂಬರ್ 34ರಲ್ಲಿ 13 ಗುಂಟೆ. ಸರ್ವೆ ನಂಬರ್ ಇನ್ನೊಂದು ಇದೆಯಲ್ಲ ಖಾತಾ ಸೈಟ್
ಮನೆ ಎಂಜಾಯ್ ಫಾರ್ ಎ ಪೀರಿಯಡ್ ಆಫ್ 3 years.
ಒಂದ್ ಸೈಟ್ ಇದೆ, ಹೌದಾ? ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ಸಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಅಲಾಟೆಡ್ ದ ಜಾಯಿಂಟ್ ಶೇರ್ ಆಫ್ ಅನ್ನಪೂರ್ಣ. ಮತ್ತೆ ಯಾರು? ಶ್ರೀ ಭಾನುಪ್ರಕಾಶ್ ಅಂಡ್ KR ದಿಲೀಪ್. 3 ಜನನ ನೀವು? ನಿಮ್ಗೇನ್ ಬರುತ್ತೆ ಗೊತ್ತಾ? ಸರ್ವೆ ನಂಬರ್ 3/1ರಲ್ಲಿ 3 ಗುಂಟೆ, ಹೌದಾ? ಔಟ್ ಆಫ್ 11 ಗುಂಟಾಸ್ ಅಲ್ಲಿ. ಸರ್ವೆ ನಂಬರ್ 6/1C ನಲ್ಲಿ 2.5 ಗುಂಟೆ. ಆಮೇಲೆ ಸರ್ವೆ ನಂಬರ್ 6/2ರಲ್ಲಿ 31 ಗುಂಟೆ. ಸರ್ವೆ ನಂಬರ್ 27/2ರಲ್ಲಿ 31 ಗುಂಟೆ. ಸರ್ವೆ ನಂಬರ್ 34ರಲ್ಲಿ 20 ಗುಂಟೆ. ಸರ್ವೆ ನಂಬರ್ ಇನ್ನೊಂದು ಯಾವ್ದ್ರಲ್ಲೂ ಈಸ್ಟ್ ವೆಸ್ಟ್ ಮೆಜರಿಂಗ್ ಈಸ್ಟ್ ವೆಸ್ಟ್ 45 feet into north to south 21 feet.
ಮನೆ
ಐಟಮ್ ನಂಬರ್ 6, ಹೌದಾ? ನೆಕ್ಸ್ಟ್ ಡಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ವೆಂಕಟೇಶ್ ಅಪಲೆಂಟ್ ನಂಬರ್ 7 ಪ್ಲೈಂಟಿಫ್ ನಂಬರ್ 7 ಅಲಾಟೆಡ್ ಟು ದಿ ಶೇರ್. ಯಾರು? ವೆಂಕಟೇಶ್ ಯಾರು? ನೀವಾ? ನಿಮ್ಗೇನ್ ಬರುತ್ತ್ರಿ? ಸರ್ವೆ ನಂಬರ್ 6/1C ನಲ್ಲಿ 2.5 ಗುಂಟೆ, ಹೌದಾ? ಸರ್ವೆ ನಂಬರ್ 6/2ರಲ್ಲಿ 29 ಗುಂಟೆ. ಸರ್ವೆ ನಂಬರ್ 34ರಲ್ಲಿ 20 ಗುಂಟೆ. ಸರ್ವೆ ನಂಬರ್ 26/3ರಲ್ಲಿ 30 ಮುಕ್ಕಾಲು ಗುಂಟೆ. ಐಟಮ್ ನಂಬರ್ 5ರಲ್ಲಿ ನಿಮ್ಗೂ ಕೂಡ 40 feet into 16 feet. ನೆಕ್ಸ್ಟ್ ಕೃಷ್ಣಯ್ಯ ನೀವಾ? ನಿಮಗೆ ಸರ್ವೆ ನಂಬರ್ 4ರಲ್ಲಿ 1 ಎಕರೆ, ಹೌದಾ? ಐಟಮ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 26/3ರಲ್ಲಿ 1 ಎಕರೆ 4.25 ಗುಂಟೆ, 4.25 ಗುಂಟೆ. ಐಟಮ್ ನಂಬರ್ 3 ನಲ್ಲೂ ಕೂಡ 40 into 16, ಹೌದಾ? ಹೌಸ್ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ. ಸರಿ, ದಿ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ is also read out to the parties and parties have also accepted the terms and compromise, and all of them have understood the terms of the compromise, and hence terms of compromise is accepted. The respective advocates are also identified the parties, and apart from the compromise petition, sketches are also produced before the court. 6 in estidaari 7 in number, 8 in number, 8 in number, and these sketches are part of this compromise. Houdala?
It is written.
In view of the compromise entered between the parties, the registry is directed to draw the decree. Take the signature of the parties. ಸಹಿ ಮಾಡಿ ಹೋಗ್ಬೇಕು.
ಸಿಗ್ನೇಚರ್
ಅವ್ರು ಸೈನ್ ಮಾಡಿಲ್ವಾ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1
70 ಪಾಸ್ ಓವರ್. ಹಾ ಅದ್ರಲ್ಲೇನು ಇಬ್ರು ನಾನು ಹೇಳಿದ್ರು ಬಂದ್ರ ಏನು ಇಂಟ್ರಿ ಮಾಡ್ರಿಗೆ ಇಲ್ಲ ಅಲ್ಲ ಅಷ್ಟೇ ಮಾಡಿ ಡೇಟ್ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks ಅಂತ ಏನೋ ಕೊಟ್ಟಿದೀವಲ್ಲ ಅದೇ ಸೇಮ್. ಹ್ಮ್
75.
ಆರ್ ನಾಗಭೂಷಣ್. ಹಾ ಬಿ ಎಂ ಸಿದ್ದಪ್ಪ.
Application on Rule 27.
ಹ್ಮ್
Additional document and additional.
ಯಾವಾಗ ಹಾಕಿದಿರಿ ಅದು?
19 ಅಲ್ಲಿ ಹಾಕಿದೆ.
19/7 ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾರೆ ಅದರ್ ಸೈಡ್ಗೆ.
Notice served ಅಂದ್ರೆ ಅವಾಗ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿರ್ಲಿಲ್ಲ to the respondents. Therefore, copy has not been.
ಆಯ್ತು ಈಗ ಕೊಡಿ ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ.
No, now I am serving the copy.
The appellant counsel submits that an application is filed under order 41 Rule 27 and directed to subsidy. On the other side, the wakalat filed for R1 is accepted. ಇನ್ನು ಬೇರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದಾರ ಇದ್ರಲ್ಲಿ?
ಗೌರ್ಮೆಂಟ್ ಕೂಡ ಇದ್ದಾರೆ ಇದರಲ್ಲಿ, ಗೌರ್ಮೆಂಟ್ ಪಾರ್ಟಿ ಇದ್ದಾರೆ.
AGA is directed to take notice for respond number
2 to 6, 2 to 5 Swami.
2 to 5.
2 to 5. ಒನ್ನಿಗೆ ಈಗ ಅವ್ರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ. R6 ಹೊರಕೇರಪ್ಪ
ಅವ್ರಿಗೆ ನೋಟಿಸ್
ಹೋಗ್ಬೇಕು. ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನೆಸ್ಟ್ R6. The appellant, the copy ಕೊಟ್ರೆ ಇವರೇ order 41 Rule 27. The counsel R1 is given 2 weeks time to file objections if any to R1 and IA. And the registry is also directed to put up the IA filed under order 41 Rule 27. List after 2 weeks. 3 weeks ಅವ್ರು ಯಾರು ನೋಟಿಸ್ ಹೋಗ್ಬರ್ಬೇಕಲ್ಲ ಪ್ಲೀಸ್. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 3 weeks. 76 also pass over. Appointment of commissioner ಏನೋ ಇತ್ತಲ್ಲ ಇದ್ರಲ್ಲಿ?
Admission ಆಗಿಲ್ಲ.
Counsel for the appellant, my lords.
Non filing of memo along with receipt by the counsel ಏನ್ರಿ ಅದು?
ಬೆಳಗ್ಗೆ ಕಾಸ್ಟ್
ಮೆಮೊ ಏನು? ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರಾ?
ಕಟ್ಟಿದೆ.
ಅವ್ರೇನ ಬಂದಿರಲ್ಲ ಅವರ? ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರಾ?
ಕಟ್ಟಿದೆ.
ಯಾವಾಗ?
ಇವತ್ತು ಕಟ್ಟಿದೆ.
ಕೊಡಿ ಅದೇನ್ ರೆಸಿಟ್ ಏನು? ಮೆಮೊ ಹಾಕಿ ಕೊಡಲ್ವಾ?
ಮೆಮೊ
ಕೊಡಿ. The counsel for the appellant files memo
ಫೈಲ್ ಮಾಡಿದವನು.
along with the receipt for having paid the cost. Appointment of commissioner ಇದೇನೇ ಇದೆ? Statement of
Milord, admission ಆಗಿಲ್ಲ. It was posted last.
admission ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ milord.
And hence post the matter for admission.
Blessed.
Up to 2 weeks.
29.
Permission to produce the additional documents. ಏನ್ ಅರ್ಧ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ರಿ?
Respondent.
ಇದಾ ಬಂದ್ರ ಅದರ್ ಸೈಡ್? ಹೇಳ್ರಿ.
This is suit for declaration and injunction filed by the plaintiffs.
Declaration and injunction.
Yes.
Exhibit P4 ರಿಲೇ ಮಾಡಿದ್ರಲ್ಲ ಅದೇನ್ ಡಾಕ್ಯುಮೆಂಟ್?
Exhibit P4. This is the release.
ಲೀಸ್ ಡೀಡ್ ಅಂತ ಇದೆ.
Yes, sir.
ಏನ್ ಲೀಸ್ ಏನ್ ಬರುತ್ತೆ ಇದ್ರಲ್ಲಿ?
Lease
ಲೀಸ್ ಅಲ್ಲ, ರಿಲೀಸ್.
Released mortgage.
ಲೀಸ್ ಅಲ್ಲ.
Release.
Redemption of
mortgage.
Redemption of mortgage in whose favor?
In favor of the plaintiff's fathers. No, next up, one Veera Nayak. One Veera Nayak.
ವೀರನಾಯಕ. ವೀರನಾಯಕ ಯಾರು?
ಅಲ್ಲ, ತಿಮ್ಮಯ್ಯ has got teeth reasons. ತಿಮ್ಮಯ್ಯ family trees were explained. In para 3 of the plaintiff were explained. One proposed, namely Timmaya had got 3 sons.
ಆಯ್ತು ರೀ, ರಿಡಂಪ್ಷನ್ ಆಫ್ ಮಾರ್ಟ್ಗೇಜ್ ಯಾರ ಎಕ್ಸಿಕ್ಯೂಟ್ ಯಾರಿಗ್ ಮಾಡ್ಕೊಟ್ರು ಹೇಳಿ?
Exhibit.
You are relying upon exhibit P4.
P3 and P4.
ತಿಮ್ಮಯ್ಯನವರಿ
Huh?
ತಿಮ್ಮಯ್ಯನವರಿ ಅಮ್ಮನಗಟ್ exhibit V4
Really, ಅದೇ redemption of mortgage in favor of whom?
This is the document.
Hmm?
This is the document, the redemption of mortgage deed.
ಸರಿ ನೀವು ಓದ್ ಹೇಳ್ರಿ
Yes,
ಯಾವ್ದಿಂತ?
yes.
ಯಾರ ಪರವಾಗಿಂತ ಯಾರು ಯಾರ
1977
1979
79ನೇ ಇಸವಿ
ಇಸ್ವಿ
ತಾರೀಕು
ತಾರೀಖ್
3ರಲ್ಲಿ
13ರಲ್ಲೂ ಗುಬ್ಬಿ ತಾಲೂಕು
ತಾಲೂಕು
ಕಸ್ಬಾ
ಕಸಬಾ ಹೋಬಳಿ
ಹೋಬಳಿ
ಅಮ್ಮನಘಟ್ಟ ಗ್ರಾಮದಲ್ಲಿ
ಅಮ್ಮನಘಟ್ಟ ಗ್ರಾಮದ ಚೆನ್ನೇಗೌಡ
ಗೌಡ
ಕುಟುಂಬ
ಕುಟುಂಬದ ಸಿದ್ದನಂಜಮ್ಮ
ಸಿದ್ದ ನಂಜಮ್ಮನಾದ ನಾನು
ನಾನು ಡಿಟೋ ಅಮ್ಮನಘಟ್ಟ
ಅಮ್ಮನಘಟ್ಟ
ಗ್ರಾಮದ
ಗ್ರಾಮದ ಹೊಸ ಹಟ್ಟಿ
ಹಟ್ಟಿ ಜಾರಿ ತಿಮ್ಮಯ್ಯನವರ
ತಿಮ್ಮಯ್ಯನ ಮಗ ಪೂಜಾರಿ
ಪೂಜಾರಿ ಚಿತ್ತಯ್ಯ ಇದು
ಚಿತ್ತಯ್ಯನಿಗೆ
ಹೌದು
ಚಿತ್ತಯ್ಯ ಯಾರು?
ಇದು ಪ್ಲೈಂಟಿಫ್ಸ್
ಹಾ
ಪ್ಲೈಂಟಿಫ್ಸ್
ಚಿತ್ತಯ್ಯ ಇದೆ.
ಚಿತ್ತಯ್ಯ is the purchaser. ಚಿತ್ತಯ್ಯ is the purchaser of ಕರಿ ತಿಮ್ಮಯ್ಯ.
No, your lordship ಕಳಿಸಿ. That
ಅಲ್ಲಲ್ರಿ?
is in the 1940. That is in the 1949. He has purchased a property and
From ಚಿಕ್ಕಮ್ಮ.
ಚಿತ್ತಯ್ಯನಿಗೆ
Wife of ಕರಿ
ಚಿತ್ತಯ್ಯನಿಗೆ ಬರೆದು ಕೊಟ್ಟ ಹಣ ಸಂದ ರಸೀದಿ ಏನೆಂದರೆ
yes, ಇದು
ಅಂದ್ರೆ ಈ ಕರಿ ತಿಮ್ಮಯ್ಯನ ಹೆಂಡತಿ ಚಿಕ್ಕಮ್ಮ sold the property in favor of ಚಿತ್ತಯ್ಯ
that is in
with a condition to get the redemption deed from the ಸಿದ್ದ ನಂಜಮ್ಮ. ಹೌದಾ?
that
And
is an
also an amount of rupees 500 was kept pending with the ಚಿತ್ತಯ್ಯ
ಚಿತ್ತಯ್ಯ.
to make the payment in favor of ಸಿದ್ದ ನಂಜಮ್ಮ.
Yes.
And hence
but
how the
suit is-
court can rely upon this document and grant the relief of declaration in favor of you?
suit is filed, the suit is filed by the plaintiff.
You are not
Again-
answering to my question. Crux of the
I-
issue is this.
After this,
ಈ ರಿಲೀಸ್ ಡೀಡ್ ಏನಿದೆಯಾ ಅದು ಇನ್ ಫೇವರ್ ಆಫ್ ಚಿತ್ತಯ್ಯ. ಚಿತ್ತಯ್ಯ is the purchaser of the property from ಕರಿತಿಮ್ಮಯ್ಯ's wife. ಹೌದಲ್ಲ?
ನಾಳೆ
ಹಾ?
ನಾಳೆ
ನಾಳೆ ಏನಿಲ್ಲ, ರಿಮೈಂಡ್ ಮಾಡೋಣ
ಇಲ್ಲ.
ಅಷ್ಟೇನೆ. ಕಾಸ್ಟ್ ಹಾಕ್ತೀನಿ ಅವರಿಗೆ. They have not contested the matter.
and
And
they have not
trial
contested.
court comes to the conclusion in paragraph number 14. I
Yes, yes.
underlined it. ನೋಡಿ.
Yes, yes.
The father of the plaintiffs was the absolute, ಅದಕ್ಕಿಂತ ಮುಂಚೆ owner has mortgaged the same in favor of mother of
Mother
defendant
of
number
the
1 and 2.
defendant,
Mother of
defendant 1 and
defendant number 1
2.
and 2, no
Yes.
dispute.
Yes.
ಹೌದಾ?
The suit is-
Again redeem the said property under exhibit P4 ಅಂದ್ರು. ಯಾರ ಪರವಾಗಿ ಏನು ಇಲ್ಲ. Therefore the father of the plaintiff was the absolute owner in possession of the suit said property ಅಂತ ಬರೀತಾರೆ. How could
Now
when the mother already sold the property in favor of the ಚಿತ್ತಯ್ಯ with a condition to get the redemption from ಸಿದ್ದ ನಂಜಮ್ಮ and also document exhibit P4 is the redemption deed in
It is
favor
it.
of ಚಿತ್ತಪ್ಪ. ಹೌದಲ್ಲ? How a court can grant the relief of declaration in favor of the plaintiffs?
the suit
ಒಂದ್ ಕಡೆಯಿಂದ ಪ್ರಾಪರ್ಟಿ ಮಾರಾಟ ಮಾಡೋದು, ರೈಟ್ ಆಫ್ ರಿಡಂಪ್ಷನ್ ಕೊಡೋದು ಪರ್ಚೇಸರ್ಗೆ, ಅವನ್ ಪರ್ಚೇಸರ್ಗೆ ರೈಟ್ ಆಫ್ ರಿಡಂಪ್ಷನ್ ಪ್ರಕಾರ ರಿಡೀಮ್ ಮಾಡಿದ್ದಾರೆ ಅಂಡ್ perfected the title by executing the redemption deed in favor of the purchaser. And how a court can grant the relief in favor of the original owner?
the suit is filed by the plaintiff against the defendant 1 and 2.
ಹೌದು.
And defendant subsequently they got impleaded. Even the
ಅದೇ
sufficient opportunity,
ಕಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ಲ, ಅದಕ್ಕೆ ಕಾಸ್ಟ್ ಹಾಕ್ತೀನಿ ಈಗ. ಯಾಕೆಂದ್ರೆ ಎರಡು
the sufficient opportunity has given.
ಆಪರ್ಚುನಿಟಿ ಗಿವನ್, ಬಟ್ ಟ್ರಯಲ್ ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ನೋಡ್ಬೇಕಿತ್ತು ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರೆ ಅವರು ಅಂತ. ನೋಡಿಲ್ಲ.
This document also referred in the first appellate court.
ಹೌದ್ರಿ, ಈ ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡ್ಬೇಕಿತ್ತು ಎಕ್ಸಿಬಿಟ್ P4 ನ. P4 redemption deed in favor of the ಚಿತ್ತಯ್ಯ. How can the court can comes to a conclusion that exhibit P4 is the redemption in favor of the original owner? Relying upon their document, a declaration is granted in favor of you. This matter is listed for admission and I heard the counsel appearing for the appellant and also the counsel appearing for the respondent. The factual matters of case of the plaintiff before the trial court while seeking the relief of declaration and injunction, at the first instance filed the suit against defendant number 1 and 2. Defendant number 1 and 2 are the sons of original mortgage. It is also the contention that the plaintiffs are the sons of above said Karitimaya. The suit schedule property along with other properties had fallen to the share of Karitimaya in the said partition. Karitimaya was the absolute owner in possession of the suit schedule property. The plaintiffs have succeeded to the suit schedule property as class 1 heirs of legal heirs. After the death of said Karitimaya, the plaintiffs are in possession and enjoyment of the suit schedule property as absolute owners. One Chennai Goda had got wife by name Siddhan Anjamma, and the defendants are the sons of Siddhan Anjamma. Said Siddhan Anjamma expired few years back, leaving behind the defendants as a class 1 heirs. During the lifetime of above said Karitimaya, he executed an usufructuary mortgage deed in favor of late Siddhan Anjamma and a registered deed dated 16/8/1949. And Siddhan Anjamma was put in possession of the scheduled property, and the said mortgage was a period of 5 years. In the year 1959, when the plaintiffs were minors, their father Karitimaya redeemed the mortgage executed in favor of said Siddhan Anjamma by paying the mortgage amount to her. 59 alagide ಏನ್ರಿ?
59.
57 no? 59
59.
59.
Redeemed the mortgage executed in favor of Siddhamma by mortgage amount to her. In turn, said Siddhan Anjamma returned the said original registered mortgage deed executed in her favor to the possession of Karitimaya, the father of the plaintiffs. But ಈ document ಅಲ್ಲಿ ಇದೆ 1959 document redeem ಮಾಡಿರೋದು.
Redeem ಮಾಡಿರೋದು
Thereby the said Siddhan Anjamma redeemed the mortgage made in favor and put the father of the plaintiff in possession of the suit property by stating the same. From that day, the father of the plaintiffs was in possession and enjoyment of the suit property as absolute owner thereof. The defendants having no manner of right, title, interest, possession and enjoyment of the suit property, taking advantage of the revenue entry standing in the name of their mother Siddhan Anjamma, made attempt to interfere with peaceful possession and enjoyment of the suit property of the plaintiff by denying the title of the plaintiff. So ನೀವೆಲ್ಲ ಹಾಕಿದಿರಿ 1959 ಡಾಕ್ಯುಮೆಂಟ್ ರಿಡೀಮ್ ಮಾಡಿದ್ಕೆ?
ಅವರೆಲ್ಲ ಸಬ್ಸ್ಟೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ನಾವು ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ವಿ.
ಇರ್ಲಿ ರೀ, ತಡೀರಿ. And made attempts to ಅದಾಯ್ತು. And hence suit is filed for the relief of declaration and injunction. Defendant number 1 and 2 appeared and filed the written statement. It is their specific case that plaintiffs, without being in the actual possession, have filed the suit for the title and possession, and the same is not maintainable. It is also contended that during the lifetime of Karitimaya, he had executed a registered mortgage deed in respect of suit property on 16/8/1949. Since the date, said Siddhan Anjamma along with her sons, defendants are in physical possession and enjoyment of the suit property and growing the arakanut and coconut trees. They said the Siddhan Anjamma passed away a few years back, and defendants are being the legal heirs. They are in physical possession and enjoyment of the suit property. The trial court, having considered the pleadings of the parties, framed the issues. And allowed the parties to lead evidence. And trial court, having considered the material on record, comes to the conclusion that the plaintiff's father got redeemed the suit property from Siddhan Anjamma. And plaintiffs are in lawful, and plaintiffs are not in possession of the are in lawful possession of the suit property, and defendants are restrained from interfering with peaceful possession and enjoyment of the suit property. by decreeing the suit. It is the next. It is also brought to the notice of this court that defendants 3 to 6 filed an application to implead them as parties and they were impleaded, but they have not filed any written statement and contested the matter before the trial court. Being agreed by the said judgment and decree, an appeal is filed by the defendant number 3 to 6. They are filed the matter, they are defendant number 4.
Yes,
Opening
4.
Defendant number 4.
4 as per, in both in RA and.
And the first appellate court also having considered the material and record confirmed the judgment of the trial court. The appellant also filed 3 applications, 2 applications, IA number 4 and IA number 6. To implead the the proposed respondents ಅಂದ್ರೆ ಯಾರು?
ಇವರ ಸರ್ ಡಿಪೆಂಡೆಂಟ್ ನಂಬರ್ 3 to 6.
ಅವ್ರನ್ನ ಬಿಟ್ಟೋದವ್ರನ್ನ ಅಪೀಲ್ ಹಾಕುವಾಗ ಬಿಟ್ಟಿರ್ಲಿಲ್ಲ.
ಒರಿಜಿನಲ್ ಓನರ್ಸ್.
Made an application to implead the other defendants who have not filed any appeal before the ಮಾಡಿದಿರಲ್ಲ ಇಲ್ಲಿ
ಮಾಡಿದಾರಲ್ಲ ಮಾಡಿದ್ರು ಪ್ರಪೋಸಲ್ ಅಂತ ಬರ್ದಾರ.
ಆರ್ಯನಲ್ಲಿ ಇದಾರಲ್ರಿ ಅವರು?
ಆರ್ಯದಲ್ಲಿ ಇದಾರೆ ಸರ್. ಅವತ್ತು ಸೇಮ್ ಡೇನೆ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಅಲೋ ಆಗಿದೆ ಅವತ್ತು ಅಪ್ಲಿಕೇಶನ್.
ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲ ರೀ ಆರ್ಯನಲ್ಲಿ ನೀವೇನೋ
IA
4 ಒಂದು IA 6 ಒಂದು ಹಾಕಿದಿರಲ್ಲ ಏನದು?
IA 6 ಅದೇ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್.
ಯಾರನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಬೇಕು ಅಂತಾರ್ರಿ?
The same parties.
ಸೇಮ್ ಪಾರ್ಟೀಸ್ ನ ಮತ್ತೆ ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಬೇಕು, ನೀವು ಆಲ್ರೆಡಿ ಮಾಡಿದಿರಲ್ಲ?
ಹೌದು, ಅವತ್ತು ಸೇಮ್ ಡೇ ಆಗಿದೆ, ಅದು ತಪ್ಪು ಬರ್ದಿದ್ದಾರೆ. ಪ್ರಪೋಸಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂದ್ರೆ ರಾಂಗ್ ತಗೊಂಡಿದ್ದಾರೆ ಸರ್.
IA 6 ಅಲ್ಲಿ ಏನ್ ಕೇಳಿದಿರ್ರಿ ನಿಮ್ ಪ್ರೇಯರು?
IA 6 ಅಲ್ಲಿ
ಯಾಕೆಂದ್ರೆ ಇವ್ರು ನೆಗೆಟಿವ್ ಅಂತ ಮಾಡಿದಾರೆ ಏನು ಪಾಯಿಂಟ್ ನಂಬರ್ 3 ನ ಅಪ್ಲೈಡ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
IA 6.
Stated that in the pendency of the appeal, the respondents have sold the suitable property land to the proposed respondent number 1.
Additional
And the proposed respondent number 1 has sold the property, proposed respondent number 2 to defeat the right of the plaintiff. Subsequent purchaser, to make the subsequent purchaser as parties to the suit. And also filed another IA before the appellate court under order 41 rule 27, and the same is numbered as IA number 7. To produce the documents for deciding the appeal. The trial court, the first appellate court, having considered the material and record accorded, comes to the conclusion that opportunities accorded to the defendant number 4 to put forth his case. And also the trial court is justified in decreeing the suit of the plaintiffs for the relief of declaration and permanent injunction, and answered the point number 3 and 4 as negative in respect of 2 IAs filed by them. And also comes to the conclusion that judgment and trial court, judgment and decree of the trial court is not illegal and contrary to law, and it doesn't require any interference. And confirm the judgment of the trial court. Hence, the second appeal is filed before this court. The main contention of the counsel appearing for the appellant before this court that those they have been impleaded as party to the proceedings. ಯಾವಾಗ ನೀವು ಇಂಪ್ಲೀಡ್ ಆಗಿದೆ ಯಾವ ಇಯರ್ ಅಲ್ಲಿ?
2013 ಅಲ್ಲಿ 13/6/2013
ಯಾವಾಗ?
13/6/2013.
Impleaded as defendants on 13/6/2013. They could not file the written statement and contest the matter before the trial court. Reason ಏನು? ಈಗೇನ್ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿದ್ರಿ?
ಅದು ನಮ್ಮ ತಾಯಿಗೆ ಹುಷಾರಿರಲಿಲ್ಲ ಅಂತಂದೇಳಿ, ನಮ್ಮ ತಾಯಿಗೆ ಹುಷಾರಿಲ್ಲ, ಅವರ ಆರೋಗ್ಯನ ಟೇಕ್ ಕೇರ್ ಮಾಡಕ್ಕೋಸ್ಕರವಾಗಿ.
On the ground that the mother of the appellant was not keeping well, and hence he was taking care of the mother, and hence could not file the written statement. The counsel also submits that
In the appellate court also take a same contention. In the appellate court also, they are taking same contentions. But no document has produced before the appellate court to substantiate that the non-filing of the written statement is in time.
it is also the contended the trial court has committed a grave error when the application was filed before the trial court and allowed the same, ought to have issued the summons to the defendant number 3 to 6 to serve the copy of the plaint. And in
They-
spite of the same, trial court has served, in spite of the same, trial court has served the copies of pleadings directly to the counsels for the defendants and posted the case for filing written statement of defendant number 3 to 6. Due to non-serving of the copies of pleadings of the case, the defendant number 3 to 6 could not file the written statement. The trial court, taking this undue advantage of the same on 31/2014, recorded its file that the written statement was not filed, which leads to the miscarriage of justice.
They got as impleaded as a parties.
It is also contended that suit scheduled property was purchased by their grandfather Chittaya under the sale deed dated 10/6/1957. And further taken the contention that defendant number 3 to 6 are all having equal rights over the suit scheduled property. The trial court ought to have taken note of the said fact into consideration while disposing of the matter. Even first appellate court also failed to consider the grounds which have been urged before the first appellate court while filing an application under Order 41/27, seeking permission to produce the document of the sale deed of the year 1957. 1957. ಆಮೇಲೆ ಏನೇನ್ ಹಾಕಿದ್ರಿ ನೀವು? Along with application order 41/27 ಅಲ್ಲಿ along with the list of documents.
Registered sale deed ಒಂದು
1957.
ಆಮೇಲೆ
Redemption deed ಹಾಕಿದಿರಾ?
ಹೌದು ಆಗಿದೆ sir.
And redemption of mortgage deed executed by Siddhananjamma in favor of the father of the defendants.
ಚಿತ್ತಯ್ಯ
Huh?
ಚಿತ್ತಯ್ಯ
Chittaya. Father of the defendants, that is Chittaya. ಆಮೇಲೆ ಇನ್ನೇನ್ ಹಾಕಿದಿರಿ?
ಒಂದು ವಿಲ್ ಹಾಕಿ ಒಂದು ವಿಲ್ ಡೀಡ್ ಹಾಕಿ
Will.
ವಿಲ್
Will executed by whom? And other documents along with the application. And the application filed under Order 41/27 is rejected, and the document of sale deed and redemption document which was produced before the first appellate court clinches the issue between the parties and ought not to have dismissed this same, and hence, and also no proper opportunity was given to the defendant number 3 to 6 by the trial court. And the order passed by the appellate court in dismissing the number 7 is also erroneous, and hence this court has to admit and frame substantive question of law. The counsel appearing with the respondent would vehemently contend that even though they came on record in the year 2013 itself, they have not filed any attachment in spite of opportunity was given. And when the documents are not placed before the trial court and also not produced any evidence before the court, the trial court, having considered the material on record, rightly declared the suit. And appellate court also confirmed the same, and while rejecting the application, while answering the point number 4 also comes to the conclusion that when the opportunity was given, no such documents are produced by the appellants and not put forth any defense by producing the said documents, and even after exercising due diligence also he was not able to produce the documents before the trial court and not made out any case, and rejected the application filed under Order 41/27. Having heard the appellant counsel and also the counsel appearing for the respondent, it is not in dispute that the property belongs to the Karitimmaya. It is also not in dispute that a mortgage deed was executed in favor of the Srimati Siddhananjamma. It is the claim of the plaintiffs before the trial court that the mortgage was redeemed in favor of Karitimmaya in the year 1959. Allah? 59. On the other hand, it is the contention of the appellants before this court and also before the first appellate court that the very wife of Karitimmaya had executed the sale deed in the year 1967. ಹೌದಲ್ಲ?
ಹೌದು.
1967 in favor of the Chittaya,
57.
ಅದು 57 Chittaya,
10-6-19.
with a condition to get it redeem the mortgage from Siddhananjamma.
Yes.
And the amount of rupees 500, the 500 is left with the purchaser to get it redeem the same. Accordingly, he said Siddhananjamma receiving the amount of rupees 500 executed the redemption deed in favor of Chittaya. The council also, the exhibit P4, which is marked before the
In the second page.
59 there, redeem ಆಗಿರೋದು, ನಾಟ್ ನಿಮ್ಮ ಪರವಾಗಿರೋದಲ್ಲ,
ಇಲ್ಲ,
ಇದು exhibit
ಅದರಲ್ಲಿ
P4.
exhibit P4 ಅಲ್ಲಿ
ಅದು ಸೇರಿಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿರೋದು 57 ಅಲ್ಲಿ, ರಿಡೀಮ್ ಆಗಿರೋದು 59.
ರಿಡೀಮ್ ಆಗಿರೋದು 59 ಅಲ್ಲಿ. ಓ, ಅದ ಆತರ ನೀವು ನಿಮ್ಮವ್ರು ಕನ್ಫ್ಯೂಸ್ ಮಾಡೋರು ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ಅದರಲ್ಲಿ ಇದು 57 ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪೇಜ್ ಲಾಸ್ಟ್
And also council would submits that the redemption
Second
deed
page.
was executed by Siddhananjamma in favor of the Chittaya, who is the purchaser, in terms of exhibit P4. The trial court did not, having considered the material on record, the trial court did not consider this document and not even read the recitals of the document, the redemption in favor of the Chittappa, not in favor of the Karitimaya,
Chittaya.
and the Karitimaya. But the trial court comes to the conclusion that in paragraph number 14, that the mortgage deed was redeemed in favor of the plaintiff's father, and hence plaintiff's father become absolute owner of the possession of the suitable property. This reasoning given by the trial court is erroneous and did not look into the document of exhibit P4, and they said redemption deed executed in favor of Chittaya and not in favor of the original owner Karitimaya, but proceeded in an erroneous approach that the redemption deed was executed in favor of the father of the plaintiff. And the conclusion arrived by the trial court that the plaintiffs, the father of the plaintiff was the absolute owner in possession of the suitable property in terms of exhibit P4 is erroneous, and did not look into the recitals of the document, and also the document registered in favor of the Chittaya, who had in the year 1959, who had purchased the property in the year 1957 itself. No doubt the appellants herein have not filed return statement and not questioned, not produced any document before the trial court. Even the judgment of the trial court apparent on erroneous apparent on the record relying upon the document of exhibit P4. Apart from that, the document of the mortgage deed, sale deed are produced before the appellate court, seeking an opportunity to produce the evidence that already sale was made in the year 1957 itself, and subsequently redemption document was also executed in favor of the appellants herein. And the appellate court, while considering the document, ought to have considered Order 41 Rule 27 with regard to the Germany issues involved between the parties. And no doubt there is a lapsus on the part of the appellants not filing return statement as well as producing all these documents before the trial court. Even the trial court also did not look into the document of exhibit P4, and the said document was produced before the trial court itself, which shows the redemption of mortgage executed in favor of Chittaya, who is the purchaser. And the first appellate court also not looked into the document of additional document produced before the appellate court, and committed an error in dismissing the IA number 7 in coming to the conclusion that not made out any ground to invoke Order 41 Rule 27, and hence it requires the reconsideration, and the order passed by the appellate court requires to be set aside regarding the rejection of IA number 7, and consequently the allowing the dismissing of the appeal also requires to be set aside, and matter requires to be remitted back to the first appellate court to consider the additional evidence, and also allow the appellants to file a written statement and lead additional evidence before the first appellate court. In view of lapses on the part of the appellants ಕಾಸ್ಟ್ ಆಫ್ rupees 1 lakh is imposed on the appellants. ಎಷ್ಟ್ರಿ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲಿರೋದ್ರಿ ಇದು?
ಗುಬ್ಬಿ ತಾಲೂಕು ಸರ್. ಗುಬ್ಬಿ
ಗುಬ್ಬಿ
ತಾಲೂಕು.
ತಾಲೂಕು. ಎಷ್ಟು ಬೆಲೆ ಬಾಳುತ್ತೆ ಈಗ?
1 ಲಕ್ಷ.
ಎಷ್ಟಿದೆ ಇದು ಎಕರೆ ಎಷ್ಟು ಜಾಗ ಇರೋದು?
2 ಎಕರೆ 27 ಗುಂಟೆ.
2 ಎಕರೆ
27 ಗುಂಟೆ.
More than 20
21
lakhs
ಗುಂಟೆ.
ಇದೆ
27.
per acre.
ಹಾ?
More than 20 lakhs per acre.
per acre.
Yes.
ಉಡಿ ಕಾಸ್ಟ್ ಆಸ್ತಿ ಉಳಿಬೇಕಲ್ಲ, ಏನ್ ಮಾಡೋದು? ಇಲ್ಲಿ ಒಂದು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಮಾಡ್ತಿರ್ಲ. Impose cost of rupees 1 lakh.
ಇಲ್ಲ ಅರ್ಧ ಮಾಡಿ.
Out of that, an amount of rupees 50,000 is payable to the yaru plaintiffs. And the remaining 50% is vest with the state. The vest with the state state. In view of the discussions made up, I pass the following order. The appeal is allowed. Judgment for the trial court as well as the first appellate court are set aside. Matter is referred back to the first appellate court to give an opportunity to the appellants herein to file WS. Akin munche.
WS ಅಂದ್ರೆ trial court.
Set aside, matter remitted back to the first appellate court to press consideration. The parties are directed to appear before the first appellate court on 27th of August, 27th of August without expecting any notice from the first appellate court.
Statement has to file before the trial court.
ಅದನ್ನೇ ಹೇಳ್ತೀನಿ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ, ಇಲ್ಲೇ ಮಾಡ್ತಾರೆ ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲ. ಮತ್ತೊಂದು ರೌಂಡ್ ಮತ್ತೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹೋಗೋದು ಬೇಡ. ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲೇ ಹಾಕಿರೋದ್ರಿಂದ ಅಲೋ ಮಾಡ್ಬೇಕಿತ್ತು ಅವರು. ನೆಕ್ಸ್ಟ್, ದಿ ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಈಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಗಿವ್ 1 month ಟೈಮ್. ಅಲ್ಲ, ಹಿಂಗ ಹಾಕ್ಬಿಡಿ. ದಿ ಅಪಲೆಂಟ್ಸ್ ಹಿಯರ್ ಇನ್ ಆರ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಫೈಲ್ ದೇರ್ WS within 1 month from 27/8/2024, and thereafter the first appellate court frame issues and also allow the parties to lead their evidence to substantiate their case. The suit is of the year ಯಾವ ವರ್ಷದ್ರಿ ಇದು? 2004.
Yes.
Suit is of the year 2004. Already 20 years has been elapsed, and hence directed to dispose of the same within 6 months from 27/8/2024. The respective parties and their counsels are directed to assist the trial first appellate court in disposal of the case as stipulated. Full stop. The cost of rupees 1 lakh. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಹಂಗೆ ಇದನ್ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್. ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಮೇಲೆ ಹೇಳಿದ್ನಲ್ಲ, ಅದಲ್ಲೇನು ಹೇಳ್ಬೇಡ. ರಿಕ್ವೈರ್ಸ್ ಟು ಬಿ ಇಂಪೋಸ್ ದಿ ಕಾಸ್ಟ್ ಅಂತ ಹಾಕಿ. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಸೆಟ್ ಅಸೈಡ್ ಬಂತಲ್ಲ, ಸೆಟ್ ಅಸೈಡ್ ಅಲ್ಲೇ ಅಲೋಡ್ ಆನ್ ಸೆಟ್ ಅಸೈಡ್ ಆನ್ ಕಾಸ್ಟ್ ಆಫ್ rupees 1 lakh ಅಂತ ಹಾಕಿ. ನೆಕ್ಸ್ಟ್, ದಿ ಅಪಲೆಂಟ್ಸ್ ಆರ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಡೆಪಾಸಿಟ್ ದಿ ಕಾಸ್ಟ್ ಅಮೌಂಟ್ ಆನ್ ಆರ್ ಬಿಫೋರ್ 27/8/2024 before the trial court. Out of that, 50,000 is payable to the plaintiffs and remaining 50% vest with the state. ಇದು ರೆಕಾರ್ಡ್ ಬಂದಿಲ್ಲ ಅಲ್ಲ ಇದರಲ್ಲಿ? ಇಲ್ಲ. ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ, ಬೇರೆ ಬರೋದಿಲ್ಲ.
ಒಂದ್ ಸಬ್ಮಿಷನ್
ಏನ್ ಹೇಳಿ?
ಕಾಸ್ಟ್ 1 ಲಕ್ಷ ಜಾಸ್ತಿ. ಕಾಸ್ಟ್ 1 ಲಕ್ಷ ಜಾಸ್ತಿ ಆಯ್ತು.
ಅಲ್ಲ ರೀ, ನೀವು 2013 ಅಲ್ಲ ಯಾವಾಗ್ಲೂ ರೆಕಾರ್ಡಿಗೆ ಬಂದಿರೋದು.
ಅವರೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡ್ ಬಂದಿದ್ದೆ.
ನೀವೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡ್ಬಂದು ನೀವೇ ಹೋಗ್ದವ್ರು ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
50,000
ಹಾಕಿರೋದು
50,000.
ಅವ್ರು ಬಂದವ್ರಲ್ಲ ಈಗ 3 ಕೋಟಿಗೆ ಖರ್ಚು ಮಾಡ್ಕೊಂಡು. ಅಲ್ಲೇ ಆಯ್ತು, ಅಪಿಲೇಟ್ ಕೋರ್ಟ್ ಆಯ್ತು, ಈಗ ಇಲ್ಲ ಆಯ್ತು, ಲಾಯರ್ ಫೀಸ್ ಇಟ್ಕೊಂಡಿರೋದು. ಅದಕ್ಕೆ ಪ್ಲೇಂಟಿಫ್ಸ್ 50,000, 3 ಕೋರ್ಟಲ್ಲಿ ಕೇಸ್ ನಡೆದಿದೆ, ಅದಕ್ಕೆ ಸರ್ಕಾರಕ್ಕೆ 50,000. ಸರಿ ಆಯ್ತು. ನಿಮ್ಗೆ ಆಸ್ತಿ ಉಳಿಬೇಕು ಅಂದ್ರೆ ಅದೇ ತಾನು ಉಳಿದಿರೋದು. ಹಾ, ಅಲ್ಲ ರೀ, ನೀವುಗಳುವೆ 59 ಅಲ್ಲಿ ರಿಡಂಪ್ಷನ್ ಮಾಡಿರೋದು ಅವ್ರ ಪರವಾಗಿ ರಿಡಂಪ್ಷನ್ ಮಾಡಿದ್ರೆ ನೀವು ಹೋಗಿ ಕ್ಲೈಮ್ ಮಾಡ್ಬಿಟ್ಟು ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ ಹಾಕೊಳ್ತೀರಲ್ಲ.
ಅದರಲ್ಲಿ ಅಮೌಂಟ್ ಎಸ್ ರಿಸೀವ್ಡ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ರಿಸೀವ್ಡ್ ಬೈ ದಿ ಮಾರ್ಗೇಜ್ ಅಂತ ಹೇಳಿ.
ಸರಿ ರೀ, ಅವ್ರ ರಿಡಂಪ್ಷನ್ ಡೀಡ್ ನ ನೀವು ಹಾಕ್ಬಿಟ್ಟು ಅದನ್ನ ಕೋರ್ಟ್ ಅವರು ನೋಡೋದಿಲ್ಲ, ನೀವು ನೋಡೋದಿಲ್ಲ, ಎಲ್ಲಾರು ಸರಿಯಾಗಿದ್ದೀರಿ. ಹಾ, ಆಯ್ತು. ನೆಕ್ಸ್ಟ್
109 P. Nataraju, Abubakar Shafiq.
109 appears for the respondent below.
ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಮತ್ತೆ ಬರೋದ್ರನ್ನ ತಪ್ಪಿಸಿದೀನಿ. ಈಗ ಬಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಇಲ್ಲಿಗೆ ಬರ್ಬೇಕು, ಡಿಸೈಡ್ ಆಗಿ.
109 appear for the respondent below.
ನೈನಾ?
ಹೌದು ಸ್ವಾಮಿ.
109.
ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಅಂಡ್ ಸಪರೇಟ್ ಪೊಸೆಷನ್. ಕಂಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ. ಪ್ಲೈಂಟಿಫ್ಸ್ ಮತ್ತೆ ಡಿಫೆಂಡೆಂಟ್ಸ್ ನಡುವೆ ಯಾವುದೇ ರೀತಿಯಾಗಿ ಫ್ಯಾಮಿಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಏನಿಲ್ಲ ಸ್ವಾಮಿ. ಅರ್ಲಿಯರ್ ಆಗಿ ಅವರು ಮದುವೆ ಆಗಿತ್ತು ಅಂತ ಹೇಳಿ ಪಾಲ್ಪಾರಿಕತ್ ಆಗಿದೆ. 1996 ಅಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ D14 ಪ್ರಕಾರ
ಥರ್ಡ್ ಅಲರ್ಟ್ ಆಗಿದೆ.
ಹೌದು ಸ್ವಾಮಿ, ಆಗಿದೆ. ಬಟ್ ಏನು ಅಂತ ಹೇಳಿದ್ರೆ ಇದರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ಗೂ ನಡೀತಿದೆ. ಮಾತುಕತೆ. ಯಾಕಂದ್ರೆ ಇವ್ರು
ಕಾಂಪ್ರಮೈಸ್
ಯಾರು
ನಡೀತಿಲ್ಲ ಸ್ವಾಮಿ, ಯಾವುದೇ ಕಾಂಪ್ರಮೈಸ್ ನಡೀತಿಲ್ಲ. ನಮ್ಮ ಪಾರ್ಟಿ
ಫ್ಯಾಮಿಲಿಲಿ
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ,
ಸ್ವಾಮಿ ಹೇಳಿದ್ದಾರೆ,
ಕಾಂಪ್ರಮೈಸ್
ಅವರೇ
ಇಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕ್ರಾಸ್
ಅಂದ್ರೆ
ಎಕ್ಸಾಮಿನೇಷನ್
ಅವರು
ಹೇಳಿದ್ದಾರೆ.
ಬಿಕಾಸ್
ನಮ್ಮ ಮತ್ತೆ ನಮ್ಮ
ನಮಗೆ
ಅಣ್ಣ
ಏಜ್
ತಮ್ಮಂದಿರ
ಆಗಿದೆ,
ನಡುವೆ ಯಾವುದೇ ರೀತಿಯಾಗಿ ವೈಮನಸ್ಯ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಕ್ಲಿಯರ್ ಆಗಿ
ಏಜ್
ಹೇಳಿದ್ದಾರೆ.
ಆಗಿದೆ, ಜಸ್ಟ್ ಟು ಡ್ರಾಗ್
ಬಟ್
ಆನ್
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಮಾಡಲಿಕ್ಕೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಮಾತುಕತೆಲಿ ಇದೆ.
ಇಲ್ಲ
ಈಗ
ಇಲ್ಲ,
ಇದು ಒಂದು
ಡೆಫಿನೆಟ್ಲಿ
ಶೆಡ್ಯೂಲ್
ಇಲ್ಲ. ನನಗೆ
ಐಟಮ್ ನಂಬರ್
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ರಾತ್ರಿ ಫೋನ್ ಮಾಡಿದ್ದೇನೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರನೇ
ಇಲ್ಲ
ಕೇಳ್ತಿರೋದು.
ಇಲ್ಲ, ಯಾವುದೇ
ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್
ಕಾಂಪ್ರಮೈಸ್
ಒಂದ್
ಇಲ್ಲ.
ರೆಫರ್ ಮಾಡಿದ್ರೆ ಒಂದು
ಇಲ್ಲ
ಆಪರ್ಚುನಿಟಿ
ಇಲ್ಲ
ಕೊಟ್ಟು
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಮೀಡಿಯೇಷನ್
ನಮ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ನಿನ್ನೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕಾಂಪ್ರಮೈಸ್ ಯಾವುದೇ ಕಾಂಪ್ರಮೈಸ್ ಇಲ್ಲ. ನಾನು
ಅಪೆಲೆಂಟ್ಸ್ ನಂಬರ್
ಗೌರಮ್ಮ.
ಗೌರಮ್ಮ ಪ್ಲೈಂಟಿಫ್ ಸ್ವಾಮಿ.
ಹಾ, ಆಕೆ ಸಿಸ್ಟ್ರಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಯಾರಿಗೆ ಸಿಸ್ಟ್ರು?
ಮಹಾಂತ ದೇವರು ಮತ್ತೆ
ರಾಜಶೇಖರ್
ಪುಟ್ ಬುದ್ಧಿ. ಇಲ್ಲ ಸ್ವಾಮಿ, ರಾಜಶೇಖರ್ ಸ್ವಾಮಿ ಬಂದ್ಬಿಟ್ಟು ಎಲ್ಲಾ ಲೀಗಲ್ ಏರ್ಸ್ ಆಫ್ ದಿ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1.
ಓ D1 ಗೆ ಅವ್ರು
ಹೌದು
ಸತ್ತೋಗ್ಬಿಟ್ರು.
ಸ್ವಾಮಿ.
ಮಾಂತದೇವ್ರು ಸತ್ತೋಗ್ಬಿಟ್ರು.
ಹೌದು
A B
ಹೌದು.
C ಆಯ್ತು.
ಪುಟ್
ಬುದ್ಧಿ
ಬುದ್ಧಿ ಬಂದು ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 2 ಸ್ವಾಮಿ.
ಡಿಫೆಂಡ್ ನಂಬರ್ 2.
ಹೌದು ಸ್ವಾಮಿ.
ಈಗ ಡಿಫೆಂಡ್ ನಂಬರ್ 2 ಅಲೈವ್.
ಹೌದು ಸ್ವಾಮಿ.
ಹೌದಾ? ಹಾ,
ಗೌರಮ್ಮ ಪ್ಲೈಂಟಿಫ್.
ಆಯ್ತು. 3 ಜನ ಮಕ್ಕಳಿದ್ದಾರೆ, 1/3 ಶೇರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪ್ರಾಪರ್ಟಿ ಬಿಲಾಂಗ್ಸ್ ಟು
ತಂದೆಯಿಂದ ಬಂದಿರೋದು ಸ್ವಾಮಿ. ಮಹಾಂತ ಸ್ವಾಮಿ.
entitled for a share. What
ಯಾಕಂದ್ರೆ
is to be decided in second appeal ರೀ?
ಯಾಕಂದ್ರೆ ಒಂದು ಆಪರ್ಚುನಿಟಿ ಅಂತ ಕೊಟ್ರೆ, ಯಾಕಂದ್ರೆ ಮಾತುಕತೆ ಆಡ್ ಮುಗಿಸ್ಕೋಬಹುದು
ಇಲ್ಲ
ಅಂತ ಹೇಳಿ
ಇಲ್ಲ
ಸ್ವಾಮಿ.
ಸ್ವಾಮಿ,
ಒಂದು ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್.
ಅಲ್ಲೇ
It's
ಹೋಗಿ
my humble
MPP ನಲ್ಲಿ ರಾಜಿ
submission.
ಮಾಡ್ಕೊಳ್ಳಿ,
ನನಗೆ
ಏನ್
ನಿನ್ನೆನೇ
ತೊಂದ್ರೆ ಇಲ್ಲ.
ರಾತ್ರಿ ಫೋನ್ ಮಾಡಿದ್ದಾರೆ, ಯಾವುದೇ ಮಾತುಕತೆಗೆ ನಾವು ರೆಡಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ. ಇಟ್ಸ್ ಮೈ ಹಂಬಲೆಸ್ಟ್ ರಿಕ್ವೆಸ್ಟ್.
What is wrong in the order, counsel? You are not disputing that property belongs to the father. She is a daughter.
ಫಸ್ಟ್ ಇಂದ ಅವ್ರು ನೋಡ್ಕೋತಿದ್ದು
Your
ನಾವೇನೆ
lordship kindly see the
ನೋಡ್- first ಯಾರು
DW1
ನೋಡ್ಕೊತಾ ಇದ್ರು?
cross
ಅವ್ರನ್ನ
examination.
ನೋಡ್ಕೋತಿದ್ರು. ಅವರೇ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲೂ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ
Cross
ಸ್ವಾಮಿ.
examination ನೋಡಿ ಸ್ವಾಮಿ.
ನೋಡ್ಕೊಳ್ಳೇಬೇಕು ನೀವು. ಅಪ್ಪ ಇಲ್ದಂಗ್ ಅಂದಿರೇ ನೋಡ್ಕೋಬೇಕು, ಬೇರೆಯವ್ರು ನೋಡಕ್ಕಾಗುತ್ತಾ?
Your lordship kindly see the cross examination of the
ಇರ್ರೇ ಒಂದ್ ನಿಮಿಷ
DW1.
ಕೌನ್ಸಿಲ್, ಇರ್ರೇ ನೀವು.
ಆಯ್ತು ಸ್ವಾಮಿ.
When there is no ground to admit second appeal, why you are poking your nose?
Sorry, I am very
Admission between the appellant and also the court.
extremely sorry.
ಹಾ, ಹೇಳ್ರಿ, ಏನ್ ರಾಂಗ್ ಏನ್ ರೀ? ವಾಟ್ ಇಸ್ ದ ಎರರ್?
ಯಾಕಂದ್ರೆ ಇವ್ರಿಗೆ ಮದ್ವೆ ಆಗೋ ಟೈಮಲ್ಲೇ ಇವ್ರಿಗೆ ಹಣಕಾಸು ಕೊಟ್ಟಿದ್ದು, ಒಡವೆ ಕೊಟ್ಟಿದ್ದು ಅಂತ ಹೇಳಿ
ಆ ಕತೆ ಎಲ್ಲ ಹೋಯ್ತು.
ಸಿದ್ಲಿಂಗಮ್ಮ ಅಂತ ಹೇಳಿ ಅನ್ಮ್ಯಾರಿಡ್ ಇನ್ನೊಬ್ರು ಸಿಸ್ಟರ್ ಇದ್ರು. ಅವ್ರ
ಮದುವೆ ಆಗಕ್ ದುಡ್ಡು ಖರ್ಚು ಮಾಡಿಲ್ವಾ?
ಮಾಡಿದ್ರು.
ಮೋಸ್ಟ್ಲಿ ಹೆಣ್ಮಕ್ಳು ಒಂದ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಖರ್ಚು ಮಾಡಿರ್ತೀರಿ. ಕೊಡೋದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ ಏನೋ ಹೆಚ್ಚು ಕಡಿಮೆ ಮಾಡ್ಕೋಬೇಕಷ್ಟೇ.
ಆದ್ರಿಂದನೇ ಸಿದ್ಲಿಂಗಮ್ಮಂಗೆ ಅಂತ ಹೇಳಿ ಒಂದ್ ಶೆಡ್ಯೂಲ್ ಕೊಟ್ಟಿದ್ದೋ ಸ್ವಾಮಿ. ಬೇಕಾದ್ರೆ ಮಾತುಕತೆ ಕೊಟ್ಕೊಂಡ್ರೆ ಆ ಶೆಡ್ಯೂಲ್ ಐಟಮ್ ಪ್ರಾಪರ್ಟಿ ಕೊಡೋದಕ್ಕೆ ಏನು?
ಸಿದ್ಲಿಂಗಮ್ಮ ಯಾರು?
ಸಿದ್ಲಿಂಗಮ್ಮ ಒನ್ ಆಫ್ ದಿ ಸಿಸ್ಟರ್ ಸ್ವಾಮಿ. ಅವ್ರು ಅನ್ಮ್ಯಾರಿಡ್ ಈಗ ಸತ್ತಿದ್ದಾರೆ.
ಈಗಿಲ್ಲ ಅವರು.
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಇಲ್ಲ.
ಅವ್ರಿಗಿರೋಂತ
ಇದ್ದೇ ಇರೋದು ಈಗ.
ಪ್ರಾಪರ್ಟಿ
ಅವ್ರು ಯಾರ ಜೊತೆ ಇದ್ರು?
ಅವರು ಡಿಫೆಂಡೆಂಟ್ಸ್ ಜೊತೆನೇ ಇದ್ರು ಸ್ವಾಮಿ.
ಏನಾರು ವಿಲ್ಗಿಲ್ ಏನಾರು
ಇಲ್ಲ
ಮಾಡಿಲ್ಲ?
ಸ್ವಾಮಿ, ಏನು ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಟೆಸ್ಟಮೆಂಟರಿ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾಡ್ಕೋಬೇಕಿತ್ತು ನೀವು.
ಅವ್ರನ್ನ ನೋಡ್ಕೊಂಡಿದ್ದು ನಾವೇ, ಅದನ್ನ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
ಅವ್ರ
ಕ್ರಾಸ್
signature
ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲೂ ಅವ್ರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಪ್ಲೈಂಟಿಫ್.
ಈಗ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಎನ್ಲಾರ್ಜ್ ಆಗ್ಬಿಡ್ತದು. Unmarried and since deceased devolves upon the heirs of the father. In other words, it reveals back to the father's family in view of section 15(1) of 1D of the Hindu Succession Act. ಅದೇ ಡಿಸ್ಕಷನ್ ಅವ್ರು ಮಾಡಿರೋದು.
ಹೌದು ಸ್ವಾಮಿ.
ಹಾ,
ಅವರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ನಮ್ಮ ಅಕ್ಕ ಸಿದ್ಧಲಿಂಗಮ್ಮನನ್ನು ಪ್ರತಿವಾದಿಯರೊಂದಿಗೆ ವಾಸವಿದ್ದ
listed for admission and I heard the counsel appearing for the appellant and also the suit is filed before the trial court seeking the relief of partition, claiming that the plaintiff is also the sisters of defendant number 1 and 2 and also contend that suit scheduled property belongs to their father. And on account of death of their father, she is entitled for 1/3 share in the suit scheduled properties. The contention of the defendants that her share was given, but in order to prove the same, nothing was placed on record and hence the trial court, considering both oral and documentary evidence, comes to the conclusion that the plaintiff is entitled for 1/3 share out of the suit scheduled properties. And also taken note of the fact that one of another sister also passed away, that is Siddhalingamma,
8/10/2006
as a spinster and not left any document of testamentary document, and hence taken note of section 15D of Hindu Succession Act. The same vests with the other legal heirs of their father and hence rightly granted a 1/3 share. The appellants filed the appeal RA number 84 of 2021 and appellate court considering the grounds urged in the appeal memo also framed the point for consideration whether the first appellate court, whether the trial court committed an error in granting 1/3 share, and also whether there was already a partition in terms of the Panchayat Paluparika dated 19/10/1996. Since the appellants have contended the same in the appeal, and first appellate court also on appreciation of both oral and documentary evidence answered the point 1, 2, 3 as negative and confirmed the judgment of the trial court. Being agreed by the said judgment of the concurrent finding of trial court as well as the first appellate court, the present second appeal is filed, and counsel appearing for the appellant would vehemently contend that both the courts committed an error in ignoring the unregistered Palu Parikar dated 19/10/1996 as per exhibit D14. And if the document exhibit D14 is considered, the plaintiff oblique respondent would not get any share over the property, and hence this court has to frame substantive question of law. Having heard the appellant counsel and the counsel appearing for the respondent also would immediately contend that trial court considering the relationship between the parties, since there is no any dispute, and also the property belongs to the father, and he died intestate, and hence the plaintiff and defendants are entitled for 1/3 share, and accordingly the trial court granted the same, and first appellate court also confirmed the same, and hence it doesn't require any interference, and question of invoking section 100 doesn't arise. In view of the discussions, but having heard the appellant counsel and also the counsel appearing for the respondent, no dispute with regard to the relationship between the parties. It is also not a dispute that one of the unmarried sister also passed away during the pendency of the suit. And also she also not left any testamentary document, and apart from that, even the father also not left any testamentary document. When such being the case, when the property belongs to the father, the plaintiff also succeeded to the estate of her father, and having taken note of the said fact into consideration, though content that there was already a partition, the same has not been proved, and document exhibit D14 is also unregistered document, and the same is not also not admissible, and hence trial court has not accepted the same, and first appellate court also not accepted the same. Even the first appellate court also framed the issue in view of the contention of exhibit D14 as point number 1, since they relies upon the Panchayat Palu Parikar dated 19/10/1996, and the same is also not accepted in view of unregistered document, and the same also has not been proved, and hence when such being the case, I do not find any error committed by the trial court in granting the relief of partition as well as apportionment of share also 1/3. She is entitled for a share in respect of the property of her father, and hence I do not find any ground to admit and frame any substantive question of law invoking section 100 of CPC. In view of the discussions made up, I pass the following order. Second appeal is dismissed.
Immensely grateful, my lord.
112. Halli Shantappa.
I'm appearing for the appellant in this matter. That plaintiff appeal ಮಾಡಿದ್ದಾರೆ.
ಹೇಳ್ರಿ.
Against the divergent findings. That
Divergent ಏನಿಲ್ಲ, decree ಮಾಡಿದಾರೆ first appellate
ಹೌದು
court
ಹೌದು.
ದುಡ್ಡು
That so far as the order for refund of the earnest money.
refund ಮಾಡಿ ಅಂತ
That
ಹೇಳ್ತಾರೆ.
your lordship may kindly see come to para 23 of the appellate
ನೋಡೋಣ,
court.
ಅವರು ಬರ್ಲಿ ನೋಡೋಣ.
Please.
Decide, issue notice and call for records.
And that interim order may kind, that sought for stay ಮಾಡಿದ್ದಾರೆ.
Records ಬಂದಿದೆಯಾ? Notice
ಬಂದಿದೆ.
ಆಗಿಲ್ಲ.
Notice ಆಗಿಲ್ಲ.
Issue notice against the respondents. ಏನ್
for stay ಮಾಡಿದ ಅದು that lower appellate court stay ಕೇಳ್ತಾ ಇದ್ದಾನೆ. Refund of ಅದಕ್ಕೆ amount ಇದು ಮಾಡಿದ್ದಾರೆ. So lordship may kindly to stay that order.
Heard the appellant counsel on IA 1/24, and counsel appearing for the appellant would submit that the trial court granted the relief of specific performance, and first appellate court modified the same, directing to pay an amount of rupees 2 lakh with 6% interest, which was the earnest money paid by the appellant. And if the said judgment is not stayed, there is a chances of alienating the property by the respondents, and in view of taking note of the same reversal of the judgment of the trial court and not granting the relief of specific performance, it is appropriate to stay the judgment of the first appellate court till the next date of hearing.
Then 50.
I beg to appear for the appellant.
Hmm.
These two appeals arise out of a common judgment and decree
passed in two different suits. Plus, the first appeal arises out of a suit for special performance. This is plaintiff's appeal. The second appeal, the second one is by the defendant. Plus, the first one is filed by the appellant before the lordship as plaintiff for the relief of specific performance. Plus, the total sale consideration was 4 lakhs. The consideration of 3,75,000 was paid at the time of execution of the agreement to sell. What remained was 25,000. The legal notice was issued in 2013, asking the
ಅಗ್ರಿಮೆಂಟ್ ಯಾವ ಇಯರ್?
2006.
ಅಲ್ಲ ರೀ ಇದು ಹೆಂಗ್ರಿ ನೀವು ಎರಡನ್ನು ಪ್ಲೇಂಟಿಫ್ ಅಪೀಲ್ ನೀವೇ ಹಾಕಿ ಡಿಫೆಂಡೆಂಟ್ ನೀವೇ
ಇಲ್ಲ ಅದರಲ್ಲಿ ಇನ್ನೊಂದು ಕೇಸ್ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ. Pursuant to the agreement to sell.
ನಿಮ್ಮ ಹೆಸರೇ ತೋರ್ಸರ್ ಮತ್ತೆ?
ಹೌದು, pursuant to the agreement to sell, I was put in possession of the scheduled property.
ಕೇಳ್ತಾ ಇರೋದು ನೀವು ಪ್ಲೇಂಟಿಫ್ ಗೆ ಡಿಫೆಂಡೆಂಟ್ ಗೆ ಇಬ್ರಿಗೂ ಹೆಂಗ್ ಅಪೀಲ್
ಹೌದು,
ಹಾಕಕ್ಕೆ?
ಒಂದು ಸೂಟ್ ನಮ್ದು, ಒಂದು ಸೂಟ್ ಅವ್ರದ್ದು, ಡಿಫೆಂಡೆಂಟ್ಸ್. ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೂಟ್ ಒಂದು.
ಆ ರೀತಿ ಆ ಸೂಟ್ ಅಲ್ಲಿ ಎರಡು ಸೂಟ್
The
ಇದೆ.
second one is for declaration and recovery of possession.
ಎರಡು ಸೂಟ್ ಇದೆ.
ಹೌದು ಸರ್. Common
ಪ್ಲೇಂಟಿಫ್ಸ್ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಇನ್ ಅದರ್ ಸೂಟ್.
correct.
ಹೌದಾ?
ಹೌದು. Vice versa.
ವೈಸ್ ವರ್ಷ.
The first one, this appeal 816.
523 138.
ಹೌದು. 816 arises out specific performance.
ನಿಮ್ಮ ಸೂಟು
That's dismissed. That suit has been dismissed. Their suit for declaration and possession has been decreased. I have been directed to hand over possession within 3 months, holding that I'm a trespasser, not a party in
having any agreement ಅಂತ.
not pursuant to the agreement. You are not put in possession.
ಆಯ್ತು.
This finding is not correct because
ಅಲ್ಲ ಆಯ್ತು, ಆಮೇಲೆ ಅಪೀಲ್ ಅಲ್ಲಿ ಏನಾಯ್ತು ನಿಮ್ಗೆ?
appeal ಅಲ್ಲಿ trial court upholds the
ಎರಡು
concurrent finding. Despite having paid 3,75,000, here is a defendant who
ಅದಕ್ಕೇನ 3,75,000 ಕೊಡಿ ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ಆರ್ಡರ್
with interest ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಹೌದು ಸರ್. Here is a defendant who denies the agreement to sell, and despite that discretion has been exercised in his favor. That is not a sound discretion. Is my
notice call for records.
Let's say I prayed for interim order stay.
Interim order ಏನೋ not
interim order of stay of execution of the judgment and decree in the second case, and stay of this one. That's
ಅಲ್ಲ ಈಗ ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಕೇಳಿದಾರ?
ಇದರಲ್ಲೂ ಸ್ಟೇ, ಎರಡರಲ್ಲೂ ಸ್ಟೇ.
ಬರೀ ಜಡ್ಜ್ಮೆಂಟ್ ಸ್ಟೇ ಕೇಳಿದಿರಾ?
ಹೌದು.
Heard on A number 2 of 24 in RSA number 816 of 24 and also A number 2 of 24 in RSA number 807 of 2024, and in both the IAS prayed the court to stay the
operation and execution of the judgment
and judgment of
judgment
in respective
suits in OS number 523 of 2010
suits,
OS number 523 of
also
2010.
the respective appeals,
ಇಲ್ಲ, only respective suits.
suits ಮಾತ್ರ.
House.
Respective suits.
OS number 523 of 2010 clubbed with OS number 138 of 2013.
Since and council also brought to notice of this court that in the appeal an order is passed to refund of amount of rupees 3 lakh.
No, in the suit itself.
Suit itself.
House.
suit ಅಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ ದುಡ್ಡು.
ಹೌದು.
ದುಡ್ಡು ಕೊಡಿ ಅಂತ.
ಹೌದು.
ಯಾವ್ದ್ರಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಮಾಡುವಾಗ?
dismiss
ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಡಿಸ್ಮಿಸ್ ಮಾಡುವಾಗ.
ಹೌದು, refund ಮಾಡಿ.
ಹಾಗಾದ್ರೆ ಬೇಡ. ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಕ್ರಿ ಆಫ್ ದಿ original suits in both the suits are stayed till next date of hearing. In the meanwhile, registry is directed to get the records of both the courts and issue notice against the respondents and list the matter immediately as soon as records are received.
Highly grateful to you.
115 SV Prakash.
SV Prakash 16 share reversed 1 to 3 4 and 5 dismissed.
Plaintiff's appeal.
Plaintiff's appeal,
My lord.
Plaintiff's appeal.
Plaintiff's appeal.
Issue notice and call for records.
Only with regard to schedule item number
ಅದೇ
4 and 5.
4 and 5 ಮಾತ್ರ
Self-acquired ಅಂತ.
ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಾರೆ, ಅದಕ್ಕೆ ನೀವು ಕೇಳಿದಿರಿ.
ಹೌದು.
ಆಯ್ತು.
116.
116.
Lordship's permission, Lords, prepare for the appellant.
Dismiss partly allowed, B scheduled property, hand over the possession.
Divergent findings. This is the defendant's appeal. Suit for declaration and possession on the basis of the will allegedly executed by the grandfather of the plaintiff. That came to be dismissed on the sole reason that as per section 68.
Thoroughly. Heard the appellant counsel and there is a divergent finding and Suit was dismissed
Please.
and the same is reversed in the first appellate court, directing to hand over the B schedule property, which is the part of A schedule property. Correct?
Correct.
A schedule property. And in view of divergent finding, issue notice against the respondent and call for records.
I have sought for stay.
Stay in ಕೇಳಿದಿರಿ?
Stay, para 3 affidavit to ಕೇಳಿ.
Heard
Direction.
on A number 1 of 24 and in view of the direction given by the first appellate court to hand over the B schedule property, which is part of A schedule property, and the judgment and decree of the first appellate court is stayed.
I'm
till
grateful.
till next date of hearing.
I'm grateful.
ಯಾರು ಬೇಡ ಅಂತ ಹೇಳಿದ್ವಲ್ಲ, ಆಯ್ತು ಬಿಡಿ, 4 ಹೊತ್ತಿಗೆ ಮುಗಿದೋಯ್ತು. ನಾನು ಮೋಸ್ಟ್ಲಿ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಇಟ್ ವಿಲ್ ಟೇಕ್ಸ್ ಮೋರ್ ಟೈಮ್ ಅಂತ ಅಂದ್ಕೊಂಡಿದ್ದೆ. ಆಯ್ತು, ಇವೆಲ್ಲ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ. ಯಾವ್ದಾರು ಡೇಟ್ ಕೊಟ್ಟಿದಾರ? ಯಾವ್ದಾರು ಎಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾಡೋದು ಟೈಮ್ ಕೊಟ್ಟಿದಾರ? ಯಾರು ಹೇಳಿಲ್ವಾ? ಕಳ್ದ್ಬಿಡಿ. 118.
118.
For the appellant in this matter, my lords.
List this matter after 2 weeks.
My lords, entry matter may be extended.
Entry matter ಇದೆಯಾ?
Yes, my
Entry
lords.
matter granted earlier is extended till next date of hearing. 118.
119 adjourn 120. A Nagarajappa.
19 urgent.
ಹಾ.
120. ನಾಗರಾಜಪ್ಪ, PK ಮಂಜುನಾಥ್. ಇಲ್ವಾ? List this matter after 2 weeks. ಹಂಗೆ ಹಾಕ್ಬಿಡಿ. ಏನು absent ಗಿಬ್ಸೆಂಟ್ ಏನು ಬರೆಯೋದು ಬೇಡ. ನಾವೇನು ತೊಗೊಳಲ್ಲ ಅಂದಿದ್ವಲ್ಲ.
121.
121 ಸೇಮ್.
Lord Mariappa. 122.
ವರಪ್ರಸಾದ್ ಸರ್ವಣ ಅದು ಅಷ್ಟೇ.
123 adjourn 124.
List after 3 weeks ಅಂದ್ಬಿಡಿ. 2 weeks. ಓಲ್ಡ್ ಇದೆ. 125 also.
126.
Same. 127 also same. Up to 2 weeks. 23 after 3 weeks ಮಾಡೋಣ. ಓಲ್ಡ್ ಏನಲ್ಲ, 3 weeks ಮಾಡೋಣ ಅಂದೆ. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 3 weeks. ಇವನ್ ಮೇಡಮ್ ಅದನ್ನು 3 weeks ಮಾಡಿ 126 ಎಲ್ಲ ಇದಿದೆ. ಬಾಕಿ ಹಳೇದೆಲ್ಲ ಬೇಡ. Why those people are waiting? ಯಾವ್ದು ಕೇಸ್ ಇದೆಯಾ?
It's a wasted.